Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I'm your host, Nick Recollection of Recollection Law, a small law firm in central Minnesota. What's happening? I'll tell you what's happening. My mic boom arm is not holding. It's not doing its job. There we go. Get breaded. Oh my goodness. Here we go. Perfect. How's it going today, sir?
It's going awesome, Nick. How are you?
I am, I'm bright-eyed, bushy-tailed. I'm very chipper. It's early in the morning. This trial is, look at this. Look at this. I'm going to show you how great today is.
Hey, Link, do you have a link to the actual trial?
I do. That's what makes today great. Is that it's actually, look, it's actually happening and it's on. Let me get you the link real quick. I'm in such a good mood because things are working. I mean, I know everything's going to go to hell in a little bit, but for now, things are working. Let me send you I'll send you this link here. There you go. I just sent it to you.
Okay.
I don't know if there's a different one. Oh, I might have to put my, have you seen my transformative overlay? Because, I wouldn't want Law and Crime's logo to confuse people. So what the hell? What the hell? Okay, here we go. Yeah, here's my transformative overlay for this. I probably won't keep that the whole time. Might have to just put it up every now and then. So what's up, chat? How you doing? We'll see what's going on. Yes, pin the links. Yes, it's not like I'm doing anything else right now. It's not like I'm getting this whole stupid stream ready or anything. Okay. One thing I do want to do. I want to share this video to the world. I think this live stream is a live stream the world needs to see. Okay, Curtis Reeves opening statements starting any minute now. Get in here. So how was your weekend, man?
It was okay. Spent 2.5 hours yesterday doing a live stream on the relevant law and legal arguments here. Replayed the opening statements from the self-defense immunity hearing back in 2017, in which the audio was horrifically bad.
Oh,
the video wasn't great either. But that was my Sunday morning.
Well, there you go. Yes, I wanted to pop in on that, but I think I mentioned to you that I was at church while it was going on, so that didn't really work for me.
Well, I expect the opening statements we're going to hear in a few minutes are going to be duplicative of what they argued at the self-defense immunity hearing. So I don't think we missed much, really, except we did cover the statutes for people who are interested in that level of granularity.
So what's the verdict? What do you think?
Depends on who you believe.
I know you don't predict verdicts, but
yeah, depends on who you believe. If you believe Curtis Reeves, then I think there's a colorable argument of that he had a reasonable perception of a imminent threat of grave bodily injury from an outraged, lunging, striking Chad Olson. And if you believe the state, well, then Curtis Reeves simply shot someone unnecessarily because he was offended that popcorn had been thrown at him.
Right. So for those in the chat who don't know, I did see someone asking for kind of a summary about this. This is an incident that happened 8 years ago. The gentleman in the suit on your screen is Curtis Reeves. He's 856 years old. He is a retired Tampa police officer, chief. Was he
Captain.
chief? Captain. Okay, it was captain. He's actually the founder of the Tampa SWAT team, is what I believe. I've also heard and read as this trial has gone on. And he was at a movie theater with his wife. And prior to the movie starting, another individual, now deceased, got out his cell phone to have a text message with the babysitter. And
that turns out to be a lie, by the way.
Seated, thank you.
Oh,
He was actually on a gambling website.
oh,
Morning, everyone.
wow. Now he
Alright.
deserves to die for sure.
We have some issues we need to talk about.
We do, Your Honor. If the court recalls last Friday, I had promised the court that I would give the court a case on the issue.
Oh, you know what?
I have given.
They have the same video issues here that Rittenhouse did. So both parties want to show enhanced videos on big screens.
Sure.
And the defense in particular is objecting to the state's version because it does what Binger was doing, adding pixels.
Yeah.
The judge can't understand what a pixel is because she's
that's-
about as dumb as a loaf of bread.
Stated you
Beautiful.
had an opportunity to
I'm going to actually open this in a different window because I don't have my volume booster on. I can already tell.
I need a chance to read it.
Give me just a second,
It's
guys.
directly on point with the car issue, Your Honor.
Very good.
All right, I'll take a look at this and
Your Honor, the state, I apologize for interrupting, but the state does have an argument regarding that, so I'm suggesting the court at some point before you make a ruling, I could suggest
okay.
that you allow Mr.
The judge
Escobar-
can't understand why blowing up the image on the TV, the giant TV screen, is any different than using a magnifying glass.
Oh,
I'm
boy.
not sure if it's going to impact opening statement.
I think it will. It's an easy case to read, Your Honor. I think it's only 2 pages. But I will tell you, and I'll read you the holding of the reasoning of the court.
She does not look like she wants to read anything ever.
On Friday, they had 2 hours in court, and she couldn't wait to get out of there and left a lot of open issues on the
This
table.
was the same type of instruction, a self-defense instruction, did not refer to mere words or conduct without force. In other words, provocation has to be force. Provocation cannot be words. And so I think
One of the arguments the state is making is attacking that element of innocence of self-defense by arguing that Curtis Reeves provoked the conflict
there is no
verbally.
provocation, period.
Um,
Now he wants
the
to go
defense
on
is trying to argue that provocation as a legal term of art cannot
that somehow
be met if only words are used. It takes some physical conduct.
My client and Mr. Olson was somehow inappropriate. It has no relevance in this case because when you look at the jury instruction, provocation now is out the window. And so it is totally not relevant. It's a 403, huge 403 issue. And he should not be able to comment at all on whether it was appropriate or inappropriate for that verbal exchange to take place because this case is directly on point.
Your Honor, the case is Gibbs versus Florida, 789 Southern 2nd, 443. It's the fourth
So
district
did the
case
prosecutor's
decided in
chin
2001.
recede
Your Honor, if
at
you would
the
go to the
previous
second
hearing, or was
page,
it already gone?
It was already gone.
And for the case law side, it'll be.
He was already melty.
In that particular case, the
I think
defense
his chin
counsel
is hanging
wanted
out in the
jury
same
to
place that Mitch
understand
McConnell's chin
that
is.
any provocation by appellant had to be by.
You wouldn't be
force
shocked to learn they were
or
related.
threat of force.
You really wouldn't. They
He was
sound the
concerned
exact
that the
same.
jury might be confused and think that merely provoking someone by complaining they didn't say good morning justified the victim's attack on the appellant and did not justify appellant in defending herself against attack. If you go down where you see
This is a big part of the state's preferred argument. They want to be able to argue this provocation issue because, of course, if they can do that and the jury buys it, self-defense goes clear out the window.
Yeah.
The instruction stated that the appellant could not defend herself with non-deadly force.
But the prosecution kind of dishonestly characterizes this verbal exchange as contact. They keep referring to the unwanted contact made by Curtis Reeves, but it's a verbal exchange. There's no physical contact. And I guess you can say you were contacting someone with communication, but that's clearly not the
word
implication they're trying to create.
as used in the instruction did not refer to mere words or conduct without force. Stated another way, the instruction gave the court, the instruction given by the court eliminated the use of non-deadly force in self-defense if there was any provocation by the defendant, no matter how slight or subjective the provocation. By that standard, mere insult could be deemed sufficient to prohibit defendant oneself from another's attack. If you go down, the court reasoned that because the instruction did not limit provocation to some force or threat of force, the instruction could have misled the jury to believe that the appellant's pointedly asking the victim why she failed to acknowledge her greeting and/or
Yeah, they've only had 8 years
force
and a month to prepare for this trial, and they're still arguing this very fundamental legal question on the morning of opening statement.
From attack by the victim. The court went on to say, yes, we know there's a standard instruction. The clarification that the defense sought here was particularly applicable to the facts of the case and should have been given. I went through that so the court could understand the analysis that the appellate court did. They acknowledged that the standard jury instruction deals with the issue of provocation. They also indicated that the standard jury instructions can be modified and made clear under specific circumstances, and that if there is in fact coupled with the instruction about provocation, that it has to be force on force and mere words are not sufficient, then it's not misleading. So applying the facts of this particular case, in this particular case, after Mr. Reeves leaves the theater and complains to the manager and is coming back, the testimony will be that Mr. Olson had discontinued using his phone. It was down. Mr. and Mrs. Olson were sitting there and watching the movie. The testimony from the state witnesses will be that as
The state witness is Chad Olson's wife.
There was no looking, there was no commenting. It was over. It was Mr. Reeves when he came back and he initiated contact, knowing that everything was done.
There's that contact.
Everything was
He
done.
didn't touch
and
him.
Comments to the fact, and I'm paraphrasing, words to the fact, okay? I see you put your phone away or something like that. But again, he has had the contact.
That's
That
not contact.
situation falls into the area of
That's akin to saying I called someone on the phone. It was contact.
rekindling, if you will, very.
I mean, colloquially, I guess it's a form of contact, but not in any use of force sense,
Whatever. That was over.
which
and done
explicitly
with.
differentiates
And so
between
there
mere
wasn't
words
back
and
rekindling.
physical force.
But those words in that situation.
It's this type of stuff that makes
would,
me
in fact,
hate prosecutorial
if the
strategy.
court modify the instruction, informing the court that mere words themselves are not sufficient provocation, then it's not misleading. The state has the right for the jury to know Mr. Reeves' state of mind as he was coming back. Why did he lean forward? We're going to see it. Witnesses are going to testify that it occurred. There's going to be an exchange. If that is disallowed, then there's no predicate leading up to the fact of the tossing of the popcorn and shooting. There's none. It's just like, okay, he just stood up and did it. So we have to get into the fact there was a predicate, that was exchanged. And so I think it is relevant. It places the actions of both participants in proper context so that the jury can make an informed decision. So I'm suggesting to the court that we modify the jury instruction.
She hates the very mention of modifying the jury instruction. This is clearly a judge who's been reversed before because she did that.
After Mr. Reeves came in and sat down, it wasn't like sat down, seconds later, okay, Mr. Olson just stands up and does what he does. See, that's just a vacuum. There's no contact.
We also learned last week that Chad Olson and his wife had been at a bar before they went to the theater.
Event that triggered the actions of these two parties. Are we going to argue that this is sufficient provocation and reverse the standard that he can't do it? No, we're not going to do that.
Really?
But we are suggesting to the court that these facts are in fact relevant. And with
Where's
the
Borkowski?
modification, as indicated by the court,
Enough.
you can do that. This
I'm
is
tired of this,
fact
counsel. You
relevant.
made this argument
Otherwise, we're
for
just
hours
taking
and
a lot of
hours
time.
on end. I've heard it 150 times now, I think. And if you actually make this argument again, counsel, both of you, I'm going to sanction
So
both of
even
you.
if the
to
court
spankings.
indicates or decides that, okay, we're just not going to do the jury instruction and I'm not going to modify it, the facts that I just recited to the court are relevant, just like I indicated that they are relevant. So we understand the limitation. We are not going to make the argument like that, the jury instruction is reversed. We are not going to do that.
That
But we
dude
do have
behind
a
him
right
looks so
to lay all
familiar.
the facts in front of
The
us.
guy over his shoulder there. I don't know
Let me
why.
first point out that case was
With,
not
with the
marked
big hair or the other guy?
Yeah, the big hair guy.
Cited under that particular section of provocation. So it's a case obviously that, even the Supreme Court, has acknowledged, needs to be considered. Now, let's listen to what the prosecutor's saying. Well, we're not going to use the word provocation, but we're going to use rekindled, hostile, unfriendly. That is provocation. That's exactly what he wants to do. He wants to term provocation by some
Those
other
are words,
world. And
Mr. Escobar. Those are just words. So words are not provocation, correct?
they are not provocation, but if in fact, we're going to ask the court to make this as a matter of law, but there was no provocation because what he's telling you is incorrect. There are his witnesses that are going to be testifying today that say that when Mr. Reeves first came back, what happened was Mr. Olson looked over at Mr. Reeves and he says, "You turned me in, huh?" He was the first one to initiate that conversation, not Mr. Reeves. And
Ooh,
so
that lady's
these are
not
the
happy.
witnesses that are going to
It
testify
must be
today.
Olson's mom.
I'm prepared for them. They're going to say that. And so we
She's
can't
very
get into
disappointed.
this issue of, hey, listen, was it appropriate for Mr. Reeves to engage in that conversation? Because that's exactly what the court here is saying. It's irrelevant. If they had 20 conversations in that process, it's totally irrelevant because it does not mean that he acted with any ill will or any hatred or anything of that sort. It has absolutely no relevancy in this particular case. And even more importantly, it's a 403 and highly dangerous.
All right, so you.
May I have just a moment with counsel?
Yes,
He
just let me clarify. So let's say, based on this case, I don't give the instruction. Are you indicating that Mr. Martin can't have his witnesses testify as to what happened?
Oh, no, they can testify as to what happened, but he can't get up here and tell this jury that there is some reason for them to decide one way or the other because of that conversation, because that's what Gibbs is saying. We can't do that because there's a reason for the provocation instruction in this particular justifiable use of deadly force. But you can't go beyond that provocation and now start thinking that, well, any word that was said between these two gentlemen somehow.
Such a lack of clarity of argument. It just drives me
In
crazy.
this case, it does not. And this case is directly on point. It's cited in the jury instruction.
Yeah.
I would ask the court to follow because otherwise it is, you saw what they did in Gibbs. It was reversed. And so we can't have that here. We've spent way too much time.
Thank you for that reminder. I'm well aware of how much time we've spent.
Are you,
So,
Judge? 8 years.
Again.
8 years.
You keep saying that these activities are completely irrelevant. How do you answer Mr. Martin's argument that would leave kind of a vacuum?
Judge, the witnesses are going to testify about what happened. What I am concerned about is not that the witnesses are going to testify about what happened.
You have to be clear with this judge. This judge is not
Yeah.
right. You have to lead her down the road. You do not want the prosecution to be able to argue the legal doctrine of provocation to the jury. That's
engaged Mr.
the key.
Olson, which is exactly what this court is saying you can't do because that's the issue of provocation. You can call it provocation. You can call it rekindle. You can call hostility. You can call it whatever you want to call it. It's still provocation. And we can't have that in this particular case. Now, are the witnesses going to be able to say that, hey, listen, when Mr. Reeves came back in, Mr. Olson, made that statement, or what if they even don't say that? Let's assume that, they don't have that. Mr. Reeves came back and said, oh, I see that you put your phone away. That's perfectly fine. I'm not going to object to that because those are facts, as to what happened there. The danger here is how they use that to this jury, because they know that it has absolutely no issue with reference to this case.
Yeah. Judge,
facts
I don't
suggested
care
are
what the
stating them are
witnesses
almost exactly
testified
true.
to.
The defendant was the one, based on his own statement. You're going to hear from witnesses, but the defendant's own statement was when he came back from the manager.
What, they got a different prosecutor arguing now?
Contact with Chad Olson. We are not going to be arguing.
That's not a good look.
Different than the jury instruction. We're not going to try to put any facts out there or apply.
This is a lie.
To
This
the
guy's
law
lying right
as
to
the
her
law
face.
does not exist. We're not doing that. But the facts are certainly relevant, and I think that the court's obviously, indicating that it is. But we are not going to be arguing this case any way different than what the law allows.
Well, what does that mean?
I guarantee that's a lie.
When Mr. Reeves came back from the manager, as he's walking down the row, or when he sits down, or immediately thereafter, he initiates a conversation with Chad Olson. At that time, he says to him words to the effect of, "I see you put your phone away. I went to the manager for no reason." It's at that point in time that Chad Olson turns around in his seat. I mean, that's basically exactly what I'm going to say.
Okay.
There's no way that's provocation under the
That's
law.
all he says, and I'm not concerned about it, but I am concerned if he says anything about fault in what Kendall was.
And provocation.
All right.
And there shouldn't be an instruction if that's what he's going to say.
Be more closing than opening. Yeah.
Right.
And we are allowed to draw whatever inferences the facts.
See,
All right, so-
there he goes. He just mitigated it.
So we're clear on openings.
We're allowed to
We
draw
can get
whatever
started.
inferences.
I'll look a little closer at this case, and I'll make my final decision as to the jury instruction when we're at a break or something, when we're discussing other matters.
It's like she doesn't want to be a
Anything else
judge.
we need to address this
It's another one of
morning?
these.
Yes, Your Honor, unfortunately. I was told this morning that the exhibits that Mr. Martin had told me were going to be played in opening statements. They're not going to play those exhibits now. They're going to be playing some ABI exhibits. And if the court recalls the conversation that we had Friday concerning these videos, some of them have blue screens or black screens that show up when the video is not recording. And we talked about some videos that actually have the last frame that is recorded, and it stays in that last frame while it's not recorded. And Mr. Martin, and I can get the transcript, Mr. Martin himself agreed that that particular type of video was certainly a video that would suggest to the court something that the evidence isn't, meaning that that frame stays. And the jury gets the impression that that's the recording, and when it's not, that is misleading. He said that Friday. He agreed with that Friday. Today he wants to introduce that, and so we would object. We think it's misleading. There is absolutely no reason that we need to introduce anything that's misleading to the jury.
How do you walk back the "I agree, this is misleading"
In this
statement?
particular case, there's the first exhibit is the native video that was downloaded by the IT at Cobb, given to Fred Myers and given to the sheriff's office. Later on, we got the hard drive. Our experts determined that what was on this USB hard drive that you stick in the computer and the hard drive were in fact the same. Now, what was downloaded on the 15th is known as a recorded video. It is the native video right out of the DVR. There is no blue screen. It runs continually, and it's the native video. From the hard drive, we exported.
But the video is not a fair and accurate representation of what was happening because it's like motion activated and it freezes the last frame when there's no motion. So it makes it look like everyone's sitting still.
Where the DVR software itself actually inserted the blue screens to show where there was no recording. I haven't even received all of the new exhibit from the defense today. I received some.
What's that got to do with your video?
After reviewing what their expert has redone, which I haven't been able to talk to him about. No, I got them. I watched them. Once I watched them and discussed it with my expert, It's important for the jury to know what the native raw data is.
Why?
And that's the reason today, at the beginning, I will play the native raw data.
That's when you get up and say,
I
Judge,
already have it preloaded on the
he's
whiteboard.
arguing to show video
Right
that is
after
not a
that,
fair and accurate
I will play
representation
the
of the events that happened
native
that
raw
day.
data and push the
Who
blue
cares if
screen
it's
for
native or
on
not?
all three
This
cameras.
is
So
not
they'll
what the
see the
defendant
raw
and the
native raw
deceased
data
experienced
real time,
on that
that
day.
it's just
It's something
straight,
else.
and then
Software
immediately
edited,
after
person
will be the blue
edited,
screen.
it doesn't matter.
And we will use the blue screens with our witnesses. The first exhibit will be used either with my witness or with in my cross of their witness, but we are going to be playing it, and I think because of what Mr. Escobar handed me over the weekend, I have no choice but to let the jury see what is an absolute, no enhancement, no nothing, no one's manipulated it at all, because the defense exhibits that I have been manipulated to the point that they have to see the raw data. And that's why it's being put on. I'm not going to argue that this timely. It's just, we're going to play one after another. And it's almost like any type of enhancer. You put in the original first, then you put in the blue screens. That's what we're doing, back to back.
Judge, if I may, because I want to clear this record.
Man, it's so
I'm
weird
gonna
to watch
show you-
these prosecutors
I'm
tag
gonna
team
show you
like
what
this.
was given to me.
Or is that the defense now?
Which
Sorry.
is the
Yeah.
raw data. They went through great lengths with them to put the raw data and use it with the GeoVision.
Oh, God.
Oh my God, it's like, hey, why don't you just go get a bag of potato chips?
To transcend thumb drives. They went through a great deal of work with Emil in order to get the raw data to play on the GeoVision software, which was the software that was in the DVR at the theater. This is raw data. For him to say now that he has to play this other video because it's raw data is not correct and it's not true. This is raw data. This is GeoVision. I think that the reason, frankly, now that they're switching horses and they don't want to play this one is because ours is I think, a much clearer portrayal of the actual video. And let me tell you what we did. Ours is very simple. If we had a screen of the video this big, we used nearest neighbor and we made it this big. That's it. Ours don't even cover the
These
entire
guys,
screen
the defense
because
obviously
there's a
learned from
graphic
Rittenhouse. They're using the
that
same
you have to
terminology,
gotta be
raising the same
square.
concerns.
If you
Yeah,
go
this
beyond
judge
square,
doesn't
you're
know what
using
nearest neighbor
interpolation,
means.
and we don't want to do that. And so ours, the screen doesn't do anything to our videos. Our videos are what they are, and our experts are going to testify about that. But think about it. We're now introducing a video, which up until this morning, he said he was going to use this. Now he's going to use a video that has the last frame continuing to run as if someone that's looking at it is going to think, oh, that's what's happening during that period of time. For no reason whatsoever. When he's got the raw video, these are the raw videos with the GeoVision, which they made such a big deal about that they had to get a GeoVision software to make them operate. To be honest with you, you don't need a GeoVision software to operate these things. We looked at it. We didn't want to do what he did, but I think at this point in time, Your Honor, we're creating in the eyes of the jury, we're creating something that they're seeing that clearly is misleading. And Judge, I'll be more than glad to get the transcript from Friday where he admitted that it was misleading. And here we are. Now he wants to introduce it.
Your Honor, it's the raw data, and then what he showed the court very dramatically.
The misleading
What
thing
I
is
did,
saying
yeah.
raw
Yeah,
data
I
as if
don't
that
play it up.
matters.
So it's not misleading. They're
If
gonna see
raw
a
data
fact,
shows
the
something that
fact,
didn't
the
happen,
fact.
it's
It's not
irrelevant.
to be misleading. It's just
And
like
it's prejudicial.
we would do with our experts. You put
It
on
has no
the
probative
original
value.
law, then you do in the enhancements. It's important that they see what the native video is.
Why?
All right,
So it's
so.
not misleading.
Not if it's not an accurate
Fine, we
representation
were
of what
talking
happened.
about raw data. Now we're just talking native. What's the difference here?
I'm sorry, it's just a term. It's the same.
All right,
It's
so the one that you intend to show is the same one that Mr. Escobar is showing?
What he's showing, no, I'm
No,
not.
I mean, look, this
I
is
plan to, that'll be the second video. The first video, which has already been stipulated to previously, back 5 years ago, that it is, whatever, I'm not going to repeat the stipulation. All right. It's already been stipulated. It's coming in. I mean, there's no argument it's not. He's arguing, well, it's a 403, and I said it's this. I go, yeah, I'm not going to use it with the witnesses. We'll use the other ones, but they need to know what the raw looks like. So I'm going to play that and then 3 more. Right at the beginning before any witness. It's just, the unrecorded is not there.
But for time frame, it shows on there that there's a gap. So for example, it would go up to 1 minute and then it'll start at 1:03. So if you look at the time, you know there's a 3 minute
Oh, because that's what the jury's doing, looking at the time of the video. That's what everybody does.
3 minutes went by. No one in here is going to be arguing anything at all to mislead the jury that it's one continuous set of events. So that's the most important thing.
Judge, take a look at that video and you tell me whether you can tell that there's 3 minutes that go between one screen and another. You won't be able to. Neither will I. Neither will that jury.
If you want us to, we will argue it. We're not going to mislead the jury.
Now you're
Then why-
testifying
why
to what the
would we
video
show
shows.
that one? Where did that come from?
It is direct response to the manipulated videos that I was provided by the defense that they're going to put on. They have to know what the video looks like, whether it's a fair and accurate representation of what the DVR.
No, they do not,
as opposed to
actually.
The manipulated.
They need to know if it's a fair and
DVDs
accurate
that the
representation
defense
of what
is going to put on in this
happened.
case.
Right.
It's paramount.
Exactly.
That they see this
If this
particular
jackass
video.
defense
They
attorney
have
doesn't
to.
stand up and say that,
They're
I'm going to
going
be pissed
determine
off.
Whether or not one set of videos or another is in fact.
It's like the state had a video of a traffic accident and the
Native
camera
law
reversed the
shows
blue and green
extreme
lights.
difference.
And they want to argue, well, that's not what happened in real life, but it's what the video recorded. So therefore, we get to show that to the jury.
We've talked about that.
Yeah.
I insisted that they get to see the original, raw, native, naked, whatever you want to call it, so they can make the decision by themselves. They can be the fact finders that they need to be, and they can give each expert's witness testimony the weight that they think it deserves based on the differences in the videos. And I've said all along since Friday, I haven't seen these videos in many years, and I don't know if we've got new versions.
Why
but,
haven't you rewatched them?
all this argument.
As if
that
this
we've been
trial
doing about
was
these
coming
videos, I'm wondering, is there any difference that the jury's going to see? But
Yes, Judge, and I will tell you,
waits to be seen.
I will tell you what we signed. We had the signed stipulation on the.
Uh-oh.
Exhibits 2 and 3. Is it here? Let me show you what we agreed to this weekend. We spent an enormous amount of time agreeing to on those transcend thumb drives. Can I approach?
Yes?
It hasn't been signed right now, but we've signed.
All right.
Mr. Reeves has signed it.
I know.
And so we spent, now, Judge, if you want to, let me have the transcends. You can put it on. I want to explain this to you because it's so important. They went through great lengths with Emma to get the raw video with the GeoVision software. That GeoVision software actually puts blue screens when it's not recording. So let's think about that. The GeoVision software that was in the DVRs puts the blue screens when it's not recorded. But he wants to introduce raw data that doesn't do that. Does that make any sense? We went through great lengths, and I agreed. I said, I looked at him, I said, yeah, we'll sign off on it. You can, this morning, he says, we're canceling that. Now we're putting in some AVI that doesn't have those blue screens in between. That is misleading, especially since he agreed on Friday that it was misleading. Here we are arguing about something that, Your Honor, he agreed to on Friday that it was misleading. We can't mislead this jury. And by the way, he says that.
Get the
ours is
transcript
manipulated.
at this point.
Can
Just
you
get the
please tell us
transcript
what
from Friday.
We did manipulate.
Put it on
I
the
can tell
table
you,
and say,
ours
here's
is-
him saying it's
okay. I
misleading.
know.
I mean, the judge was present.
And-
It was only 2 days ago.
Yeah, are you sure
We're not
she
gonna
was
go into that.
actually present? Like,
And theirs is, remind me.
It's by cubic.
By
feet,
cubic,
but the
thank you.
bottom line is none of that. And yes, I'm still playing what I told him I was going to play. We're just playing the first one, which is the stipulation that we signed many years ago. We all agreed what it was, and I played it right from the beginning of last year.
Did you all stipulate to this years ago?
As far as the one AWS. yeah.
Whatever one, the
Yeah,
one, the
it was
controversial
stipulated
one
years-
today.
It was stipulated
Your Honor,
years ago.
What we stipulated to was that those were in fact authentic videos. Not that playing it before this jury was going to be appropriate, because I can tell you that we weren't doing that. All of ours have black screens. In between every
Very
area, it
racist.
has black screens, and it actually has a counter on the black screen that you can really read, and you can see, okay, the next screen is coming up in a minute, or the next screen that's being recorded is coming up in 30 seconds. So that the person that's looking at it can say, okay, it's not recording right now, but in 30 seconds, we're gonna get some more recording. And bingo, the next recording comes up, and then the black screen comes up again. Okay, next recording is going to be in a minute and 30 seconds, and a minute and 30 seconds, bingo, it comes
How
up.
have they
It's
not
a very
resolved
easy
this at this
process
point in time?
for
Like, this
jurors
is amazing.
To understand, and we're not confusing them. And so, yeah, I would object, Your Honor. What I would ask the court, if for some reason the court rules against us, that particular video that is being played in opening be entered into court's evidence so that we can have it preserved for any future need.
Tell me again, why do you need this different one?
The very first one that we got 2 days afterwards, because that is the raw
That's not the reason.
that
That's just what it is.
Neither
What's the
expert
reason, the legal
has
reason that you
Yeah.
need that for your
jury
argument?
needs to see that.
The
uh,
other video
so
is
that
the
they
video
can,
that
like
neither
you said,
expert has touched
determine
also, right?
which
From the
one they're
software.
going to accept. It is
See,
extremely.
this is what makes
different
me
from the
annoyed about this
expert.
case, because I want to be like, it's really
and
ridiculous to
so
shoot
they're
a man
gonna
over
have to make a
popcorn, and yet the
decision. Like I
prosecutors
said,
got me on the
they-
side of the
it-
defense.
We are going to play the other one right behind it. They're not going to be misled. They're going to know that there's gaps. So
All right.
I want.
Then why are you gonna?
All right.
Why play both of
I'm
them?
gonna allow it. If it's the raw, if it is what it is, then that's what they're gonna get to see. Obviously, the next one's gonna show the time gaps with what yours is blue, and
I mean, it suggests to me the state
And-
does, in fact, not have confidence in their own legal argument. They deceptively use this word contact.
Yeah.
They have to show a video that's not representative of reality.
I mean,
We're not
If
using it in
if you've agreed to have it in, then it's going to be in as part of the record. I just want to make sure that that thumb drive stays here with the clerk, because if there's an issue later on, we need to have that preserved as to what was showed.
I have it. I'm going to hand it to the clerk. It's already loaded on the whiteboard that I'll play, but it'll be offered,
Wow.
submitted. I have it here. It will be in the clerk file.
so what witness is gonna,
It's solely based on the stipulation. You're going to read that
Okay.
stipulation, then I'm going to play 3 more. So I'll offer it into evidence based on the previous stipulation. It'll be marked, entered. I'll play it on the whiteboard.
The middle prosecutor
and
looks
then
like he's
I'll
there
play
to
the
break the
next,
knees of
3
anybody on the defense who gets out of line.
exhibits number,
Look at this guy. Look at this
number
guy.
2.
all right, so.
The defense attorney stands up one more time. I'm going to go over there and bust him.
How's this gonna work? Am I gonna read a stipulation during opening?
We're not playing a video in open.
Okay.
That's why
Okay, I thought that's what this was all about, right?
Is that Ray Donovan behind him there?
We're not playing the video in opening. It would be at the beginning of the state's case. in chief.
Okay,
It'll be
okay, that's
short.
why I couldn't understand. How are you gonna enter it during openings if, you know, you don't have a witness?
No, it'll be
Okay.
before any witnesses, I'm gonna play 4 videos. Based on the stipulations, then.
Oh my God.
You're just
Okay.
going to play
I'll be the
random
witness.
videos based on.
To play them, that's correct, but, and you either have to have a stipulation or a witness to
Yeah.
enter it. So,
we have the stipulations for those.
okay. So
Do they have a stipulation
just for housekeeping
for this
matters,
purpose?
before you play the video,
They have a stipulation that the video is
I assume I'm gonna
authentic.
be reading a stipulation.
According to the defense.
As far as the first one, we can go back to the one we signed years later.
All right.
We have that. In fact, I'll.
That's a
If I'm the
weird.
defense, I want to see that. Show me that stipulation that says
Yeah.
this is an accurate representation.
And I'll review it with Mr. Escobar, and then we'll provide it to the court. But I was just going to enter pursuant to previous stipulations, so we didn't have to refer to anything,
Okay.
which we all know what it is and occurred.
It just so
Do
it's
you?
also slimy.
Yeah.
Anything else we need to address before we get the?
I'm going to read some
Just
super chats as soon as there's a
signing
quick
these,
pause.
Orders real quick.
Okay,
And then
that-
if you'll may I approach or maybe,
you can come up.
thank you.
That one chick says early today. So proud of you. Thanks for your stream of these trials. It's a great way to make my workday a bit better.
Well,
Love you
Return
guys.
it to me, I'll make sure everyone gets a copy.
All right.
Squizgar says, Nick, you can't keep being on time. Think of your reputation. Jason Dixon says, did you grow up in Spring Branch, Houston, Texas? I did grow up in Houston, Texas. Spring Branch, it was Inwood Forest Village is where I lived. On Cold Lake.
All right. So do we have all?
Is that Spring Branch?
Awesome.
It might
Are we
be.
ready? Oh, fantastic. Good job. All right. Are we ready to bring them
Do I
out?
know you? Do we know each other as kids? That would be amazing.
All right. So they'll be sworn. I've got a little bit of instruction for them, and then
C.
You'll
Goody says,
begin
you can lead a horse to water, but you can't make him drink. You could lead a judge to a conclusion, but you can't make him think. Can I please turn off the subtitles? No, I'm not going to turn off the subtitles because it helps some people see what's being said when either if we're talking over the judge or the people, because, well, sometimes we do that here. And if you do not like commentary, by the way, go watch. You can go here. Let me point you to the direction of where you can go. See, there's a graphic right there. You can go watch it there. If you don't like commentary, that's fine. But so sometimes there's going to be us talking over people. We're not trying to, but it'll just happen on occasion.
By the way, you'll get a kick out of this. I was shopping in my local supermarket this weekend, and some dude with a shopping cart stops me and says, "Hey, you're the law self-defense guy. I saw you on Nick Recollection."
good morning. Thank
That's
you all
great.
for returning. Yeah, I need you guys standing for just a moment. You're going to go ahead and take an oath. But were you all able to abide by my instructions during the recess? Nobody did any independent research or looked up anything or watched the news or anything? All right. If you would, please raise your right hands to receive the oath from Madam Clerk.
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida
Okay,
and the
I'm
defendant?
gonna read this
Curtis
last
Reeves, and
one.
render a true verdict according to the
Britt
law
Kormeyer
and
says,
so help
these judges that
Okay,
put
you
off
can be
making
seated.
rulings
Thank you.
about what/how the parties can argue are like umpires that change the out of
All right,
bounds line
ladies
as the
and
game is
gentlemen,
played.
and just
If you don't know where the
a
boundaries are,
housekeeping matter real
how
quick.
can you
I
make good
know,
arguments?
Some of you had inquired about a letter
that's why you should be taking care of all
that I
this stuff
get
well
for your
before this
employers.
day.
How many of you need
Judge.
those? All right, number 2, 3, 4.
Yeah, Michael, I know that the AI robot that's doing the
9,
whatchamacallit,
8.
the subtitles isn't perfect, but it
So,
for
okay.
some people
All
it
right.
is better
And
than nothing.
you'll have those probably at the next break. All right, so I've got a few instructions for you, and then we are gonna move into opening statements.
But Jason Dixon, if you think like you knew me when I was a little kid, that would be super cool if you would email me, recollection@recollection.org. It's down in the description. Send me
All
an
right,
email,
ladies
man.
and gentlemen of the jury.
I can think of a
You
couple
have
Jasons
been
I knew, and if you're
selected
one of
and
them, that'd be
sworn
really
as the
cool.
jury to try the case of State of Florida versus Curtis Reeves. This is a criminal case. Mr. Reeves is charged with second-degree murder and aggravated battery. The definition of the crimes charged will be explained to you later. The state's charging document, which is called the information, and I read that to you earlier last week, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you, and it is your
So
solemn
the aggravated battery
responsibility
is
to
because
determine if the
the
state
bullet
proves
passed
its
through Nicole
accusation
Olson's hand
beyond a
before it
reasonable doubt
entered her
against
husband's
Mr.
chest.
Reeves in accordance with the law
So it's
that
a
I
different
provide
victim.
you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Testimony by witnesses is evidence. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers,
Juries are really good at
and the
this.
instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be solely on the evidence
Reform.
or
No,
lack
there's
of
a Chad
evidence and
Reed
the law.
shooting, not a Chad Reeves
I now
shooting.
instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, please notify court personnel immediately. During the course of the trial, the court will take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. And the reason for this is we've got microphones all around the courtroom, and even if your phone is on silent and it starts vibrating, it picks up in the microphones. You'll hear it. I'm sure it'll probably
Guess
happen.
the judge is day drinking.
This trial. You may use these devices during recesses, but
you know
even
the
then, you
thing.
may
Raw.
not use your cell phone
Digging.
or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room, and you will not have in the jury room any cell phones, computers, or other electronic devices. If someone needs to
It'd be ironic if someone's cell phone rings and the judge shoots them.
Messages and to deliver them to you without delay, but you will leave your cell phones on the table there while
That
you're
wouldn't be ironic.
deliberating.
It would be catastrophically hilarious.
This case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you're in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed in the trial. And all of these rules apply throughout the trial. Once you've heard the magic words that you are now discharged from your service as juror, I don't care what you do, any of that stuff. But between now until that time, these rules apply. Jurors must not have any discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic
I can't use a
devices to
phone to do
communicate.
what I otherwise.
Do not send or accept any messages
I thought I could text
related
with
to this
everybody
case
about it.
or your jury service. Do not discuss this case or ask for advice by any means at all, including
I like the
posting
Hunger
information
Games
on
pin
an
back
internet
there.
website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial
Queries.
judge has no way to make sure that the information you obtain is proper for the
They're
case.
questions
Freudian
of a little
slip.
bit of a
The
different
parties likewise have no
predisposition.
opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against him or her, and to present argument with respect to that
You
evidence.
happen to see the news story about the Maricopa
Any
County
independent
judge
investigation
who's
by
been
a
sending
juror
memes with her
unfairly and improperly
clerk
prevents
and
the parties from having that
and reporter,
opportunity our
and
judicial
they're really
system
super offensive?
promises. Any juror who violates
Making
these
fun of
restrictions
attorneys, making fun of
jeopardizes the
defendants.
fairness
Oh
of these
God, it's great.
proceedings, and a mistrial could
I'm
result
gonna talk
that
about it
would
tonight.
require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayer.
And especially to
If
me.
you violate these rules, you may be held in contempt
gotta
of
get this
court
case
and
out of my
face
courtroom.
sanctions, such as serving time in jail,
8 years,
paying a
8
fine,
goddamn
or both.
years.
The attorneys are trained in the rules of evidence and trial
8 years ago, I
procedure,
still looked like
and it
Gary
is their
Busey.
duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case.
So it looks like I'm going to have dinner with uncivil law when I get down to Texas.
If you would
Oh,
like to
nice.
take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and a pen for use if you wish to take
She
notes.
does look
That's
like
in
Nick
your-
Nolte,
in your
yeah.
envelope there. Any notes that you take will be for your personal use. You will be able to share your notes with your fellow jurors during your deliberations. Not any time other than that, of course, because you're not going to discuss anything amongst yourselves prior to your deliberations. However, you should not take them with you from the courtroom. During recesses, just leave them on your chair and the bailiff will watch over them. After you have completed your deliberations, the bailiff will deliver your notes to me and they will
This
be
guy,
destroyed.
like,
No one will ever read your
He
notes.
should be too, but
If
he
you
looks
take
so
notes, do not
angry.
get so involved in note
Like, I don't know
taking
how
that you
you
become distracted
should
from
look,
the
but he just
proceedings.
like
Your notes
gravity
should
has
be used
dragged
only
his
as
face
aids
into
to
a
your
scowl
memory.
forever.
Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence.
She's kind of a weird accent for me. The
At
way she
this
says
time,
notes.
the attorneys will have an
Notes.
opportunity to make opening statements in which they may explain to you the issues in the case and summarize the facts that they expect the evidence to show. After all the evidence has been received, the attorneys will again have the opportunity to address you and make their final arguments. The statements that the attorneys now make and the arguments that they may later make are not to be considered by you either as evidence in the case or as your instruction on the law. Nevertheless, these statements and arguments are intended to help you properly understand the issues, the evidence, and the applicable law. So please give them your close attention.
Clues. Where's she
Steve?
from?
Mr. Rosenwasser?
A brand man says Inwood Forest Village is in Aldine, not Spring Branch, so no reason to believe the other chatter was your stalker, but now maybe I
Members of
am.
the jury, what you're going
Yikes.
to learn during the course of this trial is that back on January 13th of 2014, Chad and Nicole Olson decided to spend the day together. It was a Monday. They had not been spending that much time together based on their work schedules. They were also raising their daughter, Lexi, who at the time was just under 2 years old. So they decided on that day that they were going to put Lexi in daycare and go out for breakfast, possibly shopping, maybe over to Wiregrass. And eventually, at some point on January 13th, they decided to go to the Cobb Grove
Hope the
Theater.
defense stands
They
up
were gonna
and
see
says,
the
what
movie
kind of
Lone
parent
Survivor.
puts their kid in
That was going to
daycare?
start about 1:20 in the afternoon.
Parent who doesn't
Now,
love
that's
their
located
children.
at 6333 Wesley Grove Boulevard in Wesley Chapel here in Pasco County. So what you're going to learn is that they go to the theater. When they get there, they purchase their tickets. They then go inside to the concession stand and they buy some snacks. After that, they decide to go into the theater. Now, this theater is theater number 10. And what you're going to learn is that theater number 10 is a Cinebistro. It's a general theater and a Cinebistro. And you may know what a Cinebistro is, but basically it's an area of the theater where you can order food kind of like in a restaurant setting. You don't have to go to the concession stand. And this particular part of theater number 10 is separated from the general theater by a wall. In fact, there's a separate entrance. Now, what you're going to learn is that when Chad and Nicole Olson decided to go into theater number 10, they were looking for some seats that were towards the back of the theater. That's where they like to sit. So they chose the row that was the second to back last row. And they went over towards the middle. Nicole Olson sat down, and on her right was Chad Olson. Now, at this point in time, there wasn't that many people in the theater. People were still coming in. They had their snacks. They were talking. And at some point in time, one of them, doesn't matter who, one of them wanted some more snacks or some type of candy. Chad Olson gets up,
Don't tell me what
leaves
matters.
the theater, goes back to the concession area. And of course, more and more people are coming into theater number 10 to see the movie. When Chad Olson comes back, he sits down. Again, he's still on Nicole Olson's right. And at some point in time during this, the defendant and his wife, whose name is Vivian Reeves, comes into the theater. Now, when they come into the theater, they decide to sit in the very back row. Now, there's a wall behind them because behind that wall is where the Cinebistro area is. They go to the very back row, walk all the way across to the middle, and they sit down. Now, to kind of paint a picture for you as to where everybody's seated, and you're going to see this in video, and people are going to tell you where they were sitting. Picture this. So in the very back row, you're going to have the defendant. He's sitting in the middle. Directly in front of him is Nicole Olson. To Nicole Olson's right is going to be Chad Olson. Behind Chad Olson is the defendant's wife, Vivian Reeves. So stated another way, to picture it a different way, you have the defendant in the very back row, basically in the middle. An entire row in front of him and an entire seat over to the right is where Chad Olson is sitting.
Wait, I mean, it's just one.
That's the layout of the theater on this particular day when this shooting occurs. Now,
Would it be
what
half
you're
a row?
learning
I
is
mean,
that
what's that
It's
mean?
right
there are
in
many
front
people
of
that came
him.
into the theater. In fact, at the beginning of jury selection, a long, fairly long witness list was read to you. And you heard from the court and you heard from us that you're not going to hear every single witness that's on that witness list. because there was a fairly
We're going to
large
hear
law
too many. So
enforcement
the
response.
pretrial immunity hearing was 2
Not
weeks.
everyone in the theater
But
has
just
relevant
imagine how long the
information.
trial's going to be.
Some people
God.
became aware of the shooting afterwards. Some people didn't see anything. Some people didn't hear anything. And some of the law enforcement officers were there for basically security. So you're not going to hear from every single person. The people that you are going to hear from, they have different parts of the whole picture, meaning this. Some of the witnesses that you're going to hear from heard the beginning of what happened. Some heard the middle, some heard the end. Some saw the beginning. Some saw the middle, some saw the end. Some heard and saw basically everything.
For everything, there is a season.
Now you are going to learn that there is a video. And by video, I mean just that. There is
I mean,
a
4
video
videos that we're going to show.
and not an
Just
audio.
4.
The video comes from the Cine Bistro area. There are 2 cameras inside of theater number 10.
Imagine
on
the other
opposite
prosecutor's
sides.
dilemma when he wants to rest his chin on his hands
Now,
and
they
he
were
can't.
designed, as I mentioned, to capture the Cine Bistro area, but they did capture some of the general part of the theater and did capture this shooting.
He has to
capture
put his
people
mouth
coming
on
in the
his
theater.
hands because his chin doesn't
Did
exist.
capture people leaving the theater. The
Got to
defendant
rest
leaning
his
and
lower
talking
lip
to
on his
girls,
hands.
things of that nature. The video did capture that. Again, there's no audio. The audio is going to come from witnesses. Now, what are you going to learn? Well, people are going to tell you what the lighting environment was. So people in the theater are going to tell you the following. Now, don't pay particular attention to any single one-word description because you can't adequately describe something in one word. In other words, to be pigeonholed to one word. For example, in everyday life, if someone were to tell you that someone was of a medium build, well, one person might think of that as a thin person, and another person might think of that person as a heavier person.
Well, that's
But
why he
the
said
description,
entire row away, because
when
that's
people
2 words.
elaborate, that's how you're going to be able to determine exactly what happened. So in this case, what are you going to hear from people that were in the movie theater? You're going to hear that at the time of the previews. Now, this shooting occurred during the time of the previews. So when I talk about the lighting conditions, it's the same during the time of the shooting. So what witnesses are going to tell you is that it was light enough for them to see in the movie theater. The lights weren't full, they weren't full house lights. It had been dimmed. So if you hear the words dim, dimmer, pretty dark, darker, that sounds like it's painting a different picture. But I submit the evidence is going to show you that when everyone came into the theater, their overall description, forget the one word, was that they could see. They could see aisles, they could see rows, they could see seats, they could see people in those seats, even at a distance. They didn't have any concern during these previews. Again, this was the time of the shooting, that they needed a flashlight or their phone to offer some light for them to navigate in the theater. It wasn't dark like when the movie starts. That's the lighting conditions at the time the shooting takes place. And that's the lighting conditions you'll learn about when Chad Olson is on his phone. Now, what happens? The previews start. People are seated inside the theater. Again, you have the defendant in the very back row in the middle. In front of him is Nicole Olson. Over to her right is Chad Olson. Behind Chad Olson is Vivian Reeves. The previews start, and there is a message that you should turn your cell phones off, basically. Now, here's what you're going to learn. Chad Olson had his cell phone on. Now, by on, this is what I mean. Chad Olson, the evidence will show you, he's not talking on his phone. He's not conducting a business transaction. He's not talking to a friend, a family member, not having a loud conversation. By on, literally the phone is on. That's it. The evidence will show you that there was a white light coming from the phone. That's how the phone was on. You're going to learn that almost immediately or very close after the time of that message, please be responsible, turn your cell phone off, whatever the message is. Very close in time to that, without really waiting, the defendant over here leans in to Chad Olson and Nicole Olson. Because the evidence will show you that cell phone.
I think we've learned today that
No
message is valuable and should be heeded.
Now, what you're going to learn is that this defendant leans all the way in, and it's
All
going
the
to
way
sound
in.
when I say this, to Chad Olson's personal space. And you're going to see this on video because it's captured. Not only is a witness going to talk to you about it, but it was captured on video. The defendant leans all the way in from his seat and basically gets back to the left ear of Chad Olson. So the defendant's head is basically in their space.
I'm gonna lick
Basically,
You're going to learn from a witness that the defendant's tone was kind of demanding. Turn your cell phone off.
the witness is the decedent's wife.
Now, at that point, their evidence will show you they're kind of taken aback by this. Now, Chad Olson did not turn his phone off. Now, here's what you're going to learn what was going on that phone. He was looking at Facebook, social media. There was a website that he was looking at through Facebook, and they had been looking at it.
What website?
The evidence will
Pornhub.
show you, of course, that's no reason to shoot another man. But here's what you're going to learn.
Wait,
That
the evidence is
defendant
going to
leans
show
all the way
that?
forward, tells Chad Olson to turn his phone off. Chad Olson doesn't turn his phone off right away. Now, in a perfect world, should Chad Olson have turned his phone off? Yes, but the evidence will show you that you can't kill someone for that. Now, the evidence will also show you this, that the
Where's
defendant
the
waited a
evidence
little
going to
bit,
show you that?
asked him again
Legal
to turn his phone
conclusion.
off, then got up to leave the theater. Now, the way
Nobody's claiming he shot him because he didn't turn his phone off fast enough.
The overall attitude and demeanor of the defendant that's going to be described to you during the course of this trial is very important. Because one of the charges the defendant's been charged with is a crime called murder in the second degree. And all of these laws are going to be explained to you at the conclusion of the case when the judge gives you all of the instructions. But a part of murder in the second degree is that we have to prove that the defendant acted with ill will, hatred, spite, or evil intent. Ill will, animosity, bitterness, spite, annoyance. So the defendant's demeanor and his actions will play into whether or not there was ill will, hatred, spite, or evil intent. So here's what's important.
He was on
when the
Mommy
defendant
Chew's
gets up to go
Facebook
tell the
page.
manager that this white light is bothering him.
I'll allow it.
The movie begins. The defendant gets up, and as he goes out the aisle, he's mumbling to himself. Now, you're going to hear from a witness who's going to tell you that based
They
on
keep saying a witness. It's the decedent's wife.
and angry. The evidence is going to show you that he was. He was annoyed that Chad Olson still had that phone light on. And he walks out, he's mumbling to himself. Now, as he's walking out fine, meaning this. Whenever anyone navigates through an aisle or a row in a movie theater, you necessarily have to move around people, and it's kind of awkward. But he was able to do that. There's a video that you're going to see that shows him getting up and walking out of the theater. People watch him leave the theater. Memories in the back row. Goes all the way down the steps. There might be 13 rows. You're going to see pictures. You can count for yourself. Walks all the way down the ramp, all the way to the manager's desk. Now, when he's at the manager's desk, what happens? Well, when he's there,
He said,
and again,
"Hello,
there's
my
no
name is
audio,
Karen."
There's going to be just a video. Watch his demeanor. Now, I don't mean to present to you, and I'm not painting the picture to you that when he's at the manager's desk, he's banging on the desk and screaming and demanding action, because he's not. But when we're talking about the demeanor of the defendant, the evidence will show you this ill will or spite. Watch his arms, watch his hands, watch his fingers, watch his facial expression. He's there for about 3 minutes, walks back into the theater, all the way up the ramp, around the corner, all the way back up to the back row, all the way across again into the middle. Now, the witnesses you're going to hear from are going to tell you this. They're going to tell you that the defendant did not appear to have any disability. He didn't have a cane, didn't have a walker, didn't have a wheelchair. The evidence will show you, and it sounds like a silly thing to measure, the defendant parked 133 yards away from the theater. Now, it sounds silly again. It's a football field and a third, but there's no handicap placards. The defendant's not handicapped. Wife didn't have a handicap placard. You're going to see video of the defendant as he purchases tickets. He's in the lobby area, in the concession area, walking to and from the theater. Now, why is that being brought up? Well, the evidence is going to show you this, and we're going to talk more about it in just a little bit. But the defendant gives a taped statement to law enforcement, freely and voluntarily waives his rights, and there's going to be a picture painted during this taped statement. And one of the things you're going to learn in this taped statement is the defendant states he's got arthritis in his back and his knees. Well, the evidence will show you that, let's say that's all true. It's very, very bad. The evidence will show you that's no reason to shoot and kill another person. However, when you see the actual pictures,
the evidence,
meaning the video, and you listen to the witnesses, you're going to see he was completely fine.
That's a legal conclusion, by the way.
What
Again,
happens?
that's not an
When he walks
evidentiary
back
conclusion.
into the theater, after speaking to the manager.
Plus, Reeves' physical condition
back
is
across the
relevant to self-defense.
Now,
Right.
it doesn't matter exactly when this happens. It's either as the defendant comes back into the theater, as he's sitting back down, or even some seconds after he's fully seated in his seat. Doesn't matter. But the defendant in this taped statement indicates that he reinitiates contact with Chad Olson. Now, what's the evidence going to show you in this case? Chad Olson was talking to someone earlier, and it was the person in the row in front. At no time will the evidence show you that Chad Olson is volunteering to talk to the defendant. The defendant's always the one initiating the conversation. And as the defendant comes back, based on his own statement, he indicates that he reinitiates contact.
There's
with
contrary
Chad Olson
evidence.
and tells him
that.
this. And here's something that's important you're going to learn during the trial. Chad Olson did, in fact, turn off his cell phone. The phone was off when the defendant came back into the theater. The evidence will show you that the defendant could have just sat back down in his seat and everyone could have watched the movie and everything would have been fine. The phone was off, no problems.
I
Did Chad
hate this
Olson
stupid argument.
Stand up and turn around.
The evidence will show you that after there's a conversation, Chad Olson is in his seat.
I mean, it's uncontested
Now,
who
what
was the
defendant
initial physical
states
aggressor.
to Chad Olson is, I see you put your phone away. I told the manager for no reason. Now, I submit the evidence will show you that there was no reason for that. Regardless, the statement was made. Based on the defendant's own statement, Chad Olson turns around in his seat. Now, when you listen to the defendant's taped statement, pay very close attention to the words he chooses to use and the order in which he uses these words.
Now the specific words matter.
The defendant states Chad Olson turns around in his seat, and now Chad Olson says some words to him. Now, in a perfect world, should that have happened? No. The evidence will show you you can't shoot someone for that. Chad Olson does turn around and starts to have some words with the defendant.
It's
Mind
just not a
your business, leave
compelling
me alone. There might
argument
be an
here.
F-bomb in
You
there.
keep saying, well, the defendant didn't have to do this. He could have done something
At some
different.
point,
But when the
very close in
victim
time,
could have
this
done
is all
something different, then it
happening,
doesn't matter. You can't shoot
fairly
somebody for that.
quickly. It's fluid.
Right.
Chad Olson stands up and continues, and he looks at the defendant. Chad Olson's in his row. Remember, he's an entire seat in front of the defendant.
An entire seat,
I mean,
6
an entire
inches.
row in front of the defendant, and an entire seat over.
He's literally the
And during this
seat in
conversation,
front of
while
him
he's
and to the
standing up,
right.
he says, if it's any of your business, and there may be an F-bomb in there, I was texting my daughter. Now, the evidence will show you that he was on Facebook. The evidence will show you that under the law, whether he was on Zillow, buying a car, buying a house, checking the stock market, Facebook, texting, you can't shoot and kill somebody. It's irrelevant. I submit the evidence will show you he was just trying to get the defendant to leave him alone, and that's what he chose to say. Really doesn't matter. So the evidence will show you
Well,
this.
the defense
Chad
should
Olson
chew
stands-
up this opening statement.
And as he's standing up facing the defendant, and you will see this on video, Chad Olson reaches over with his right hand. And he reaches over into the defendant's lap and he grabs something. Now, this might sound silly.
It was his
What does
penis.
he grab? Does he grab a deadly weapon out of the defendant's lap?
Why would he do that?
The evidence will show you absolutely not.
Did he grab a
even
pumpkin?
grab a big tub of heavy popcorn? No, here's what you're going to learn during this trial.
Tub of heavy
Chad Olson
popcorn.
reached over
Where
with
did
his
he get one of
right
those?
hand into the lap area of the defendant and grabbed a bag of popcorn.
No, I'm kind of on
He
the
grabbed
side of
that
the
bag
defendant
popcorn
after
and he
hearing
brought
this.
it back and he flicked it at the defendant. Now, the
Flicked
evidence will
it.
show you, of course, in a perfect world, should Chad Olson have grabbed a bag of popcorn and tossed it on the defendant?
Well, that's a battery.
Of course not.
I mean,
The
it's a
evidence will show you
crime.
you can't shoot and kill another person over that.
Well, maybe.
So the evidence
It's
will
a
show you
battery
this.
on someone
There's
over the
a
age
couple
of
things
65
happening
years
simultaneously at
old,
this point.
which is a
So I wanna
felony
break
in
it down
Florida.
just a little bit.
And you can shoot somebody in
Chad
Florida
Olson
to prevent
stands
a
up,
forcible
he's facing
felony.
The defendant says something about texting his daughter. He reaches over, grabs a bag of popcorn, and flicks it. Doesn't pull it back, isn't using it like a bat, just flicks the popcorn off. His hand is now coming back. At about that very same time, Nicole Olson, remember, she's sitting in front of the defendant.
A whole
She's
row.
starting to reach over with her left hand while this is happening. And in the process of getting up to say, honey, it's just sit down. So her hand's up.
So he's standing
When her
up
hand
now.
is up,
Yeah, yeah.
and
he
while
stood up
Chad
and
Olson's hand's coming back from that popcorn toss, this defendant shoots. So taking a step back, to kind of go over what happened. The evidence will show you Chad Olson is sitting in his seat, turns around, says a few words to the defendant, stands up, says a few words to the defendant, reaches in, grabs the popcorn, flicks it. Now, this is important to watch on the video because it goes back to arthritis, my back, my knees. What you're going to see on the video is the defendant in an incredibly quick and swift maneuver reaches his right leg out as he's leaning back, goes into his pocket to get his firearm that he's brought into the theater, pulls it out, and lunges forward to shoot Chad Olson. The evidence will show you he's not back in fear, but watch the manner in which he grabs his firearm, how quickly he is able to do it, how fluid he's able to do it, and how he lunges forward as he shoots. And why is that important? Well, to go back to the instruction of ill will, hatred, spite, or evil intent. The evidence will show you he was mad. Chad didn't listen to him, and Chad threw popcorn on him.
That's not ill will, spite, hatred, or intent,
what happens
actually.
next?
None of those apply to him
After that,
being mad that someone threw popcorn at him.
Chad stumbles. He begins to turn to go towards the aisle. He goes down a couple of seats. He's shot in the chest. He can't make it to the aisle even. He falls down on other people in the theater. Nicole Olson's finger is almost shot off. It's almost severed from the bullet going through. She's screaming. Chad falls on the ground. There happen to be nurses and other people there that try to help Chad Olson as he's laying on the ground with that bullet in his chest. Now, ultimately, of course, Chad Olson dies. He's basically dead in the
little 380 caliber round. 380s kill a lot of people.
There happened to be an
folks.
off-duty deputy, not from the Pasco Sheriff's Office, but from another county in the theater. He gets up, you're going to see this on video, and he walks over to the defendant. The defendant has his gun on his lap. It's taken from him. The gun eventually is given to a sergeant at the Pasco Sheriff's Office. That gun is eventually sent to a place called the Florida Department of Law Enforcement. Now, during this trial, there's going to be some stipulations. Stipulations are agreed upon facts, so to speak. You get these, there's not going to be any other testimony on the matter. They're basically just accepted to. Now, one of the stipulations you're going to learn is that this firearm, the one the defendant used, it's a 380, was sent to the Florida Department of Law Enforcement. There's a shell casing there. Shell casing came back to that gun. Now, that's not an issue in this case because this is not a whodunit case. The important part of that stipulation is that this firearm, the one the defendant brought into the theater, was working properly. Didn't malfunction, wasn't an accidental shooting. This was an intentional and purposeful shooting. The gun was working fine.
It's not going with the Edgecombe self-defense theory.
People are working on Chad Olson. His other deputies with the defendant.
Not yet.
You can imagine when there's a 911 call about a shooting in a movie theater, there's a fairly large law enforcement response, and there was. And this is when the investigation begins. Now, people that were in the theater, they go to different parts of the theater. Some are in front of the screen, some are in the concession area, the lobby. Now, fire rescue was called. They had to what's called stage, meaning they had to wait for the movie theater to be secured before they could go in to try to help Chad Olson.
That's always true.
When the deputies came in, they made sure the scene was secure. They were trying to help Chad, dealt with the defendant. Fire rescue comes in, everyone goes to the hospital. Chad's life can't be saved. Eventually, Nicole has work done on her finger. Now, while deputies are there and people are in different parts of the theater, they hand out these blank forms. And sometimes they're called written statements. And people are not given any instructions on how to fill these out. They're just told to write down what you know. Now, of course, these are people in a theater who aren't law enforcement officers or lawyers, and they don't know how much to write or how little to write. Some people write one sentence, some write 10 sentences. It's basically just what they saw. Some people are going to tell you they're really upset by what they saw. And law enforcement used this as a first step in their investigation. Read those written statements, try to figure out who they needed to talk to in some type of order. Who they were going to talk to that day, who they were going to follow up with later on. That's what happened with the written statements. Now, when people filled out these written statements, some people were near them, but no one was telling other people what to write or what to say. The witnesses that come into court are going to tell you what they personally heard and what they personally saw. That's it. Now, witnesses were interviewed. The defendant himself gave a statement, as I mentioned. He gave a tape statement. What the evidence will show you is that Chad Olson was shot and killed over tossing popcorn. The defendant's statements are fairly consistent with other testimony and other evidence, including the video, up until the point of time of the shooting. The evidence will show you that the defendant's statement is not accurate as about what had occurred, based on what you're going to view during the course of this trial. So what did the defendant tell the police? The defendant tells the police that he went to the theater. Obviously, he did.
So that's
While he was in the
accurate.
theater, he saw Chad Olson had his phone on. Now, the defendant states he leaned forward and was being nice, asking him to turn the phone off. When Chad Olson did not, he got up and went to tell the manager. He came back. The defendant says that when he came back, he did talk to Chad Olson, and he told him the statement that I represented before. I see you're not on your phone anymore. I went to tell the manager. He says, and again, the words he chooses are very important. You're going to learn that he was former law enforcement, so he knows the importance of the accuracy of words. He says that Chad turns around in his seat, and at that time, there's some words between them. He then indicates that Chad Olson jumps up. Now, here's where I submit to you the tape statement.
Why is
has
in his
maybe
seat
two
so
different
important
statements,
if he
and this is
jumps
where you're
up
gonna have to
by the time he's
critically
shot?
analyze this tape statement. It seems as though the evidence will show you that the defendant states nothing at all about the popcorn in the beginning, as that event never took place.
It seems as if.
Now, you're going to learn with his glasses on, the defendant's got 20/20 vision. Can't really miss anything.
Oh, you can still miss things to 20/20
What the
vision.
defendant states is that Chad Olson is coming over on top of him. Okay, so when you listen to the tape statement, at first it appears as though the whole popcorn thing never happened. Later in the tape statement, the defendant states when Chad Olson jumped up, the popcorn fell almost immediately. Well, the evidence is going to show you that after the popcorn fell, that's when this defendant immediately took out his firearm and killed Chad Olson. So the evidence will show you that tape statement's not exactly true. He says that when Chad Olson jumps up, the popcorn fell immediately. And this is the picture painted in the defendant's tape statement. Here's what the evidence will show you.
So he didn't perceive the
defendant
popcorn
states
being
he's in a
thrown
seat
at him. He perceived a
behind
man
the poles,
attacking
and
him.
remember, Chad
Is
Olson's one
kind of how it sounds.
seat over to
Yep.
the right. One row down, one seat over. He's back in his seat, and he's got his left hand up.
Reeves also
and he's
claims that he
yelling,
was
"No,
actually
no,
struck in the
no," or
head
"Whoa, whoa,
with
whoa."
some
This is
hard
the picture
object.
the defendant's
Maybe
gonna put on
maybe
his statement. And he's
Olson's
back in his
phone.
seat,
He
and
had a
Chad
red
Olson is
mark on the
coming
side of his
over the
head when he was
seat,
photographed by
and Chad
police.
Olson is virtually on top of him. In his lap. Those are the words the defendant himself uses. Virtually on top of him in his lap, and he's got his left arm out, and he's touching his arm or his shoulder, but he really believes he's touching Chad Olson's chest because he's so far into him, into his row. And at that time, he has to straighten his right leg out, pull out that firearm, and kill him. The defendant states he's surprised he didn't shoot his left hand because his left hand was so far out when he took that shot. He's surprised.
Okay, this isn't
The
actually
evidence
helping
will
the
show you
prosecution's
that is not
case,
exactly
to
what
me.
There will be no witnesses that will come in here and tell you that happened. No one heard any yelling, screaming.
I think the
any
defense
type
has evidence of
of
stippling
fight like
on the
that,
left
like a
hand,
struggle.
which would put it in front of the muzzle of the gun.
You're going to hear about a term called stippling during the course of this
There you go.
trial.
There it is.
Stippling, and this might be a really bad description of it, is when a firearm is fired, material comes out, hot material, and anything that's close in its way gets these embers, so to speak, and there's a burn mark on skin. Now, you will see stippling in this case. The evidence will show you there was stippling on Nicole Olson's hand because it was in front of the firearm when her finger was almost shot off. You're going to see stippling on Chad Olson's wrist because when he brought his wrist back after tossing that popcorn, you're going to see stippling all over there. But the evidence is going to show you there's no stippling on the defendant's left hand.
Oh, maybe I was wrong
This will
about
show you
that.
that's because his left hand was not out. No, you got to get off of me. That's what the evidence is going to show you. Now, after the defendant fires the shot, there's some important words that people in the theater hear. And these are people that don't know each other. And these are people that are in different areas of the theater. And the defendant states some words to the effect of throw popcorn at me or throw popcorn on my face. Yet when you listen to the defendant's tape statement, it never really brings up the popcorn. The evidence will show you that's important for ill will and spite. And when you see the way he lunges forward with the firearm and makes that statement, you get a clearer picture of what was really going on in the theater on January 13th.
I watched the video. I didn't really see a lunge forward.
The defendant states in this
Maybe
tape
I missed
statement that while he's back with his arm out, yelling, no, 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 or whoa,
That's
whoa,
why
whoa,
they have this enhanced
has
video
Bertie in his lap. He's
version,
struck
so they can
on
do the
left
Binger
side,
thing. See, it's right
side.
there. It's right there. You can see it. There'll be some vague movement.
And we're going to hear defendant, prior law enforcement. Words and choices of words are important. The defendant states in this tape statement that he's hit on the left side of his face. Well, witnesses are going to tell you they never saw that. And the evidence will show you that.
I never saw it either. That doesn't mean it didn't happen.
It's not possible. The evidence will show you that Chad Olson was a row in front and a seat over to the right. And that it would be virtually impossible for him to do this hook that hooked all the way around from that distance across an aisle, all the way across seats, and struck the left side of the defendant.
Didn't Chad
As
Olson
he was all
tall?
the way back with his left.
Yeah, 6'3".
The evidence will
I mean,
show
I
you
could
simply
easily
did
hit
not
someone
happen.
in the.
The evidence will show you there was no injury.
This guy can't. He's
As
short.
if he was struck that hard, because the defendant in his tape statement, you will learn, says he was dazed, but he wears glasses. You'll see there is no injuries of any markings for glasses of being hit that hard that he felt he had to kill another human being. At some point in the tape statement, the defendant indicates he thinks that maybe a cell phone was at play because he saw the blur of a screen. Now, you will learn that a cell phone was found in front of the defendant, and it was, in fact, Chad Olson's cell phone. I submit the evidence will show you that it got there in one of two ways. One, because he was holding it in his left hand or his left side.
Thought he had put it
We
away.
know that because that was the side that was bothering the defendant. That when he stood up and he grabbed that popcorn, it fell over. Or at the time he was shot, it was dropped. But the evidence will show you that no witnesses see anything.
Well, if he dropped it when he was shot, then he was leaning over the row, right? He was leaning.
Yeah.
There's no possible way that could happen.
The
over-
fact that
over the
that cell
seat.
phone
Now, another
exists
stipulation will
in
be
the
about
row
the
is
cell phone.
consistent with his
This cell
statement.
phone
It's
was
not
also sent to the
inconsistent.
Florida Department of Law Enforcement. And there was some DNA testing done on this phone. Chad Olson's DNA was on the phone, but not the defendant's. Now, you're going to see pictures. The defendant did have some redness on his left eyelid, possibly the most fragile part of the human body. But the evidence will show you he had his glasses on.
Does this
And
guy
the
not have
reason that
testicles?
his left eyelid, only his left eyelid, was red was because after the shooting, he was rubbing his face and rubbing his eyes, and witnesses will tell you that. He indicates he thinks there's something in his left eye. Paramedics check him out. There's nothing in there. They do a saline rinse. That's the end of the story. The defendant indicates in his tape statement that he second-guessed himself. He's sitting in the cruiser, and you're going to hear he says, I'm second-guessing myself. Did he hit me? This is the picture that's going to be painted for you during the course of this trial. The defendant also states, and I apologize for cursing at some point in his tape statement, and again, I apologize for the language, but oh shit, this is stupid. Now, for his actions, the defendant's been charged with 2 crimes: murder in the second degree and aggravated battery. Now, again, all of the jury instructions are going to be explained to you at the conclusion of the case. Now, suffice to say, this is what murder in the second degree is. What we have to prove to you is Chad Olson is dead. It was due to the criminal act of the defendant, and it was by an act that was imminently dangerous to another, demonstrating a depraved mind. And shooting someone at close range is an act imminently dangerous to another. That's not going to be an issue in this case. Did he do it with a depraved mind? That's where we fall back on the definitions that you're going to learn: ill will, hatred, spite, or evil intent. The other crime that the defendant's been charged with is aggravated battery. Now, going back to murder in the second degree, we do not have to prove to you that the defendant here intended to kill Chad Olson, just that he intended to act, which he did. This is not a case where it's an accidental shooting. He did intend to shoot him, and he died. We just don't have to prove he intended to cause Chad Olson's death. Now, aggravated battery, what we have to prove to you is that the defendant did intentionally, knowingly, and unlawfully touch or strike Nicole Olson against her will. Now, obviously, he didn't do that with his hands. He did that by using a gun and firing a bullet. So it's the same analogy. Did he touch or strike her against her will? And did he use a deadly weapon? Yes, a firearm is a deadly weapon. The other way that we could prove aggravated battery on Nicole Olson is, did he intentionally touch or strike her against her will? Yes, and cause great bodily harm, permanent disfigurement, or permanent disability? And the answer is going to be yes. You're also going to learn about an instruction called transferred intent. And basically what that means is if one person intended to do an act, meaning the defendant intended to do an act to one person, but ended up harming another. In other words, intending to shoot
You don't get
Chad
to make
Olson,
a defense saying, well, I didn't try to hit
harm
them.
Nicole Olson, be transferred intent. And that's how we get to the aggravated battery charge. Now, what is this
Well,
case
that
gonna
it
be
presumes
about?
unjustified intent. If it was,
Based
if the
on
intent was
facts that
justified,
were given
that
at the beginning of
transfers
the
to.
Recollection and the defendant's
Right.
own tape statement, it's apparent the defendant is claiming self-defense. So you're going to hear a lot about self-defense. At the conclusion of the case, you're going to get all of the self-defense jury instructions.
We're going to give you so
Maybe
much
not all of them.
The
self-defense.
question will be not whether or not this
Maybe
was
not
an accident.
provocation.
There's no evidence of that. It was an intentional shooting. Whether or not the defendant was lawful, whether or not he was justified in using that deadly force and killing Chad Olson. Now, this is basically what the self-defense instruction indicates. The use of deadly force is justifiable if Curtis Reeves reasonably, okay, and these are going to be important words here, reasonably believed that the force was necessary to prevent imminent death, he was going to die, or suffer great bodily harm, while resisting an attempt to commit a felony upon him. In deciding whether or not the defendant was justified in the use of force, the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used.
No mention of the forcible felony
The evidence will show you
basis
those
for
circumstances.
deadly defensive
At the
force.
time
He
that
kinda
the force,
glossed
meaning
it.
the shooting took place, was that another individual had tossed popcorn on him. The danger facing the defendant need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person under those same circumstances would have believed that the
Which means
danger,
as a
and the
what,
evidence will show you the
71-year-old
danger was
man.
popcorn was just thrown on him, could be avoided only through the use of that force.
So again, like
So the question for you
not
will
to
be
defend
this.
the guy, but his
Would a reasonably
perception,
cautious
is it
and prudent
reasonable for him to
person
think that a
at 71
young
years old, because that's how
6'3"
old the
man
was,
standing up,
would a
turning around,
reasonably cautious
grabbing at
and
his
prudent
popcorn
person
is taking a
at
swing at
71
him
years
and puts
old,
him in serious bodily and danger of serious
6'2",
bodily injury? Is that reasonable? If it is,
270
then
pounds,
it's justified.
who's able to walk all around the movie theater, who has over 20 years of law enforcement experience, including 15 years on the Special Weapons and Tactics Squad, also known as SWAT. Sitting inside a theater that, by all accounts,
When
is
is-
described
back when
as
it was a
high-end,
cavalry
steep,
unit.
the environment, not pitch black like the movies, and not deafening loud. Reasonably believe that the danger could only have been avoided through the use of shooting Chad Olson. And the answer is going to be absolutely not. The evidence will show you there were some differences between Chad Olson and this defendant on January 13th.
This guy doesn't look
2014.
270.
Chad Olson was 6'4". The defendant
He's
here
big,
is just
I
6'2".
guess.
2 inches difference. The defendant outweighed Chad by 65 pounds, but there was an age difference. The defendant was sitting an entire row back, an entire seat over. But the most important
An
difference you're
entire
going to learn
row.
about during the course of this trial is that one of those two individuals brought a loaded firearm into a theater and shot and killed another person after popcorn was tossed on them. And that's
I would
this
hammer on
defendant.
that
That's the
entire
one.
thing. I would really point out how much this guy
At the
is
conclusion of this case, we're
misrepresenting
going to
that.
ask you to find the defendant.
He's really being
guilty of
deliberately
murder in the
deceptive
second
on
degree.
so many fronts.
We're gonna
I
ask
mean,
you to find
the
guilty
defendant's
of
not
aggravated
claiming
battery.
that he
Not
shot
because we're
somebody because
asking
they
you
had an
so, but
exchange
because
of words.
The evidence that you're going to see in here during the course of this trial is going to tell you that that is the lawful and just verdict in this case. Thank you.
Thank you, Mr. Rosenwasser. Ladies and gentlemen, who's gonna, okay, we're gonna take a break, yeah. Mr. Michaels will be doing his opening statement in a few moments, but I think it's
Dino
appropriate
Dino
to take a
Michaels
10-minute
with the
recess.
bow tie.
So,
He's got a bow
remember
tie.
my
I
instructions during the
immediately
recess. No
distrust him.
research, no discussing the facts, etc. And the bailiff will, where are they going to go to the jury pool room or just mill about and then return back here? Okay. All right. So as usual, you can mill about a little bit and then, but try to stay to this side of the courthouse if you would, and head back.
So
to
the
jury
defendant still
pool
hasn't
room.
bought himself a
and
decent suit jacket.
Deputy Martin will come and get you. Any questions?
He's
All
only
right,
had 8 years
thank
to
you.
shop. All right, I'll pull their feed off while we wait. So yeah, so that's the prosecution's case here. Now to the chat, I want to say something about my personal perceptions and biases the way they are now. I go into this thinking guilty. That's where I am on this, because to me, just the basic description or synopsis of the situation, absent any argument, absent any witnesses or whatever, is that I have a hard time believing that a guy shoots somebody over popcorn and it's justified, because that's kind of the narrative of the case, right? But now, as we're sitting here and as we listen to the prosecution's opening argument, I'm starting to have my doubts. And the reasons I'm having my doubts are because I'm immediately starting to distrust the prosecution's description of events. Because, and it starts with that row, an entire row in front of him, an entire seat over. It's literally right there. I mean, you've all sat in a movie theater. And it had to be. They've
It's
already
uncomfortably close, right? I mean, we don't
Yeah.
enjoy that part of it. I mean, the prosecution's trying to make it sound like there was an empty row between them.
And this guy is 6'2", which means his
I think
knees.
he's 6'4", actually.
Well, the big guy, the dead guy is 6'4", but the
Yeah.
defendant's 6'2".
Right.
So the defendant's knees are likely against that seat or very close. Just take it from a guy who is 6'2". When you sit down at basically any movie theater in the world, your legs are right up next to, if not pressing into, the seats in front of you. They just are. So he's also 270 pounds and he's older. So like the idea that he's way back or whatever from this guy is probably not true. In fact, he's likely hunched forward a little bit. But that being said, it's right there. There's no, and we know it has to be right there because by the prosecution's own statement, this guy stands up and grabs popcorn from his lap, which I didn't know. I thought he grabbed it out of his hand, but he's reaching in so far into his space that he's grabbing the popcorn out of his lap and then flicking it at him, just loving a love flick or whatever of popcorn. So now, based on the way that the prosecution has presented his case, this is just me, I'm starting to distrust the factual representations made by the prosecutor in the opening statement, because I've been to a movie theater before and I know that now his definition doesn't sound accurate. And this is why it's really important not to oversell these things, in my opinion, because if you get me in that jury box, I'm a guy going, wait a minute, I don't like any of this that you're saying. This doesn't ring true to me. This sounds like you're misrepresenting stuff.
Yep.
Also, I agree with what you're saying. The witness that he keeps mentioning is the wife. And I think that omitting that fact is maybe setting the jury up to be very disappointed when they find out the witness who's saying this is the wife and not someone else. But what are your impressions of that opening statement so far?
Yeah, I thought it was at best ambiguous, at worst deliberately deceptive in characterizing the events. And if you're the prosecution and you think you have a conviction here, you don't need to do that. And you set yourself up for failure. I mean, this is an adversarial process. The defense gets a chance to talk to the jury now too. And if the defense is smart, they will highlight these mischaracterizations, these acts at deception. The state keeps saying an entire row. That was 6 inches away. Why are they doing that? Why are they trying to create a misperception, a misunderstanding in your minds? Ask yourself that.
Right. And one of the other things that's really important to remember in any self-defense case is it is the defendant's perception of reality, so long as that perception is reasonable. So it doesn't actually matter if the guy grabbed his popcorn. If the motion to grab the popcorn looks for all the world to Curtis Reeves like that guy is trying to hit him and cause him harm, and this, again, like, I know he's 65 pounds on him, he's still 6'4". I don't want to be hit by any 6'4" man. I don't care if he's thin and wiry or gangly or whatever. Just there's a lot of bone mass there that can transfer energy.
Almost
even if
half his
they're-
age too.
Right. Even if there's very little muscle, but 6'4" guy, and he even characterized it as jumps up. So he jumps up out of his seat, turns around, and goes to grab the popcorn. If the jury agrees with Curtis Reeves that he is perceiving a threat in that action, then he very well could be justified, even if the reality of events turns out different than he anticipated them to be. Now, there would be a question as to how much time elapses between this motion and the shot, but like the prosecutor's making the case that the shot happens immediately after the popcorn is thrown. Well, and he's talking about like how fast that reaction is. Maybe it wasn't fast. There's a very real possibility that reaction was slow and that he's reacting to the movement that comes at him when the guy's grabbing the popcorn. I don't know, but that's not unreasonable to think of, in my opinion. Now, will we get testimony to that fact? I would, if I'm the defense attorney, that's what I'm trying to elicit out of my client, is that he was not reacting to the popcorn. He's reacting to the 6'4" man's arm swinging at him. And the fact that he got his gun out at the time that fast, even at his age, is still impressive, but that he was reacting to being attacked, not reacting to having popcorn thrown at him. And so I think it'll be the defense's job on their opening statement to really poke as many holes in the narrative that they can and point out anything where the prosecution has even a hint of deception, because the argument should be, this is a straightforward case. And if the state had a straightforward murder case, they would present it straightforward, but they're not. They're not telling you this. They're not telling you that. They're trying to convince you so hard of something here. And the question is why? We think this is a straightforward case, and we're going to tell you this is what happened. There was a discussion about a cell phone. When our client came back from the manager, he sat down and said, guess I didn't need to tell you about that, or didn't need to talk to the manager after all. I see you put your phone away. And then after that, the other guy turned aggressive. And the other guy got up and turned around, and he grabbed my client's popcorn out of his lap. Yes. And he threw popcorn at him. But really, what was that throw? What was going on there? That was an assault on my client. My client perceived it as an assault from a larger, much younger man. And he turned and he had to fire. That was the only way he could do this. It's a very straightforward case of self-defense. Look, when you're my client's age, any little thing can happen and cause you a permanent injury or even death. You've all heard of someone falling and breaking their hip. You've all heard of how quickly an older person's health can decline from the slightest injury. My client's thinking about that every day. He's watching his own health decline. He's watching his wife's health decline in real time. It's preeminent in his mind. And this guy put their entire life together in jeopardy. And that's the narrative you build, in my opinion. I mean,
Yeah, there's no question who was the initial physical aggressor here, right? That was Chad Olson. Maybe by the strike to the head, maybe by just grabbing the popcorn and throwing it back. But this is the trouble for frankly, I thought the prosecution's opening during the self-defense immunity hearing was actually better from a substantive legal perspective than this. They, at least there in the self-defense immunity hearing, the other attorney, I think is the prosecutor Martin. I don't know who this guy's name is, by the way. The reporting on this case is terrible. I keep trying to find out the names of the prosecution team, and the newspapers never even mention their names. But at least they touched on each of the elements. They touched on innocence, the issue of provocation, which we heard argued earlier. They touched on imminence, that even if there was a threat, the threat was over by the time the shot was fired. They seem to be backtracking on that now by saying how quickly it was that the shot was fired. They talked about proportionality, that even if some defensive force would have been justified, deadly defensive force would not have been justified. It was just popcorn. They talked about, well, not avoidance, of course, because Florida is a stand your ground state, so there is no legal duty to retreat. And frankly, in this circumstance, even if it were a duty to retreat state, you only have that duty of safe retreat as possible in the confines of a movie theater row. That would seem unlikely. And then
being
touched,
that old.
yeah.
I mean,
Hard
even
for
if you
anyone
can
to-
navigate a row just fine, navigating a row while retreating and running is a whole different story. Plus,
while
his
you're
wife
under
is still
attack,
there.
right? Because that's when the avoidance issue matters for legal purposes. It's when you're making the decision to use defensive force, not 5 minutes later you could have moved seats in the theater. That's not what avoidance means in the use of force context. And then, of course, reasonableness, that even if he had a subjective belief in the need to act in self-defense, that belief was not objectively reasonable. They really touched on all of those in the self-defense immunity hearing, and I didn't really hear that here, but maybe I was distracted by the repetitive entire row over and over and over again.
Yeah, that just was, that just didn't, it's not necessary to do that. And that's what I dislike. And the state, you expect that from a defense attorney, right? You expect the defense
Right.
attorney when they're grasping for any straw they can find
To raise that reasonable doubt.
right. We're going to try and just plant some little seed in the jury's mind that they can grab onto and hope that they do. The state, in my opinion, is always held to a higher standard and a higher duty because they're the one trying to take away liberty or life. Like they're the one who is trying to put someone in prison forever. And so they need to be the most honest. They need to be the most factual based. And remember, when they're bringing these charges, they have to have probable cause to believe that the charges are correct and that they can prove that guilt beyond a reasonable doubt at the time they bring them. So when they do that, when they say that, or when they bring the charge and they're bringing this to court, they're making a representation that by the actual facts, not by the things the jury might be able to pick up on. And that's a key distinction between the prosecution's duty and the defense's duty. And that actually really bothered me about the argument over provocation at the beginning, is if they're going to argue that the words or that the actions of Curtis Reeves are provocation when Florida law clearly says that it must be a physical act and that mere words are not enough, then but we hope that the jury misunderstands that and finds provocation. Right. Again, it's looking deceptive to me, and I hate that. It's the state's job is not to do that. Goodness.
Yeah, I mean they're trying to get a conviction by hoping they can deceive the jury on what the law is and how the facts fit into that law, and that's not justice.
No, the facts, that what they should focus on is, because they have the crazy thing is the state actually at first blush has a pretty good set of facts. He's not hit as far as we can tell. He might have been hit by a cell phone or something. Don't know, but he's not obviously hit. The guy's not grabbing him and throttling him or anything like that. He gets popcorn thrown at him and he pulls a gun out and shoots him. Shoots the guy's wife. But shooting the guy's wife's hand isn't actually good. If the wife felt the need to hold her husband back, and if I'm the defense, I'm going to bring that up. The state's charging my client with battery of the wife because she shot her hand because her hand was holding her husband back. Even she's afraid of what her husband's going to do to this old man.
That's right.
So I don't know. We'll have to see how it goes. I'm anxious
And of
to
course,
hear
the state has to disprove self-defense beyond a reasonable doubt, folks. The defense just has to maintain a reasonable doubt that this could have been self-defense and it's supposed to be an acquittal. The defense doesn't have to prove it's more likely than not self-defense.
Yeah. Okay. Squeeze Louise says, I don't understand the point of this trial. The dude was playing on his phone in the middle of a movie in a dark theater. Are we really going to pretend he didn't deserve it?
Well, you can see the prosecution is concerned about that perception of the events, right? Because it wasn't actually a dark theater yet, and the movie wasn't actually playing yet. But the prosecution clearly believes that if the jury were to believe those to be facts, it would be an acquittal every day of the week.
Yeah, and well, when you think about it, like, there was white light from his cell phone. When someone an entire row in front of you and an entire seat over opens their cell phone while the previews are on, it
It's
looks
pretty
like the frigging sun has just risen over Hiroshima or whatever. Like, oh my gosh, you can't. It's very, very bright. It's not like a little thing. It drives me crazy whenever someone does it. Usually I don't say anything because it's not during the movie yet, right? But when it happens, it is horrendously annoying.
And clearly the theater thought it was past the point at which the phone should be off because they'd put that notification up on the screen.
Right. And the interesting thing to me is how they're already framing his statements to the dead guy, right? Like they're framing him by the wife's testimony about how he sounded, which is going to come out. Well, he sounded very mean or whatever. But, up on the screen is a thing, put your cell phones away. And the guy's got his phone out blazing into the background. And the guy's like, hey, can you put your phone away? Could have been it. Like he leans forward into almost virtually into his personal space. If he leans forward and just says, hey, can you put your phone away? That's not actually menacing. That, it might be, I don't know if that's a good idea or a bad idea. I don't usually do stuff like that because I don't want to get shot or hit or anything like that. But they've characterized it as this menacing thing that he did. He leaned into his personal space. So, I'm like, I'm not. Naz N, he was texting the babysitter. No, he was not actually. That is untrue. That is an untrue statement. That was what he said he was doing. That is not what he was doing, as the evidence will show, according to the prosecution. That is not what he was doing. He was looking at a website that he went to from Facebook. And I hope everybody caught that. The prosecution is very hesitant to talk about what he was doing. I don't know. Is it confirmed what website he was on?
Yeah, they know what it was because
It's a gambling
they did the
website?
forensics on that's how the defense characterized it earlier. And of course
Here, I'm bringing it back up.
If I could just have a moment, Ms. Rosenwasser.
Sure. Uh-huh.
A moment with Ms. Rosenwasser, just going over some things to make sure we're in agreement on everything.
Okay.
the judge has a very sentimental cup on the bench there. I guess her wife got it for her.
Is that real? Are you serious?
Yeah, it says you and me.
Oh, there you go.
It's off screen now, but when they pan back to the right, you'll
Yeah,
see.
I saw it for a second.
DNA. We're going to discuss it. I'd like for the court to read it. I think it's proper coming from the court before I discuss it. May I approach?
Yes.
Can I have a copy here, Your Honor? What I've done is
Bad
Oh my
Vibe says this
God.
prosecutor is creating empathy for the defendant. No juror wants to be sitting in the defendant's seat against this
Okay.
gluttonous sombrero.
Stipulate, sure. And I have an instruction for
Oh, God.
that.
They've got to learn how to manage a microphone in a courtroom.
Here it is,
Putting that-
2.3 stipulations. When lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact, or at the moment, well, right now,
There it was.
Oh no!
Someone's got old time
same
rock and
ringtone
roll
that
for a
my
For a
husband uses
softball
from me gets
Oh.
my attention.
husband, she said.
Oh,
Okay,
that's good to
so
know.
I'm going to read that instruction, then I'll read the stipulation.
He must be the one who cuts her hair.
Mhm.
Look at the demeanor of these guys. Are these two defense attorneys brothers? Like, they're the aerodynamic crew. Oh my goodness. Delhi 8079 says, even if he theoretically could be legally justified, I don't see a jury ever deciding he was justified to shoot him. And I think it's a hard sell. It's a hard sell, but it's not impossible. And we'll have to see. The prosecution can lose this case by their conduct too. Remember, all of these people live under the state. And if the state lies enough to the jury or misrepresents enough to the jury, they can just say, you know what? F you guys, because you could do this to me. And that is something that people occasionally consider. Gates of Above says this trial finally started after 3 presidents in office. Will we get another before the trial ends? It would be really horrible in so many ways if the defendant died during the trial. You wait all this time, do all this prep, and then he just kicks off and it's over.
They come back with a guilty verdict and he gives the jury the finger and bites that cyanide capsule in the back teeth. You ain't getting me.
Caligula says, nah, Matt Smith was right in Doctor Who. Bow ties are cool. I don't like bow ties, man. Very rare.
Yeah, I mean,
Gates
this may well be a trial that it's less a case of the defense winning it than it is of the state losing it.
Yeah. Gates of Above says, yes, I don't like how the prosecution started is suspect, but at the same time, one of the defense attorneys has a bow tie. So who do I side with? The bow tie is a heavy distrust. I agree. 100%. I am with this argument. I do not like, why are you wearing a bow tie? I don't trust you. Elena Stansby says, this case is crazy as hell. Love the UK, Great Britain. P.S. Thanks, Andrew, for the statutory law.
That was yesterday's show. I did.
Oh, okay, cool.
Look at the
Very
length
cool.
of that tie on the prosecution. Wait till the defense lawyer. It's almost touching the floor.
The guy with no chin, that
The
one?
guy with no chin. Yeah.
Okay. Gosh, I want that. Now I need the
When-
defense to move. I need to see how long this tie
I mean, he's
is.
going to trip on that.
Holy man, that thing keeps going.
It's almost a cod piece at that point.
I like to cover up with the tie just in case my pants fall down. Happens very often.
I left my fly down one case and it was very embarrassing.
I always I love looking at people who are standing around and like have forgotten that they're on camera. Like, just look at how their postures and their demeanors. It's interesting to me how people stand, because if you know you're on camera, like, you never want to stand like the taller prosecutor is standing right now. Like, his hands are turned out. He's got kind of an awkward sort of like lean going on. It's weird. It doesn't look natural. It doesn't matter at all, by the way. This is not like legal strategy talk here. It's me observing people on cameras when they're doing something more important. They don't remember they're on camera. It's the difference between reality and TV shows also. Like, look at how happy this guy looks. Like, this guy looks really happy. I don't get it.
He did look very happy.
He's
Oh,
just
good
sitting
Lord.
there with like
That
a
was
smile.
creepy.
I like watching this trial, man. Like, why? Who are you? Why are you there? You're up in the front row. You're clearly with somebody. It's not a good situation for anyone who's present. Beck Tech. What the hell's
That was on the TV screen in the courtroom. It must be one of the experts who prepared the video.
Oh, okay.
It was Becktech LLC.
Neil Pert says, damn it, Nick. I feel called out, lol. I stand with a lean ever since I took a chisel to the knee. No, it's not the lean. It's just the way. It's the way the guy is presenting himself. Okay, so they're previewing the video that they're going to show during their opening statement to see if the prosecution wants to object during the opening statement. Probably. Just clear that up. Because you don't want to get interrupted if you don't have to. Excuse me. Saint Chef says, I have a friend that has the worst luck in theaters. Complained about a couple and got into a fist fight. Complained about a lady on her phone and got called a binger. Got free tickets both times and can't wait for the next movie. Binger, I don't know if you know, binger is the substitute for the N-word.
Yeah. Okay.
Mad8 says, Friday was fun, brother. Don't forget to get yourself some Crown XR on your next liquor run. Oh, hey, man. How's it going? I'll try and find some. I haven't seen it around. I bought a 21-year Bushmills yesterday. That I think I'll be having some tonight. Tonight, I think we're gonna do. Tonight, I'll talk about my trip to Dallas. We'll do a whiskey review of the 21-year Bushmills, and we'll talk about some other stuff, some Canadian truckers and all of the crazy antics that are going on with that. And who knows what else? Oh, yes. We're definitely going to talk about the Maricopa judge who is sending memes, calling attorneys fat. Oh, my gosh. It's great. It's my favorite story.
That'll be a fun show. I just took a look at some of those and they're pretty over the top.
Did you saw the over the top one with the fat person like way up on the ladder or whatever? The best is like the interviewer from ABC News or whatever, like pretending not to find any of the memes funny while he's interviewing the person. Oh God, it's great. Lancelot 652 says, Nick, I like to watch people when they don't know. That's called stalking, Nick. Look, what they don't know won't hurt them much. Oh, goodness gracious. Oh, look at this. Look at this art house shot they have. One man. Or no, wait. Two men, one chin. In a battle of the ages. Will prosecutor Gary McConnell be able to bury Curtis Reeves? They need to switch the focus on the prosecutor like a couple times. They need to do that. Oh my goodness. Two lawyers, one cup. No. Fish says Sword and Scale is a chameleon. He's anti-Second Amendment and anti-self-defense. He deleted his episodes prior to 56 where he berates this defendant and a homeowner who shot two home invaders who had broken into his home many times before. Look, that homeowner, I know exactly who you're talking about. The homeowner who shot the two people breaking into his home. I'm guessing you're talking about the one from Minnesota. That guy did everything wrong in that situation. Everything wrong. And I
mean, that was such a crazy case. He put out bait. He put out like breadcrumbs leading down into the basement for them to follow. He set up basically a hunting blind for himself in his basement, an easy chair, a refrigerator, bottles of water, and recording equipment so he could record himself shooting them. Then after he shot them and they fell down the stairs into the basement, he executed them with a shot to the head. That's not going to look like self-defense or home defense to anybody, folks.
And he recorded himself saying like, sort of taunting them as they were about to die. And should they have broken into his house? Absolutely not. Would he have been justified shooting them in certain circumstances? Yes. He set it up. He premeditated the killings that were going to occur. Like you don't get to do that. It's weird because they should not be breaking into your house, and you can be justified in shooting someone if they put you in danger, but you're not automatically in danger in Minnesota if someone breaks into your house. You still have to have reasonable fear of imminent death or bodily injury in your home. That guy basically set himself up to go to prison forever. It was a very bad choice. All of his choices, especially like the crazy mutterings he was doing while waiting. That those recordings, in my opinion, really sunk his case because he sounds horrifying on those recordings. He sounds
he shot him in the head after they were no longer a threat to him. I mean, he executed them.
Yeah. It's he did everything wrong in that case. He didn't make them break in. No, he did not make them break in, but what he did to set the breadcrumbs was he believed that someone would break in if he was gone. So he drove his car down the road and parked it in front of a police officer's house. I don't know why he chose a police officer, but he clearly had a reason to do that. Then he snuck back into his house through the back door so that so presumably they would not see him do that. And then he set up shop downstairs with snacks, sitting in a chair in a position where they would specifically not know that he was there. So he's removed the element of of the imminent danger aspect of it because he has intentionally set up a scenario where he would not be there and they don't make any sort of threats towards him. You can't just shoot someone who breaks into your house in Minnesota. Maybe you should be able to, but you can't. He did
when they are.
He did a whole bunch of bad stuff there. As for Sword and Scale being a chameleon, maybe he is. I don't know. Koi540 says, you often get requests for lawyer referrals. If someone made you a simple website that let people choose state, criminal, civil, etc., and directs you to lawyers, would it be useful? I want to support base lawyers that you know. We'll see. I'm working on something on the website front. I can't just have a auto referral system because there has to be like there is a theory that if I like am just directing people to different lawyers, that could be a weird, it's a weird thing. There has to be some sort of discernment or choice being made.
When you're
There needs to be a vetting process or it's just pointless. And the vetting process is not obvious. I mean, I've struggled with this for years. I get these requests
Thank you,
too.
ladies and gentlemen.
Unless I happen to know a lawyer personally
can't see
and
most of you
professionally, of
at
course
the
I can
moment.
recommend that person.
I will be
But unless I have that kind of
repositioning myself,
relationship,
when the time comes,
Yeah.
so I'll be sitting over there nearer to you. But for the moment, were all of you able to abide by my instructions during the recess? Nobody did any independent research or looked
oh my
up
God, we're
anything
going to
or
do this
talked
every
about the
time.
facts of the case? All right, very good. Then in just a moment, I believe Mr. Michaels will begin his opening statement.
Thank you, Your Honor.
Thank you.
Your Honor, I reposition myself.
You may.
It's going to go into dog pose.
Before I begin my opening statement, I'm going to request of the court, Your Honor, if you would please read the stipulation concerning the DNA evidence in this case on the cell phone case and screen.
All right. And ladies and gentlemen, when lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true are as follows. The state and the defense stipulate to the following facts. The iPhone belonging to Chad Olson, which was seized by law enforcement on January 13, 2014 from inside Theater Number 10, Cobb Theater at the Grove in Wesley Chapel, was tested by Mary Pacheco of the Florida Department of Law Enforcement Biology Unit for the presence of DNA material. The testimony of Mary Pacheco would establish the following results. 1, the DNA profile obtained from the iPhone black case Exhibit AP 13, demonstrated the presence of a mixture of at least 3 individuals. Due to the complexity of the mixture obtained from the iPhone black case, this data was not interpretable. Number 2, due to the limited nature of the DNA results obtained from the iPhone's black case screen, this data is insufficient for inclusion purposes, but may be suitable for exclusion. Number 3, due to the limited nature of the results obtained, Chad Olson can be neither included nor excluded as a contributor to the iPhone's black case screen. And number 4, Curtis Reeves is excluded as a source of the limited DNA results obtained from the iPhone's black case screen.
Well, that's clear as day.
Bring up the display, please.
By the way, absence of DNA is not evidence of anything, folks. You can
No.
touch an object and not leave DNA.
Why did I bring this up to start my opening statement? I brought this up
Oh, I like
because
this.
I want you to be able to put into context, to look at the form of the information you're getting from the prosecutor right off the bat at opening statement.
Yeah.
What the prosecutor told you is simply not true. There is
Beautiful.
no stipulation. There is no evidence that the cell phone case or the cell phone case screen had the DNA of Chad Olson on it. It's just not true. Let's look at this. It says, as the court read, DNA profile from the iPhone case. This is an iPhone case, black case that has a white cell phone in, a white iPhone. It's a case that has one of those screens that's kind of attached to the front for protection. So when they talk
Finally,
about the
black and
case,
white coming
they're
together.
talking about the outside. When they're talking about the screen, they're talking about the front of the screen that a person would kind of scroll on. And so what this says is that, number one, presence of a mixture of at least 3 individuals. Due to the complexity of the mixture obtained from the iPhone black case, data was not interpretable. So based on what they got from the case, they couldn't interpret it. They have at least 3 people on it. So is it possible that if the evidence was properly preserved, that we would see Mr. Reeves's DNA, Curtis Reeves's DNA on that case as it hit him in the head? Of course
It is
it's possible.
bizarre that Chad Olson's
We'll
DNA
never
was
know
not
because
detectable on his own
the
cell
way
phone.
that
I mean, it
this
should be
phone
all
was
over that
showed
cell phone.
Was
And
abominable.
I don't mean in a gross way, folks. Just
The sheriff's office didn't go in there and try to preserve it for any DNA evidence. They had a tech pick it up, manipulate the phone. Later on, they pull it out of a room again and try to turn it on to see whose it was, even though they knew who it was, who it belonged to. Due to the limited nature of DNA results obtained from the iPhone's black case screen, the front of it, this data is insufficient for inclusion purposes, but may be suitable for exclusion. Again, that doesn't tell you that Chad Olson's DNA was on the phone. It tells you they can't tell you whose DNA was on the phone. Next page, please. Due to the limited nature of results obtained.
nice to see the
Chad
comments are as
Olson can
classy
be
as
neither
ever.
included nor excluded as contributor to the black case screen. So what they're telling you is, not as the prosecutor told you, the evidence will show with a stipulation that, not true. That phone does not come back with Chad Olson's DNA. We know it's his phone. His wife said, "That's my husband's phone." The prosecutor and the state attorney's office and the sheriff's office, they all went in the phone. We know it's Chad Olson's phone. But there's no DNA evidence that says his DNA was on it. Says
The reason
Curtis
he's pointing
Reeves
this out
is excluded as a source
is
from the
because
screen.
the argument is that Curtis
That's all
Reeves'
it
DNA
says.
wasn't on the
So if a
phone,
phone is
therefore
going
the
through
phone
the
didn't
air,
hit him.
There are 2 sides to it. There are corners to it. The screen hits Mr. Reeves. Maybe. What if the back hits Mr. Reeves? Then certainly this isn't something that would be unusual. Not unusual. And so I bring this up to you because I think that it's important. That's only one thing.
No, nobody destroyed evidence or anything like that. It's just DNA is not always detectable, and when it is detectable,
I
it's
think
not
it's
always
important.
discernible.
That you realize what it is you're being told here. From off the bat, you're told there's DNA on the phone. The other thing you're told, and you're going to see photos of it this morning, he's all the way in the other row. Chad Olson is a whole row away from Mr. Reeves.
There it is.
Yep.
Chad Olson is a whole seat over from Mr. Reeves. You're going to see how very close they were. The theme of the prosecutor's case is that this was over popcorn. And what the prosecutor told you going in is, well, all I have to
A
prove
court reporter should give the judge the number
is-
for her hairstylist.
that someone was shot, somebody died.
She's got a
of
little
following
wave
that
going
shot,
on.
Their state of mind regarding that. That's not true. What the prosecutor has to prove, what the government has to prove, what the state of Florida has to prove in this case, beyond a reasonable doubt, that this was not justifiable. And when they talk about justifiable, the prosecutor told you, frankly, that's the law of circumstances. Under the same circumstances as Curtis Reeves, knowing what he knew. You're going to decide if it's reasonable if you were trained like Curtis Reeves. You're going to decide if it's reasonable if you're 71 years old. And although the prosecutor is telling you he walked all right, he did all this and that, you're going to hear from experts. And I'm going to talk to you a little bit more about that, about what the realities of the aging process are and what the realities of Curtis Reeves's condition was. So the framework of what you're to decide, the states that I'm going to ask you to come back, I can't ask you how to decide the case. You're the jury. You look at the evidence, and that evidence has to measure up beyond the exclusion of every reasonable doubt that Curtis Reeves did not act justifiably in protecting himself and protecting his wife who's sitting next to him. So since we're talking about Curtis Reeves and stepping to his shoes, let's think about that for a second. Number one, he's in a theater. The prosecutor's trying to make it seem, the same way they tried to make it seem about the DNA, that this theater is somehow lighted so you can see everything. A lighted movie theater with the previews on. Imagine. They're telling you, don't believe. If somebody comes up with a description in one word, don't believe. No one can tell you what to believe and what not to believe. Their job is to put on the evidence, and you believe or don't believe. You're convinced by their evidence. Not because they're putting parameters on you, they're giving you rules. Don't believe this. If you hear one word, that's not true. Listen to the testimony, which you will. Let's talk about Mr. Reeves. All right. 27-year police veteran. Served his community for 27 years, the Tampa Police Department. Highly decorated officer. None more decorated in his years there. They thought so highly of him that at one point, the powers that be with Tampa Police Department came to Curtis Reeves and said, we want you to start a SWAT team here, which he did. A responsibility he took very seriously because that responsibility, that is a responsibility with other people's lives, his men's lives. And so he became trained and he trained his men. He trained his men so that every day they could come home to their family. They can go home to their family and be safe. That's the training of the man that was in the theater with his wife. He was a superstar. And when he was there, he did everything from patrol as a young man to homicide detective and everything in between. So he saw what it was like out there. He knows about danger. He knows what a fist can do to somebody as a young person or an old person. And by the way, the state's telling you, well, he's preventing great bodily harm. You're going to get a definition of that. That means something more than a bruise. It's not a bruise. That's what the judge is going to tell you.
It's a little bit
That's the
farther
law.
than that, I would think.
After 27 years, the Tampa Police Department,
Well, also, it doesn't have to actually have happened.
Curtis
It
Reeves
has
was
to be
Right.
the imminent threat of that harm.
he retires from the police department. He
You don't need to have suffered a
gets
scratch
succeeded by
to be
Bush
justified in
Entertainment.
acting in
becomes
self-defense,
their head of security.
even deadly force self-defense.
Now he's kind of in a a job where he's dealing with the entertainment industry, the pleasure of the experience in the park industry, and he receives training for that. And you're going to see, we're going to talk about it in a little bit, some of the various courses he took. You're going to see a list of courses, and we'll talk about some of them.
How popcorn can kill. Fists of legend.
So throughout his years,
Tall men and the dangers of
he
tall
certainly
men.
learned how to assess a risk. He certainly knows how to spot danger. And so when he's in that theater, it's no different. That's his training and experience. That's something that you must consider before you make a decision, whether it was reasonable or not.
What movie were they at? It was the premiere of
And is this
Gone
over
with the
popcorn?
Wind. That's how long it's taken this trial to come
It is
to.
not. I'm going to show you some videos, and you're going to see that
It was a Chaplin movie.
tries to paint this picture. They said Mr. Reeves is trying to paint the picture. By the way, he's a law officer. He should have known better. When he got arrested, he talked to them and he knew the words to use. Well, if he's a law enforcement officer, he also knows he has a Fifth Amendment right not to speak to the police. And he could remain silent and call his lawyer right away, but he didn't.
Well, he called you pretty quick.
So
you were his
talk about,
lawyer. The other
the
defense
fact
lawyer was
that,
his lawyer the next
symbol
day.
is here and they're saying it's over popcorn. You're going to see there was an attack before the popcorn was thrown. I'm going to show it to you. It wasn't just one attack, and it wasn't just popcorn being thrown. Put yourself in Mr. Reeves' seat. This is kind of a very unique situation in criminal law, because as jurors, you have to kind of put yourself in his shoes.
But see, notice what he's doing. He's doing what we
After
were
working
talking
at
about
Busch Gardens,
before.
his body starts to break down. a
They're
little more,
misrepresenting all of this to you.
continuing to break down, and he retired. Just couldn't do the job.
You
Age
can't
caught
trust
up.
them. They're big, fat, lying liars.
And so he's off to retirement with his wife. Back in 2014, they were married for 47 years, his wife Vivian. They have 2 children, which you're going to hear from. Matthew, who is a police officer with Tampa, following in his father's footsteps. Jennifer Shaw, she's the daughter of Curtis and Vivian Reeves, and she has
She's
child.
called Jennifer
They have a
Shaw, huh? She
grandchild.
was getting divorced at the time of the
Curtis and Vivian
self-defense
Reeves
immunity
settled
hearing.
into retirement. They built a big house because they're hoping for a lot of grandchildren. They want to have room to entertain. And they decide to go to a movie on January the 13th, 2014. As you know, Lone Survivor. As he walks in, let's think about this 71-year-old man. The prosecutor's saying, well, he's 130 yards of football in the third away, football field in the third, I guess not counting the end zones, football field in a third away, and he walks there just fine. Doesn't use a cane, doesn't use a walker. You're going to hear from several witnesses. They're going to tell you about his physical condition. You're going to hear from Matthew, his son. Matthew's going to tell you about his father, a robust, vigorous man, as he sees them over the years being able to do less and less. Can't leather work, can't do woodworking, has trouble with his hands. They went on a hunting trip right before the movie, and Curtis Reeves couldn't pull back the compound bow. They were looking to getting him across.
Can't leather work,
So
can't
he's-
woodwork.
he's
Am
seen
I
his
getting
father
old?
deteriorate over the years. He knows that his father calls him up, Matt, I need the leaves taken off of the patio screen in the back. Jennifer, his daughter, is likewise going to testify how she's seen her father over the years deteriorate. She's seen him at one point, again, outdoors, going hunting, going fishing, camping, to a point where he can't take apart the paddles for a kayak. To the point where when he's on the floor playing with her daughter, with his granddaughter, he can't get up without help. Vivian Reeves is going to testify too. Now, she has her own health problems. She probably has elements that are very serious. In fact, I know she has ailments that are very serious. She's going to tell you about them. She's being treated at Moffitt at the time. She had a knee replacement. Not in the greatest of shape. At any rate, she's going to tell you how she's seen the changes in her husband as well. How he needs to push himself off of the chair to get up when they're watching television. A little thing to some of us, Very important in this case. In fact, she's going to tell you that the day they were in the movie theater, the shoes that he was wearing, that Curtis Reeves was wearing, you didn't have to tie him with your hands because he had problems tying his own shoes. That little thing you pull, like you put on a preschooler, so they can tie their own shoes. You're going to hear from Dr. Donna Cohen. She's a PhD. She's a leading authority in the field of aging and the process of aging. She headed up the aging studies in University of South Florida. In fact, she started it. She's been doing it for over 50 years. She's an educator. She's going to testify as an expert. She's going to testify as an expert in the field of aging, the process of aging, and how it affects one's
I
vulnerability.
hope she's young because it'd be funnier.
Because we can all think, well, he's walking all right, but really what's going on in his head? Police training, realization of vulnerability. It's important.
Take notes, Nick. Oh,
We take
thanks.
for granted what we know about getting older. She's
Man,
going to
I know
tell
all
you
about it. Oh my
scientifically,
God.
as an educator, how that works and why that works. You're going to hear from Dr. Michael Foley. He's a radiologist, a preeminent, nationally known radiologist. Why? Because the prosecutor's telling you, look at him, he can walk. You're going to see his x-rays and his MRI. And that radiologist is going to tell you about all the degenerative processes, the breaking down of his body that you can see on the x-ray. So he looks all right on the inside, on the outside, but not so good on the inside. He's got problems with his neck, his back, his shoulders, his hands, his hips, osteoporosis in his hips, all the way down. And so what does that do to an individual? Makes them more vulnerable. Also, it makes them more vulnerable to serious injury. So in that regard, you're going to hear from Dr. Bernard Adams. He's a pathologist. He used to be the medical examiner for Hillsborough County for 20 years, and now he's a pathologist.
This is going to be a
on his
long
own.
trial.
He's going to testify
Yep.
as an expert.
Mm.
The interesting thing about Dr. Adams, what he's going to do
I don't think
is
I'm
a
going
lot
to
of
make it to
early
the end.
he's going to
mornings.
show you on a model the most vulnerable part.
Ooh, what's the
starting
model's
off
name?
with the most vulnerable part of a human body is the head. So he's going to show you why it's vulnerable. He's going to tell you about older people. As you age, your brain shrinks, leaves more room in the skull, which makes you more prone to injury if you were to get a blow in the head.
Old
to the
people
head.
are dumb confirmed.
He's going to show you the changes in the bone structure of the neck, of the rib cage, that again make an older person, a person as they age, more vulnerable to serious bodily injury, to great bodily
The
harm.
jury's going to feel themselves getting more age
gonna
frail
talk
as this
about the
trial
person's
proceeds.
The anatomy of it, how when you close your hand, it forms these points, your knuckles, and that becomes a dangerous weapon. You heard a little bit about what Curtis Reeves said. He got hit. He did. He has a red mark on his eye. The prosecutors tell you somehow magically the phone flew around, this and that. Well, if it was so well lighted, you can see it on the video. Why didn't everybody else see that happening? Why didn't everybody else see the popcorn grab? Because it was a dark theater. And the video, by the way, since I'm here, we're going to talk a little bit about the video. That system is not very good. It captures, it's infrared, it's motion detecting of a sort. So you're not going to see a clear video. In fact, our expert, Bruce Koenig, who again is a nationally renowned expert, he worked on the Monica Lewinsky case. They actually had him look over the JFK tapes again. He worked for the FBI, headed up their audio and visual department. He's still out there testifying as an expert. He will tell you about the resolution, how bad it is. I don't have it in front of me, so I don't want to give you the wrong numbers, but the numbers compared to what the iPhone was at the time. The iPhone had like 600 pixels, and this had like
600 pixels.
maybe 12,000, something crazy. So you're going to see, you get a little piece of it today, a video that doesn't.
I'm not going
really
to misrepresent the numbers. Immediately misrepresents the numbers.
Hope that it showed you. Let's talk about the facts of the case. You heard the prosecutor.
Oh, please talk about facts of the case.
Mr. and Mrs. Reeves.
Stop telling me about this
Retired couple,
18-week trial you're planning.
71. She's 69.
I'm going to go to Texas for a week,
They go to
come
the
back.
theater
This thing's still going to be
watch a
going
movie,
on.
matinee. To watch a movie, to get the experience of a movie, to immerse yourself in the movie, to sit in your seats, a comfortable seat, have quiet around you, and be able to enjoy the experience of watching a movie in a movie theater.
With your $100 popcorn.
The plan is to meet their son, Matthew, there, the Tampa Police Department police officer. He's washing his truck, so he's a little late. He's good.
Isn't it a felony larceny to
You walk
steal
in.
someone's popcorn these days?
The prosecutor told you it's true. That's true. He paid for his ticket. He walked in. They got a cold drink and a popcorn, which they share. Miss Vivian Reeves brings a little plastic baggie. Curtis Reeves gives her half the popcorn so they can each have their own. And they walk into the theater. Before they walk into the theater, Mrs. Reeves goes to.
By the way, the theater was posted, no guns.
That's true. It is Theater 10.
But under Florida law,
theater,
that's not a criminal
they're
act
looking for
to
5
disregard
seats
that
to
sign.
get Wi-Fi.
At worst, you're committing a
Because they
civil
wanna put
trespass.
Their son.
Usually
together
only
with
after notice, right?
Mom and dad, and have 2
You know,
seats, one on either side.
I mean,
So they
if this
look-
was a law school
they
class, I'd
five
say you're
seats
actually
together.
committing the trespass
Very back row.
inherently because you're
Very
there
back row.
contrary to the conditions for
told
being there.
it's-
You're not there by
we know
license
that
anymore.
what's
But nothing
called
ever
a speed
happens
issue.
until you're notified as a practical
There's a
matter.
Wall, it's about
Right.
5 feet.
They always
tall.
ask you to leave first.
Prosecutor told you
That's the
about that.
first step.
Interesting fact about that wall is the chairs in the theater.
So you don't end up getting trespassed until you've gotten the notice, just as a
recline
practical
back
matter.
slightly. Not, you can't lay down, but they recline back. With that wall behind the seat, you're not going to get as much movement on them. So Mr. Reeves sat there. Curtis Reeves, his wife, directly in front of Curtis Reeves. Already there is Nicole Olson.
So he chose the
Directly in
seat
front
because
of
the
Vivian
seat
Reeves
won't
is Chad Olson.
recline at all. So it's easier for him to get
Now,
up
the
because he's
prosecutor telling you
old.
it's a whole
He's
row
conscious
away.
of his
You'll see
oldness,
how
is what he
close
just
those
told
seats
the
are.
jury.
They sit down to enjoy the movie. Curtis Reeves notices the phone is on. Yeah, he's not talking, but there's a white light. Prosecutor, there's a white light coming from the phone. We know he was on the phone. We know he was on Facebook. Doesn't matter if he was talking or not. There's a white light coming from the phone, and it's in Curtis Reeves' face. He asks him politely, "Would you please put the phone away?" The answer he gets is, "I was texting my effing daughter. Do you mind?" Something to that effect. Again, put yourself in the theater. You're retired. You're with your wife who's retired. You're there to have a movie experience. You ask somebody to put their phone away, and the response isn't bug off. It's none of your business. It's F off. I'm texting my daughter.
By the way, Olson's wife did sue the theater in part because they did not
And it
adequately
continues.
enforce their
It
no gun
continues.
policy.
Finally, Mr. Reeves does
Did she win?
I don't know. I'd have to check.
the right thing. He gets up. He's going to tell the manager. At this point, there is no thought that this person is going to turn into some hostile force, which happens later. At this point, it's just a loud guy who's cussing and ruining everybody's movie experience, including mine.
Yours? You were there?
Curtis Reeves walks down the aisle. Some people are saying he mumbled. They'll tell you, I don't know if he was telling his wife, "I'll be right back." They don't know what he was saying. Some people don't hear the mumbling. Certainly, he didn't kick anybody. He didn't hit anybody. You'll see the video for yourself. In fact, when I finish, I'm going to show you that part of the video. You hear from the prosecutor how he can just walk down the aisle. It's not a problem. It's really close. Watch the video. This is what you're going to see. I guarantee this is what you're going to see. As Curtis Reeves walks down the aisle, he has his hand up and he's touching the wall for balance. You'll see him do it. He goes out to the desk, the service desk. Manager's there, a fellow named Thomas Peck. He's talking to this woman, Dawn Michelle Simpson. If the prosecutor doesn't call her, we will. She's there talking to the manager, telling him that she wants some movie posters to decorate her house or TV room, some sort of thing like that. Mr. Reeves just waits. He doesn't interrupt her. He's not rude, and that's a testimony you can hear. You can hear the testimony from Dawn Michelle Simpson. You're going to hear the testimony from Thomas Peck that Mr. Reeves was polite and acted very nicely to please.
The
Help
theater
me
employee was
enjoy
also
this movie
sued by
experience I came for.
the wife.
Those aren't the
I
words.
wonder if that
but
might
you
affect
get
their
the idea.
testimony.
Mr. Reeves walks back into the theater. And I understand what the prosecutor's saying. The prosecutor's saying, well, he says in his statement that he initiated contact.
Amazing to think
about
those
that
lawsuits
statement.
could have been resolved and gone to the
Here you
Supreme
have
Court by
somebody
now.
Yeah.
Who at this point is a suspect in committing a crime, not because it's a whodunit, as the prosecutor rightfully said. It should have been because the detective should have been thinking, was this a justifiable use of force? Never entered his mind. So they have Curtis Reeves sitting there, and they don't ask him these questions. They don't go back and re-interview him. So it's all right for witnesses that are going to be pro-government or say something that the state wants them to say, and you to believe them.
I would object to that. That's argumentative. It's not appropriate for us.
All right, I'll sustain, move on.
The evidence will show that the state will present some witnesses that say things that's favorable to their side of the case. The evidence will show, and I
Brilliantly
know,
reframed it.
because I just heard the opening statement of the prosecutor, that the prosecutor's argument is going to be that Mr. Reeves just made this statement during his interview, his voluntary interview. So you're supposed to believe one, it's what they're telling you, and then somehow not question the other, think maybe there should be more details to the other. Maybe the detective should have gotten back to Mr. Reeves and spoken to him. He was willing to do it. So what happens when Mr. Reeves gets back in, as he's coming to his seat, Chad Olson turns around and says, I see you turn me in. Words to that effect. Mr. Reeves at this point, seeing that Chad Olson put his phone away, leaned forward and told him, I'm sorry, if I knew you put your phone away, I wouldn't have gone to management. You're going to hear from Nicole Olson. She's going to tell you that from the first time Mr. Reeves asked Chad Olson to put his phone away, they took it as a bossy way to ask. Why is that important? That's important because Chad Olson gets annoyed. He was annoyed. That's what you're going to hear. That's
Avoid
gonna be
the annoyed,
description.
y'all.
Annoyed when
That's
Curtis
a
Reeves asked him to
throwback.
put away his
Hey,
phone.
what's good for the goose is good for the gander. If the
But he's just got
prosecution's going to
annoyed
say,
right
hey,
now.
you
He
should
stays
infer
annoyed.
that the defendant
Think
was
of it.
annoyed and acted
He's
out of
stewing.
anger, the defense can
Like a pressure
argue
cooker,
Chad
really.
Olson was annoyed and he
Because
was
when
acting
Mr.
out of
Reeves
anger.
gets back,
Maybe a little juiced
still
from his
annoyed.
trip to the bar before the theater.
Mr. Olson gets up. He turns around. This is a movie theater. He turns around in his seat and leans over his seat. Other witnesses are going to tell you that. You're going to hear from Angela Hamilton, who's the wife of the off-duty Sumter deputy. She's going to tell you she saw him lean. The deputy's going to tell you that too. You're also going to hear from Joanna Turner. Again, if the state doesn't call her, we will. She's going to tell you she sees a throwing motion. And I'm going to show you this morning that part of the video. So you can see that there's a throwing motion. There's a throwing motion. And then about 10 seconds later, this is still going on. Nicole Olson is trying to hold her husband back. I mean, think about this. You're going to see Nicole Olson. Her left hand was on Chad Olson's chest. My arms are long. Hers are not. You'll be able to see it. The evidence will show that her arms are short. And so we can only imagine that Chad Olson had to be on top of her right? She's in her chair, coming over towards Curtis Reeves. Again, I'm going to show you some video this morning. You're going to see that. So this isn't about popcorn. And how do we know that? We know that because we're going to present a use of force expert, Roy Bedard, an expert that testified for the state. In fact, this very office not too long ago, this prosecutor's office. And he's going to tell you that it's impossible that Curtis Reeves discharges firearm in response to popcorn. The times just don't add up. It happens so quickly that nobody humanly possible could have fired in response to throwing popcorn.
That's what I said before the whole thing.
Prosecutor told you, well, you're going to hear that somebody said, throw popcorn at me, will you? You know what Nicole Olson's going to tell you today? After the shooting, Curtis Reeves didn't say anything. So who knows if this is some kind of faulty shared recollection? And let's talk about that. Prosecutor's right. They had over, Pasco County Sheriff's Office had over.
So Roy Bedard, the
I
use
would
of force
say 80,
expert,
90
was the
officers.
state's expert
Everything
in
from
the
small
Michael
resource
Draca
officers,
trial. That's the handicap
agricultural
parking spot
officers.
trial.
They had officers from departments I frankly had never heard of. They were all there. Yet we're supposed to believe that they were all there, but somehow they didn't hand the witness statements. Witness statements are essentially the police go there and they say, here, I'm going to give you a witness statement. Write down, tell me what happened. Something to that effect. Very general. What they're supposed to do is if two people are together, they say, okay, I want you separated. You go over here, you go over there, because I don't want the witness statements contaminated. Officer after officer will get up there and tell you that. Our expert in crime reconstruction will tell you the same thing, Michael Knox. He'll say it's rule number one, learn it in the academy. As a rookie, you know to separate people. So you have 90 police officers, 70, 50, whatever the number is. There aren't just two. And they let everybody congregate and they let everybody fill out things together. Two of the forms that were filled out by a couple were the exact same. The wife filled them out for both of them. So if somebody says, well, he said throw popcorn at me, is that something that you can really believe?
He told the jury he wasn't going to do that. Needs to be very careful. If you tell the jury, I'm not going to tell you what to believe, and then you start telling them what to believe, you start to lose your trust.
So Mr. Reeves turns after speaking to the manager. Things happen really fast after that. Cole Olson will tell you it happened fast. It happened fast. I'm not sure if I was standing up or sitting down. I think I was trying to get up. That's happening fast for Curtis Reeves, and for your consideration, that's happening fast for you. Again, Nicole describes her husband and his words as agitated, as mad, as angry.
Get mad.
Other people in the theater will say the same thing. In fact, today I think you're probably going to hear from Hamilton, Mrs. Hamilton, Angela, who is the wife of the police officer who was there off duty, and you're going to hear from her that he sounded agitated. Other witnesses are going to tell you the same thing. One witness, I think his name is Alan Wolf, is going to say, I thought from what I heard, and I only heard one of them, from what I heard, I thought a fight was going to happen. He said he only heard from one of them. Nicole Olson will tell you that her husband was the louder of the two. She was right there. Curtis Reeves has a gun in the movie theater. Well, guess what? Curtis Reeves has the right to carry that gun. In fact, under the Law Enforcement Officer Safety Act, enacted by the United States Congress, Not only does he have a right to carry a gun, he's encouraged to carry a gun. Why? He's encouraged to carry a gun because if you're a police officer, you might not remember some bad guy that you put in prison, but guess what? That bad guy remembers you.
Well, encourage is a
So
strong
you're
word.
encouraged as retired law enforcement.
It's kind of a pain in the ass, actually.
The off-duty police officer in Sumter, he had his gun with him too. Didn't have it on him. His wife had it in her purse. She didn't have a license, but at any rate, he did have it with him in some fashion. So he had a right to carry a gun. He was encouraged by law to carry that gun, Curtis Reeves was. After the shooting, what did Curtis Reeves do? Took the gun, put it on his lap, on his knee.
And he
That's
said,
where it was
somebody else
retrieved
try me.
by the off-duty officer. In the meantime, people see Curtis rubbing his head, adjusting his glasses. You're going to hear various accounts of that. Please come in, handcuff him, take him out. Meantime, Curtis is concerned. He's concerned that somebody's going to get hurt. He knows that when these sort of calls come out to law enforcement, when they hear there's a shooting in the theater, they're coming in, I guess, hot would be a term. They're coming in thinking something might be happening here. And so he's concerned for his wife to move over. His son comes and gets his wife and takes her out of there. And she is interviewed, Vivian Reeves. When police interviewed the off-duty Sumter, they interviewed the wife with the husband present. Not the best technique. I'm sure it was for human purposes, but it just doesn't help the investigation. Let's talk about a little bit about the investigation. Number one, you already know that these individuals just given these slips to fill out and willy-nilly just let go. They weren't separated until a while later. That's not good.
Willy-nilly.
The detective who arrested Mr. Reeves, he arrested him before he went into the theater. Before he went into the theater.
Wait, what?
Here's something else. There's a video. We all know it. We've talked about the video. Guess what? That detective didn't even go to look.
If Reeves
at
is
the
smart,
video.
he'll find a way to fall in the
That's-
courtroom during the trial and break his other hip.
Police work 101.
Get another 8 years delay.
Chad
I'm gonna
pushed
go
me
ask the
from
guy behind
beyond.
the desk, is there a video? Shooting in a movie theater. Maybe consider whether it's justifiable use of force. Let me see what I can see on this thing. Doesn't look at the video. What happens to the video? That's interesting. What happens to that video is in the middle of the night, corporate. The owners of the Cobb Theater send somebody at the middle of the night to take those hard drives away to Alabama. And when the Pasco County Sheriff's Office finally realizes that this is probably something they should have and look at, days later, they go to where? Corporate? No. They go to a lawyer's office in Alabama to pick up these hard drives. And then guess what happens to the equipment? It gets dismantled. And why is that important? Because there's going to be an issue in this case regarding, you're going to see in these videos, as crummy as there are, there's something that looks like a light. It happens about the time when Curtis Reeves got hit by a cell phone, got punched, something happened. We know for sure that the cell phone was found between Curtis Reeves's feet. That we know for sure. We have a photograph of that, and everybody agrees with that. So how did it get there? Well, the video seems to show that, but it's not really clear. And so what we did is we got Michael Knox, went to the theater at 2 a.m. We tried to recreate it. The problem was that we brought the shoes to see if we could do something with that. The problem was that the whole system had been dismantled. So we couldn't conduct any sort of investigation to be able to either rule out or rule in what that reflection was. Curtis Reeves did have a reflection on his shoe. You're going to see that. We know he does. You're going to see it flat. It looks like it pops up on the screen. There are all kinds of weird little white spots and all of that. Like I said, it's not the finest of videos. But even if it is his foot, then is that he crosses his leg? Because by the way, this is very important, and I almost forgot it. When Curtis Reeves comes back from speaking to the manager, he comes in, reaches down, gets his popcorn from his wife, Vivian, puts it in his left hand, and crosses his legs. So is that somebody that's really engaging somebody again? Is that somebody that's saying, ha ha? Is that somebody that's there to rub it in? Or is that somebody there that's just trying to enjoy the movie and apologize and say sorry? Because that's what happens. You can see that on the video.
So we'll actually start getting into the case in chief today. That'll be good. Depends. He could have a 6-week opening statement. I mean, that's possible. It's getting a little long now. It's some long tangents about the evidence stuff, which
The state told you there's
Almost
a lot of
time for
witnesses.
lunch.
You may not call some. There's some crucial witnesses, some vital witnesses you need to hear from. If they don't call them, we will. You'll hear from them because you need to hear from them.
you're going to
Now
hear
let's-
from him.
Let's look at some of these visual aids I have to kind of illustrate what I've been talking to you, if we can, Your Honor. Thank you.
Lancelot says that's going to make the jury feel good. Quote, as you sit in this slow trial, we will put you through. You're aging and getting weaker. You're welcome. Can you feel your back start to hurt? Can you feel your legs and your hips start to hurt as you sit in these chairs uncomfortably? This is what Curtis Reeves feels every minute of the day. Gates of Above says, I'm a little beyond, but oh my, a little behind, but oh my God, this defense opening indicating how long this trial
These are
is
some of the-
by these witnesses. Can the jury
certificates
do
of
something to
training
push the
Mr.
trial out for
Reeves,
another 8
collected
years?
over as many years. 328 hours of training in the police academy, 328 hours. Florida Institute for Law Enforcement certificate. Department of the Army certificate of training for the Tampa Police Department. State of Florida Police Standard certificate of recognition.
Oh, look, it's a touch screen thing.
FBI certificate of attendance, Special Tactical Firearms School. Survival tactics. Next page, please.
Why
Tampa Police Academy, advanced training, inspector techniques, so that he can train his men, so that he can ensure their safety, so they can come home to their family.
well, inspector techniques isn't really
FBI training school,
safety.
effective communication.
See this, I don't like this. I don't, and I know he's trying to just give him some
Commission
nice
on Criminal
credibility
Justice
and. But why are we doing this? Why
Now,
are we doing
he
this
should
here?
just to
Department of
summarize
Justice,
this
administrative,
and for the
it's
purposes of
training.
the
It's not just
opening.
local.
Just say, you know,
Yeah.
he's got
State,
10,000 hours of
federal,
training in
Next page,
55
please.
different courses over his 27-year career. We'll talk about those when he's on the witness stand.
These
Yeah.
are some of the training he received when he was with Bush Entertainment. Because now, although you're applying the principles
Bush Entertainment, did he
of
do
your
9/11?
law enforcement training of 27 years, and you're training people in law enforcement
Sounds like a,
of 27 years, you're
strip
looking at
joint.
it from the perspective of the enjoyment of an
In the
experience
70s,
like
maybe.
being in the movie. Right? Okay.
In the winter months.
Number 2,
It's
please.
seasonal.
Ready? All right. Let's see inside the movie theater. The cameras are somewhere back here, up here high. I think they're 30 feet up. And they are facing down, but they capture the first few rows. Mr. Curtis Reeves and Vivian Reeves are somewhere around here.
If only they'd paid for the deluxe seats in the back.
Cole Olsen, Mr. and Mrs. Olsen.
They saved that
Here,
$12.50.
You have Mr. and Mrs. Reeves are in these 2 seats here. You have the Hamiltons you're going to hear about. They're out here. And the Turners I talked to you about, they're over here on the same row. And by the way, Angela Hamilton, even though she was 7 to 9 seats away, still could hear Chad Olson's voice over the previews. So the prosecutor is telling you, number one, they're a whole row away. They're a whole seat away. As if to create the illusion that they are an ocean apart, or at least very far apart. Not true. Line 3. Ready?
Thanks.
It's that stipulation the state told you about, an agreement that Chad was not texting his effing daughter, as he said, but instead downloading images, content associated with Facebook, link to Facebook, profootballmock.com. A missed call around that time. So
He was a busy beaver.
it wasn't true what Chad Olson said. Is that part of just being angry?
Searched how to kill with popcorn. Thank you, Adam. That was good.
Ready?
Oh my gosh.
Ready? All right. Before we
See,
start again.
his
Before
opening
we
got
watch this video,
was
let me
started
tell you
off
a little
good.
bit
It's
about
gotten
it.
really
There's
clunky.
Several
Yeah.
cameras. This camera that you're looking at here,
I'm like
is
really
kind of the
bored and
front as you're
distracted.
walking into the area where the theaters are, past the concession stands, and all of that. There's another camera at the
And I'm
front
getting
desk where
paid
you
more than the
actually
jury
pay.
is.
Those are in color. What you're going to see in the theater is not this. And that's just because the difference in lighting and the difference in cameras. The other thing you're going to see when we get to the part inside the theater, there are going to be several black frames. What happens is with these surveillance type of videos, and our expert, Bruce Koenig, the FBI, former head of the FBI audio visual department I talked to you about, is going to tell you how that works. The way it works is when you watch a surveillance video, like a home surveillance video, in this case, it's in a theater, you look at it, it appears that something is constantly happening. What happens in these motion activated videos is that when the recorder actually stops recording so that it's more pleasing to the eye, it'll continue the same images, same image until something else happens. What these videos do is take away the images where the camera is not recording. And so what you're going to see, there are going to be large gaps because that's what the camera was actually recording at the time. Go ahead, Matt. Mr. Reeves, Mrs. Reeves. Okay.
I mean, this is getting almost as bad as when your wife tries to tell you a story about what happened at work that
Walking
day.
into the theater, you can see they're taking their seats along the back row. This is the Sino Bistro area we talked about over here. There are two cameras you can see. One obviously is recording from this side. The other one is recording from over here somewhere, and that's this what's called.
Too bad we don't have
camera 12
Chad's
recording.
camera recording the
This black
interaction.
screen here, this is what I talked to you about. So what's interesting about this is you would think that if one camera is sensing action, is sensing movement, that both cameras would. But as you can see, that's not the case. And how they work exactly, no one knows. They took the cameras, the hardware, they took the drives, and I mean, this is what we had. And so you will see this is what you'll be seeing.
It's a
This
little
is the
shocking
timestamp
that
at
the
bottom. So you'll see
Theater company
actually
removed the
how long
cameras
things take
and all the data
to
from
happen.
them.
So Curtis Reeves, Vivian Reeves.
I think there'd
come
be a
in.
preservation letter from the state.
What is that? The answer is
Or from the wife.
don't know. Could be his popcorn. Why is it shiny? poor resolution, don't know. That's what the camera picked up. And so that's Mr. Reeves sitting down. Curtis Reeves, Vivian Reeves.
Turns out it was Curtis Reeves' cell phone that he had out the whole time. That'd be
13,
great.
14, 47. They go down until the
Camera away.
Thousands
Got
of
mine
seconds.
out.
Okay, let's go forward a little bit, please.
You're messing with my illegal recording of this movie.
Sit down.
Yeah, this is just bad work by the defense. This is a morass at this point.
Yep. It started off good. This is a waste of time.
Okay, let's move forward a little bit. We're skipping parts of it because nothing's happening. You'll be able to see the whole.
Also, it's the opening. It's not the entire trial.
This tells you obviously when the next image will be appearing for camera 12 and camera 11 respectively, I should say. Okay.
Which one will win? Bet it's on the left. I bet on the left. Yeah, I win.
Okay. Mr. Reeves leaning forward, getting up. Now this is when he's going to see the manager. All right, let's stop it, please. Go back a little bit. Mr. Funderburk.
Thanks, Mr.
Thunderbird?
Funderburk.
Right there. All right, hold on, stop.
Oh, Mr.
All right.
Funderburk, can you stop
Putting
when I
down
say
the
stop,
popcorn.
please?
Go ahead.
No. Is your name Burke? No, it's Thunder Burke.
Using the wall for his balance. That's not what the prosecutor told you. Prosecutor told you just zips down the aisle. Try to make it seem that way anyway. I know he didn't say that.
Your Honor, I haven't, this is argument. This isn't what you're going to see. He's pitting one against the other. It's not proper for opening. This is pure argument.
I'll
I
rephrase
object to
it.
it.
I'll rephrase. What the evidence will show, not what
Gotta be
was
careful.
represented to you by the prosecutor, the evidence will show that Mr. Reeves did not walk down the aisle with any ease. The evidence will show that Mr. Reeves used the wall for balance.
Jonathan
Go ahead, Mr.
007,
Funderburk.
the video has gaps because they're motion activated videos to preserve their surveillance videos that watch
He is
largely
leaving.
uninteresting activity in movie
Mr. Reeves
theaters.
going to the service desk.
Preserve a bunch of data by not recording most of the time.
Okay, let's pause it, please. All right. Thomas Peck, manager, service desk. Dawn Michelle Simpson. Those are the players. You're going to hear from them. Both of them are saying, and will say, because it's the truth, that when Mr. Reeves comes,
Your Honor,
See, this guy's damaging his credibility
Thomas
right
Peck
now.
is going to say that Mr. Reeves was calm. The evidence will show that Dawn Michelle Simpson will say the same thing. You can make up your mind to see if it's consistent, because the judge is going to tell you that you can judge the credibility of the witness to see if their statement matches up with another's. That's your decision to make. They're both going to say the same thing. Continue, please, Mr. Funderburk. Here's Mr. Reeves at the desk, waiting his turn. Waiting for Ms. Simpson to write down the movie posters she's looking for.
How are we watching this right now?
Back into theater 10.
God,
Sitting in
shows
his
just how worthless these motion
got his
activated
popcorn in
cameras
his
are.
left hand. Okay, stop there, please.
Thanks for not stopping on the image again, Funderburk.
I mean, this is awful. I guess the only saving grace is presumably the jury doesn't know how badly they're being disrespected by wasting their time like this.
What you saw very briefly on this camera is isolated because a video is just a series like a movie is of frames.
Thank you.
These are the frames that are within this video. Okay, Mr. Funderburk, if you would toggle forward, please. Okay, hold on.
It's awful because it's too drawn out to actually make an effective point. You have a narrative you want the jury to buy. This is where you're framing that narrative. You should be saying things like, we will show you A and maybe a still photo, and B and maybe a still photo, and C and maybe a still photo. And that's what will constitute justified use of deadly force in this case.
Yeah.
You don't run through all these video segments for minutes at a time. It's ridiculous.
Back in his seat, popcorn in his hand, getting ready to enjoy the movie. Explosion.
You want to describe an attractive narrative to the jury that you'll flesh out over the course of the trial. You want them to be interested, eager to see what's going to happen.
You have no way to prove it.
You bore them into a coma in your opening statement. I mean, the trial itself is going to be boring enough.
By moving things around. And so we can't prove it. Certainly.
Thank you for coming. Probably close. Thank you for coming to my TED Talk. More like a dead talk.
Oh, God.
Is that a reflection on his shoe? That's for you to decide. I can't tell
For
you
you to
what it is.
decide.
Nobody
For
can.
you to decide. For you to decide. We
But
know.
clearly-
Oh, just stop talking about it.
Clearly,
I don't understand. Don't they dry run these
evidence
things
would show
in front of, I don't
that
know,
Chad Olson-
associates or paralegals at their firm? And someone can tell them,
okay.
what are you
The
doing?
evidence will show that Chad Olson didn't just talk to Mr. Reeves and didn't just reach over the feet. Over the seat.
I would
The
expect a
evidence
better
would show
performance
this,
out of a law school moot court.
that Chad Olson at 30,
Almost guaranteed.
25, 422 came over his seat to the extent that his head and his arm appear to be in the road. They're in the road. One more time, please, Mr. Funderburk, for us.
Just one more. Are you sure? You sure you don't want to do a little bit more after that?
Okay, thank you. Let's go back to number 4, please, Mr. Funderburk.
Just all of this. Let's go back to number 4, please. I mean, this should all be just next.
Go ahead, please.
Oh,
And it shouldn't be video unless the actual motion is important. But if you could make the point with a screen capture.
Let's go to, if we could.
Here he is leaning over the seat. Here he is lunging. Here he is, whatever, standing up.
File 8.
yeah.
Go ahead. Was it over popcorn? It's your decision. The evidence will show that it happened mighty fast. It happened lightning quick.
Someone suggested he could
These
energize
individuals-
things by doing a Richards and using the N-word a few times here.
We'll put you in the place of Curtis Reeves.
Really show you that he
You'll be
came
able to
up
see what he saw.
and he called him and
Did he see somebody who announced, "I'm going to take your popcorn"? There's going to be no evidence of that. Did he know
oh my
that Chad
God.
Olson was going to take his popcorn? He's a man. He's
I just
got
don't
popcorn in
I
his
don't
lap.
understand, especially given how much time. I mean,
Prosecutor talked
it's been 8
about-
years. The
Evidence
facts has been
shows
established. The
that
law has been
Curtis Reeves
established for
invaded
8
Mr.
years. They've been
Olson's
thinking about this for 8
We've
years.
only had one
And this is the
invasion of
opening you
space
end up with.
will after a violent outbreak.
This ought to be a masterpiece.
Now we have a
This is inappropriate for opening argument.
The evidence will show that there's already been one violent outburst. And this is the second. That Mr. Funderburg? Okay. Step one.
Where's Burkowski? Where's this going?
Olson,
Chambers.
his arm coming across.
How did this get so bad?
Stop it. Again. It certainly appears to be a head and an arm.
Did he accidentally
coming across.
start doing his
You made that
closing?
decision.
Is there an objection?
Yes, Your Honor. It's one thing to say what the facts are, but he's interjecting his own personal opinions in an opening statement. It's not appropriate.
Let's stick to
I mean,
opening statements.
To be fair, you guys did that too, but I'm with you just because this guy's so boring.
Let's do it this way.
Oh, thank God.
You're Curtis Reeves, you're sitting there. You don't see someone taking your popcorn all at once. The evidence will show that you don't. Mr. Reeves will say that he didn't know there was popcorn being thrown. He didn't know there was popcorn being taken. Go ahead, Mr. Funderburg, if you would. Now look at this. Okay, stop, please. We have another motion. Right? Motion appears to be the arm.
Your Honor, again, I object. These personal interjections of his personal assessment of the video is not appropriate in opening statement.
Let's discuss this at the bench.
Every time this guy is given the prosecution an opportunity to object, he's destroying his credibility with the jury. And his opening of his argument was that the prosecution was not credible with the jury. He was not going to tell him what to think. He was not going to do what the prosecution just did. He was not going to misrepresent the facts. And now he's given them, what are we on objection 8 now?
Well, that's what makes it ridiculous. I mean, listen, if you want to try to sneak in your opinion and the other side doesn't object and the judge allows it, that's one thing. But once the other side objects and the judge sustains the objection, and you know what's going to happen next time you do it, they're going to object and the judge will sustain the objection. And the next time you do it, the same thing's going to happen. You have to stop.
Yeah.
I mean, I don't mind. I can't object to the effort. I mean, I guess give it a shot, but when it's clearly not working, you don't keep digging in the hole.
Once you find out the prosecution or your opponent, in this case, the prosecution, is not sleeping, you don't get to screw around anymore on this issue anyway. It just bothers me that if your premise is you can't trust them, you can trust me, but then you give them a whole bunch of reasons to not trust you, you've really screwed up. You're really screwing that whole dynamic up, and it's just not a good look at all. So I really,
and folks, it matters less. All this is how the jury perceives the evidence and the law. And just like with people, it doesn't really matter what it's like on the inside. It matters what they see on the outside. And this is what they're seeing on the outside. They're not really making their own independent assessment of the evidence in the law. It's how it's presented to them. They need to be offered a narrative that they can buy. And this is just it's not only not effective, it's counter-effective.
oh God.
Man, it's gotta suck to be a defendant in these circumstances. I mean, I would be sitting at that table just watching my life go away.
Yeah.
Had these lawyers for 8 years, and this is what they bring to the table when it counts, when it's game time.
You think he's taking notes? What he's actually doing is writing up the contract on his lawyer's life. I'll give $20 million. Don't know how. Oh, geez. Gates of Above says, will I find and acquire a PS5 before this trial is over? Yes. Probably 2. You'll get a PlayStation 6 before it's over. Yeah, that's something to consider. When did the PlayStation 4 come out? Holy criminy, this thing's been waiting forever. So here, Tim the Ancient says, sincere question. How can this be brought to trial 8 years after the fact? Well, he was charged right away. And so long as the delays are quote unquote reasonable, then there's effectively no real, there's no real date. And your right to a speedy trial goes away when you waive it. And a lot of defendants will waive a right to a speedy trial. Because for a lot of defendants,
They're guilty.
staying out of jail as long as possible is a good thing. And you never know what might come up also. So there's some considerations that are being made there. I have no idea what transpired that made this take 8 years.
Well, part of it was they did the self-defense immunity hearing, which was a 2-week mini trial all by itself. So that took a lot of time to prepare.
Right.
And then after that, after he was denied immunity, the Florida legislature changed the legal standard for self-defense immunity. There was the burden was shifted to the state to disprove self-defense by clear and convincing evidence. And so then they filed the motion for a new stand your ground hearing under the new standard. It was denied, so they appealed that denial up to the Florida appellate courts, and that probably took a year or two to work through that system there.
Whoa. But then there's only 7 other years to account for. No, 5 other years, either way. Yeah.
Well,
but
it's like 2 or 3 for the immunity nonsense, both the hearing and then the appeals afterwards. A couple of years for COVID, a couple of years you'd expect anyway, just prepping normally. So that gets you to what? That gets you to like 6 years right there.
yeah. Oh boy. Kyle Guerrero says, with this opening statement going so bad, if he is convicted, would he have grounds for an appeal due to incompetence? No. We always have to talk about this every trial.
And the standard's not incompetence, it's ineffective. So essentially they'd have to do something like forget to argue self-defense.
Yeah. And not forget to argue it well, forget
Right.
entirely.
Yep.
Like it would have to be absent, which is a hard thing to do because raising self-defense is really easy. And you get a lot of attempt to raise it, but just because you raise it and then argue it very poorly, no, you don't get ineffective assistance of counsel most of the time. No matter how ineffective your counsel is, the assistance they give you is effective. Okay, so the judge actually got up and left. This guy's like, what the hell's happening with my entire life right now?
So I actually just interviewed a lawyer last week who took over a case after ineffective assistance reversal of a conviction. And in that case, the ineffective assistance was a self-defense case. And the original lawyer in the first trial just didn't share with the jury photos of the defendant's injuries, which is, of course, what would justify his use of deadly defensive force.
Dude, I'll check Discord in a fucking minute. Stop. Like I saw you. You don't have to super chat and tag me 50 times just because I don't acknowledge. Look, I appreciate it, but oh my God, someone sent a video. I got it. We're watching. I'm not gonna play the video right now. Jesus. Yes, they've emailed me, they've messaged me, they've tweeted it to me, it's been DM'd to me. I've seen the fucking video. I'm gonna play it tonight. Good Christ.
Let's go back to number 6, please. You're about to see again that sequence of events that happened before this last part that you watched involving the grabbing of Aqua. Go ahead, Mr. Funderburg. Go ahead.
There's almost nothing I hate more than being asked to check DMs during a live stream. Almost nothing.
One more time, please.
Oh my God.
So, folks, just FYI, not only did self-defense immunity law change, self-defense law changed in the time between when this event happened and today. So,
repeatedly show a video. It goes beyond the scope of opening reference.
Well, the defense anticipates that this will be shown at trial. The defense anticipates that you will see this several times during trial.
I thought you just sustained the objection.
to playing the video, I guess.
Let's
Oh,
go back to
Yeah, they did. She did.
number 8.
Oh my God.
Go ahead.
I mean, if I were a law professor teaching this as a class, this is a failing grade, folks. Opening statements 101, F.
I wouldn't just give him an F. I'd give him an FU.
And throw him out the window. Breaking glass.
One more time, please. They just objected to repeatedly playing video, and now he's asking to play it twice.
Thank you. Let's go to the final image, if you would. File number 9, please. Before we get to file number 9, let me talk to you a little bit about that first attack that you saw. During that first attack, you want to know if anybody else.
But again, he's characterizing the evidence now.
Did. Joanna Turner. She's the lady that's sitting to Vivian and Curtis Reeves' right. She's there with her husband watching the movie. And what she describes is she sees Chad Olson stand up, turn around in his seat. By the way, Nicole will tell you that the seat popped up. Those are the type of seats that popped up. And you decide if that makes it easier or not for somebody to get to the person in the row behind them. Joanna Turner describes seeing Chad Olson make a throwing motion.
Will
It appeared he
describe.
had something in his hand. She thought it might have been a thermos, but it was something dark in his hand. Is number 9 ready to go, Mr. Funderburg? Yes. That's a photograph from after. Curtis Reeves, his seat. Vivian Reeves, his seat. Chad Olson's seat. Nicole Olson's seat. Chad Olson's phone.
Actually, the phone could have gotten there if it was just dropped on the seat, because the seat's elevated. It would have slid down the seat through that little opening.
That was a picture I wouldn't have shown. Not at this time. That picture, like the perspective of that picture, makes that seat look a mile away too. I think that was a bad play. He should have shown someone sitting in the seat.
Yes. Yes, I will.
Is this opening statement still going? Like, what is going?
I'm going to have to order lunch.
Like I said, if they're witnesses the state doesn't put on that they've listed, we're going to call them so that you can get the whole story. I can't tell you to vote guilty or not guilty. You're the jury.
You can actually ask them
You know
to.
what your job is. The prosecutor doesn't have to prove homicide here. They have to prove
They,
beyond a reasonable doubt
they do
that
still
it's
have to
not
prove homicide.
justifiable use of force. They have to prove beyond a reasonable doubt that Mr. Reeves, knowing what he knew, being in that circumstance,
Like, you know, if
Beyond a
they
reasonable
failed to
doubt
prove
that he
homicide because they're focused on the self-defense argument, they'd
That
make
he
a
wasn't
motion for
justified.
dismissal.
Yeah, they would.
thank you.
Oh, that was
Ladies and gentlemen,
Brutal.
we've reached a good time to take a lunch break. I'll instruct you once again to remember my instructions during the recess. Don't do any independent research. Don't discuss the facts of your case amongst yourselves or with anyone else. And don't do any independent research. During the recess, typically, I instruct you to keep your badges on. I'm going to allow you to take your handsome badges off during the break. When you're out and about, if you go out elsewhere to get lunch, should anyone be talking about the case in your presence unknowingly, if you're waiting in line for fast food or sitting at a table, or either tell them that you're on the case, that you're a juror on the case, and please don't talk about it, or move away out of earshot, and let me know what if something happened. Okay? Any questions? All right, I'm going to let you go till 1:30. Please report back to the jury pool room at that time, and remember my instructions, and we'll get started shortly thereafter. Thank you.
that'll be 12:30 Central Time. Remember, this is Eastern Time. Oh my goodness. I'm putting up a poll after opening statements, guilty or not guilty. You guys can decide. God, that was an
That was pretty
eternal
brutal.
opening statement. It was really disjointed. I feel bad for praising the start of his opening statement. I'm now mad at him. I'm now suing that attorney. He made gross misrepresentations. He represented that he was going to have a competent opening statement. He showed that to not be correct. Tall Skinny Geek says, Nick, check your smoke signals, Morse codes, maritime signal flags, and emergency launch abort sequence. Yeah, and I maybe owe C. Goody a little bit of an apology on that. But like, okay, when we're watching a trial, and this is not to C. Goody. The apology was C. Goody. It's to the people sending stuff to C. Goody. If we're watching a trial, I'm not going to play the unbreaded video in the middle of the defense's opening statement. And I'm probably not going to play the unbreaded video during the trial watch party. I maybe would play it during break. I don't know, but I've gotten like all of your DMs and emails or whatever about it. I got it. It's a very funny video. I plan on playing it on the night show, which is kind of where the unbreaded segment and all that stuff is. So like having people message me a whole bunch to check DMs, like I'm trying to be in the stream. And then when I have to go to a different thing and look at something else because someone's tagging me a whole bunch about it, it gets really, really irritating. And then it's like, this isn't even about what we're talking about. So I hate it. Thanks. I hate it. It happens all the time. People are like, check your DMs immediately. Nick, I DM'd you. Nick, I DM'd you. Great. Wonderful. If you DM me, I'll either get to it or I won't. I'm sorry. Good Lord. Anyway, so Mr. Branca, not that you haven't already shared your opinion, but any other observations about that, about the opening of either the state or the defense, or anything else? Like,
It makes me frightened for what to expect for the rest of the trial, the next 4 months of trial.
Yeah, they really presented this as, we're going to make you sit here forever.
I mean, when this started, the very first day when we looked at this, that Monday, I thought we would do jury selection in the morning and have opening statements that afternoon.
Yeah.
That's how straightforward this case seems to me. I mean, there are facts in dispute, but there's not that many facts. Instead, we had a full week of jury selection, in which we learned that there's a definite lack of clarity of thought and legal argument by everyone in this courtroom, particularly the judge. And then we start today with opening statements. And look, I mean, they're talking right now because they don't have their shit together. I mean, that's what this is.
Yeah, I mean, the amount of I said this during Rittenhouse. You typically don't object during opening statements or closing statements. You typically don't, unless something is pretty bad. It's you're allowed some argument. I mean, opening statements or opening arguments a lot of times are what they can be called. They can't be argumentative, which sounds weird, but you're allowed a lot of flexibility to kind of start framing the case. That's the whole point of the opening, is that you are framing the case. You're trying to set it up. You're trying to tell the jury what's going to happen, what perspective you have, what the theory of your case is, and why they should find your client not guilty or why they should find the defendant guilty, depending on what perspective you're from. That's the whole purpose of it. So you get this extra leeway as long as you are relatively certain that what you're showing them is something that's going to come out at trial. So it's going to be admissible. If there's a question about admissibility in the opening statement, you need to handle that at a pretrial hearing. But most of this stuff, this is the video that the state's going to show this video. We're going to show this video. So, okay. So, that's going to come in. Fine. You've got witness statements. You've done witness interviews. You know roughly what they're going to testify about. You've probably got recordings of them making those statements or some sort of declaration that they've signed, so that you know that when they get to trial, they're going to make those same statements. And if they don't, you're going to ask them why their testimony today is different from the signed statement that they gave you 6 months ago or 5 years ago, or whenever you interviewed them in this case. So what's going to come out. And you've talked about this on some of the other trials. By the time something gets to trial, almost nothing should be a surprise to any of the parties in court. Right. I mean, it'll be news to the jury. Maybe it might be new to us because we didn't know, but all this stuff should be hashed out and figured out ahead of time.
All the evidence and the legal arguments to be made should be rock solid, in concrete, by the time the jury is hearing opening statements. There should be, in a perfect trial, there's no surprises at all. Everybody knows what's going to be said, what the testimony will be, what closing argument would be. You should all know that. The only variable is how will the jury determine how to interpret those legal arguments and facts that are presented to them. That's always uncertain because juries are dangerous and unpredictable creatures. But to the lawyers and the judge involved, there should be nothing happens that's surprising.
Yeah. And so to have, imagine, if you will, that you've had 8 years.
Uh-oh.
What?
You froze there, buddy.
I did?
Yep.
Am I back now?
You are.
Oh, okay. Imagine, if you will, that you have had 8 years to get ready for this high-profile murder case. I mean, it's kind of a sleeper now because it's been so long, but this is a former police captain shooting someone in a movie theater under what appears to be kind of ridiculous circumstances. So you've got this high profile murder case, especially in the area you're in. You have 8 years to prepare, and that's the opening statement you come up with. Like, they've had this video surveillance footage the whole time. It's not like they just got it. They've had a video expert edit the footage and come up with clearer video. Apparently, they didn't play any of that. Like, why didn't they play that? Why didn't they focus on that aspect where it's blown up and you can see, say, here's what we got. Our expert's going to testify about how exactly he produced this image and why it's an accurate representation of the original image. State's going to show you the original image. They're going to show you what their expert came up with.
I
You
mean,
get
it
to
almost felt
decide.
like at the last minute, Attorney Michaels came down with COVID, couldn't make up. So they grabbed an associate from the office and said, here, just take his notes and do the opening. Like they hadn't thought it through at all.
Yeah. It's, oh gosh, it's wild. And you need to change. You need to be a little adaptable with your opening statement, but you should have some sort of framework planned out. You should have a theory of the case to present to people. Oh, Jesus. So anyway, I'm going to start. Look, guys, it's Valentine's Day. So I'm going to tell you all happy Valentine's Day. I love you, even when I yell at you. And you know what, wear that nice little lingerie number, just from me to you. Well, from you to me, frankly. But it is Valentine's Day, so I am going to go ahead and start reading the chats, and so that we can kind of keep up with them as we go, because I want to make sure we are able to get people out of here by the time this show is, or by the time the trial is over for the day. And so people aren't hanging around forever, because I presume all of you have Valentine's Day dates. And if you don't have Valentine's Day dates, well, date yourself, which is always, good stuff. Morgan Babcock says, Nick, have you seen Unbreaded? Has its own Urban Dictionary definition. I'm assuming it's a fan of yours. It's beautiful. I have not seen that. No, thank you. I'll check that. Well, again, we're going to do that, probably that stuff tonight. The Pie Baker says peanut butter on jelly chads rise up. Each slice Jack Murphy's watch from the closet. Wait, oh, I see what you're saying. No, you're a liar. Andrew, question. When you make a peanut butter and jelly sandwich, do you make peanut butter and jelly sandwiches?
From time to time.
How do you construct the sandwich? Can you walk us through the process very briefly?
I hadn't really thought about it, but I think I put jelly on one slice of bread, peanut butter on the other slice of bread, and then smash them together.
Perfect. See, chat, take it from a man who knows, Mr. Andrew Branca, how to make a peanut butter and jelly sandwich. It's done. There is no more argument. There are these disgusting people out here saying that you should put the peanut butter on and then put jelly and spread it on the peanut butter and then put a naked piece of bread on top. Doesn't make any sense. Anyway, William Mitchell, School of Law and Crime, says, as Richards, my client thought he was holding a taser, Your Honor. It's, Your Honor, we can all agree it's ridiculous to shoot somebody over some popcorn. That's why my client was just trying to tase him. That'd be great. God, I miss Mark Richards now, very much. Angry Bainling says, saw you on You Are Here. It was hilarious. I think you made Elijah a little uncomfortable with the Murphy jokes. Lol. Also, how'd your fan meet go? Pretty well. We had a couple people, hung out for a while. It was good times. Good times. Red Guy. I'll talk about my Dallas trip tonight for sure. Red Guy says, if Biden chooses to only nominate black women to the Supreme Court, does that violate the Civil Rights Act for every other of age American that can also be nominated, which would basically be all of them? No, he can choose to nominate whomever he wants for whatever reason, and Congress can choose to bring them in or not for basically whatever reason. Their political positions, their appointments, and the president is offered the full leeway to go ahead and do that. That would be a political question. If they tried to bring that to the Supreme Court, they would likely ignore the case and say, nope, it's a political question. The president and his appointments are inherent powers, and for Congress or anybody else to step on those would be an attempt to abridge their power to appoint, because Congress already has the ability to not affirm or confirm, I should say, an appointment. So no, there'd be no legal case there that I could think of. But I'm sure an enterprising lawyer somewhere will try, which would be good. And it'll be funny. Andrew War Snowboard says twitch.tv/A_War Snowboard. If you DM me during the show, I will not see it. I deleted Facebook, Twitter, Instagram, and Discord off my phone. If you need to contact me during my stream, say it in chat. Well, there you go. There's Andrew. Jesus Davila, or maybe it's Jesus Davia, sent a Woot sticker. Thank you.
By the way, a couple of weeks ago, I think I mentioned that I would send you a law of self-defense coffee mug.
Yeah.
While we were watching the trial, I got the shipping confirmation this morning.
Oh, sweet.
So you should expect
Cool.
it in a few days.
Well, I'll use it to drink whiskey and tea. Maybe at the same time, maybe separate. Who knows? Who knows? Frederick Little says, hey, Nick, question for you and Andrew. Have you ever thought about being a judge?
No.
I used to think about being a judge when I was like in law school. And then I guess maybe a little bit as a starting attorney, going, God, it'd be funny to lord over people like that. But no, not any time at all recently. I
mean, just watch this trial. Doesn't it look like a nightmare of a job?
Yes, it looks terrible. The only good thing is if you're a federal judge appointed for life, I mean,
Oh, well,
it's a
that's
little bit more
different.
fun.
Yeah.
Yeah. Cause then you could just, you could do pretty much whatever you want. It's great. Captain Spire says, watching trials like this makes me realize that even the TV courtroom drama shows handpick their courtroom audience to be visually stunning. Yes, they do. David Gomez says he looks like a somehow creepier Chris D'Elia. Daryl Conger says there's a woman who claimed he followed her to the bathroom after a phone incident in the same theater. Is that admissible? Can he claim dementia? So a woman claims that Curtis Reeves followed her into the bathroom after a phone incident in the same theater. Is that admissible? No, almost certainly not admissible. I would think that would be a prior act evidence. It would not, if you're using it to prove that he was arguing with someone else over a phone. Yeah, it's almost not going. I guess there's always a possibility a judge will let any piece of evidence in, by the way, but that's one that should probably be out.
Yeah. And that kind of testimony is always so sketchy because the case becomes high profile. People see it in the news. Some people just want attention. Some people will convince themselves that they were actually encountered by Curtis Reeves as opposed to some other cranky old man. There's no weight.
Bowtie Charlie says Judge Potato Head. Britt Cormier read that one. Knight of Knee says the prosecutor is guilty of killing his comb over. Dr. Spoon says Judge Nick would be doing Kermit voice the entire time. No, I do an Elmo voice and just ruin everybody's day, especially if it was like a horrific murder case, like talking about chopped up bodies. Nova Amp says, got my first subpoena for a jury trial on an old case of mine. Any general advice? Wait, got your first subpoena for a jury trial on an old case of yours?
I don't really even understand what that means.
Yeah. So wait, if it's an old case of yours, why are you being subpoenaed for a jury? I'm very confused by that, Nova. I'm very confused by how that's worded. I think I must be misreading what you're writing. So no, I don't have any advice. If you've been subpoenaed for your own jury trial of your own case, I think that subpoena process might be broken. Nabor says judge looks like she'd be confused as to why an expired coupon for groceries wouldn't work. Deep, deep.
That's a good take.
That was actually funnier than I thought it was when I read it, because I had to settle in. Deep Surface says if she's the judge who's driving the short bus. Let's see. Scott Campbell says it's good to see that the MR community is represented on the bench. I would use the R word for this judge, but she gives ours a bad name. Oh, man. Intellectual Iconoclasm says, Mr. Branca, how do I arrange a consult? I want to open a gun-themed makerspace. I want to be aware of issues I'd face in Colorado.
I don't know what a makerspace is. What is that?
Me either. I have no idea. What's a makerspace?
Yeah.
Does
First of all,
anybody know?
the question is very confusing. Second of all, I do use of force law, folks, so I don't do anything around setting up any kind of enterprise or business or makerspace or whatever that might be. If you're involved in a use of force event, you're facing criminal or civil liability, that's where I would do a consult. But you'd have to be one of our platinum protection members, because we only do consults for that platinum membership now.
So there you go. That's how you do it. Keldrig says, do you suppose she has to go through all this because of Fluffer Boy Binger? No, this case is entirely in a different state. I mean, there's the lawyers have watched the Rittenhouse trial. The lawyers are referencing, the video interpolation and bicubic filtering or whatever.
Next neighbor.
Yeah, next neighbor. But no, this judge is not bound by anything that happened in Wisconsin under Kyle Rittenhouse. And even if she's thinking about it, I don't know that she's thinking all that much. AZ Beauty 7 says it's creamy honey peanut butter on your choice of slice. Okay. That seems like a lot of peanut butter to me. I'm not sure about that. Janet Morgan says the defendant looks like Carl Reiner. Just saying. I kind of see it. Marie D says this opening sounds like a Dr. Seuss reading. I've learned so much. Happy Heart Day, Nick and Andrew. Oh, Valentine's Day, yes. Scott Campbell says, why is this man on trial? Sounds like he's a hero. People using their phone in the movie theater is a capital crime. Civilized society was restored. Do you have any Valentine's Day plans today, Andrew?
I actually do not.
Oh, okay. I mean, I don't think your wife's watching. You wouldn't be spoiling it if you mentioned them.
I don't know if she's watching or not, but no, wouldn't be spoiling it. We kind of did a celebration already.
Oh, okay.
By the way, somebody asked about the mug, like I sent Nick. We do sell the mugs. They're more expensive than I would like. I'm not going to lie about that. They're made in America. The Chinese mugs were much less expensive, but we preferred to get the American-made mugs. But anyone who's interested in a law self-defense, hard to kill, hard to convict mug can get that at the URL in my photo now, lawofselfdefense.com/mug.
Bad vibes. Nope, read that one. Jules Pelico says, if the screen was lit, you must acquit. Orif says, Cinebistro is a terrible term on its face. Much more so when you hear it said 15 times in 2 minutes. Yes. Circle of Snakes says, was that 380 Full Metal Jacket? It's a good question. Might have been an exploding mushroom hollow point fragment. Shrapnel incendiary. Joseph DeMartino says, did this guy study under the Rittenhouse prosecutor? Bad Vibe says, odds of the defendant winning, 70% is my guess unless something fantastically stupid happens. Well, I mean, you did just see the opening statement, so I think those odds are out the window.
Yeah, I mean, there's the facts, the actual evidence, and there's the legal arguments to be made, right? So you have to evaluate those. That's what I tend to do when I look over these cases. But then you also have to consider the delivery by the prosecution and by the defense, and they both sucked this morning.
Yeah, Not good. For what it's worth, the very official guaranteed results from the chat, we have about 3,000 votes, which means we have about 3,000 slackers, or maybe actually about 4,000 slackers. Have it at 63% guilty and 37% not guilty. So if you want to put your opinion in there, it is still, that poll is still up. You can go ahead and say what you think on the side. Wolfgang Deo says white males lead the suicide statistics for yet another year. The 2020 data is finally coming out, but not yet on the CDC website. Systemic oppression. Automata says prosecutor says he wasn't hit that hard that he felt he had to kill another being. Great to have an opening directly saying his state of mind. Boo. Yeah, and the defense should have capitalized on the prosecution doing what the defense ended up doing, which was telling the jury what to think. But, there you go. Doug Carter says, does the fact that he's second guessing himself after the fact while sitting in a squad car really weigh on the fact that in the moment he could have felt 100% need to fire in self-defense? It does when you're a prosecutor and you want to make someone guilty, then everything factors in. Trevor R says, maybe if every game of Simon Says ended with a bullet shot, we'd have a lot less rule breakers and a lot more compliance. Obey, 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 obey. 1984. Jay Fishes says, can the prosecutor sitting down stop chewing on his nails? Was he chewing on his nails?
I didn't notice that, but it sounds pretty gross.
Yeah, don't do that. Emmanuel says, use the long crime overlay when this gets boring. Also, at that age, would you rather have testes or eyelids? It's a good question. I don't know. Maybe the expert on aging will come in and give us the answer to that question. Actually, yes. By the time you pass the age of 68, you no longer care about testicles and you're solely focused on having eyelids. They have become the most sensitive part of the human body. Jeremy,
hey, careful. I can see 68 from here.
Jeremy N says the amount of neck fupa in this trial is a real crime. Gross. Stop. Contrarian 420 says the bullet easily could have penetrated the body or missed and killed some kid seeing a movie. He shot the innocent woman's hand. Unconscionable. Yeah, and that is the big perception that the defense has to try and overcome. Again, the case on its face is ridiculous. If the narrative, and you could see the defense trying to change that narrative. They said, it's not about popcorn. This is not about having popcorn thrown at him, right? This is about a guy who's afraid of being hit and severely harmed by a big, angry, unruly man. That's the narrative they're going with. And I mean, that's
they
the right narrative.
They do have to touch on that because the jury, I mean, the entire local populace would have been hearing for 8 years that this was someone who was shot over popcorn. So you definitely have to get the jury past that.
Yeah. And that'll be a big part of their job. If they don't do the job, they will lose the case. I mean, if the case is, we've talked a little bit about the sort of the outside legal argument that in Florida, it is technically a felony to do even a simple battery on someone over the age of 65. So in this case, he's over 65. Throwing popcorn at him is a simple battery, technically a felony. And in Florida, you can also defend yourself with deadly force against a forcible felony. So under sort of that chain of legal theory, he could, in fact, defend himself against that type of attack. However, where you need to win that is at the pretrial hearing to win it as a legal argument. Because otherwise, you're just asking a jury to make that determination when you've already lost that to a judge. And I think that's a much harder sell.
I mean, as a legal matter, so strictly from a technical legal analysis, I think the state should have had that argument thrown out long ago, because I mean, first of all, the way that statute, for those who were interested, that makes it a felony to commit a simple battery on someone 65 years or older. That's Florida Statute 78408. First of all, I would argue it's really a sentencing statute. It really applies to the person committing the battery, not to the victim. I would argue it doesn't change the victim's privilege to use deadly defensive force where they're not actually facing a deadly force threat. But in any case, the statute has this weird condition in the relevant paragraph. It says, whenever a person is charged with committing a battery upon a person 65 years of age or older, what would have been a simple battery becomes a felony. But Chad Olson wasn't charged here,
Right.
for obvious reasons. He was dead. So I would argue, simply as a technical matter, this statutory provision is not triggered because no one was ever charged with an underlying battery.
Yeah, and that's part of the problem is trying to use an aggravating factor basically as the justification for your self-defense is already on a losing front. But I'm glad to see that the focus of their argument appears to actually be the more reasonable traditional self-defense. I mean, that seems to be where their opening statement focused on. This guy is scared because a big guy is hitting him and he's old and frail. I mean, that is an easy to understand argument. If you're trying to bring the popcorn justification to the jury, I think you're looking at losing. So I'm glad that's not the approach that they're taking. Because that would just not be very interesting in the long run. Andrew Lawhern says the real question is, did Mr. Reeves play Call of Duty before going to the movie? Because we all know people that play video games are guilty. Just ask Binger. Very true. Very true. Also ask Chandler Halderson, who learned how to chop up and eat his parents by playing Tarkov. Not applicable says fist fight isn't a deadly threat though, right? Well, it can be. It can be a deadly threat. It
Right.
depends if you're.
So what we would call a traditional fist fight between two men of similar size, strength, and fighting ability is not normally going to be deemed a deadly force event by the courts unless there are aggravating factors. And there are potential aggravating factors like a disparity in size and strength, like a disparity in numbers, multiple attackers and one defender, or a disparity of age, or where one party is exceptionally vulnerable to harm. Those are all aggravating factors that could make what would normally be a non-deadly punch into a force that is readily capable of causing grave bodily harm.
Yeah, and also I would think the circumstances of the fight. For example, if one in this case, now you have a little bit of a difference because there's a barrier between them in the form of the seats, but where one person is sitting in a chair with nowhere to kind of go or maneuver, and another person is able to just unload on them because they're standing up and blocking their exit from like a stationary chair, like a movie theater chair. And again, not as clear because he's a whole row away, for example, but if you're in a stationary chair and that you can't get out of, and someone's able to just unload on your face, that might actually be a factor that takes this thing into the next level. And that's why the jury is always supposed to be the reasonable person in circumstances that mirror the circumstances of the actual event, the facts that they're drawing out there. Because technically, the jury is the one who determines if the fight was dangerous, right? Like they're the ones who determine if the self-defense is valid, which means they have to first find that there was a deadly force threat that was reasonable.
Or at least reasonably perceived.
Or
Right.
reasonably perceived, right? So if they think, oh, if I'm in a chair and someone's beating me, then I'm in more danger, then they can make that determination. If they don't, if they say chairs are very defensible, right? I can set up a moat or whatever, then they don't make that. That's up to the jury. DeHobbs 9 says standing up the seat base springs UP. He's closer. Oh, standing up, the seat base springs up. Yeah.
Yeah.
Oh my
So he can
God.
step closer than if it was fixed in position.
Yes. Yep. That is correct. Did I get that one? Let's see. Oh, Jackson Kai says, Happy Valentine's Day. No date for me. My younger brother just got out of surgery and I'm spending the day with him. Second nose surgery after a coworker assaulted him. Thankfully, no one threw popcorn at him. Well, that's good. That's good. If there was popcorn being thrown at him, that would be much worse than whatever happened that required surgery. QGG639 says, I've responded hothead old men in my younger years to the point where one backed out of a parking spot into a passing car, but now I'll think twice. I would strongly recommend people start thinking twice about responding to just about anybody. I mean, anyone could be carrying a gun or a knife, or legally or not, and they could be having a bad day, and you responding to them or engaging them could be the catalyst that ends up with you dead. It just could.
Or them dead. And you charged.
Right. Exactly. Same thing. They say an armed society is a polite society. That second part is really, really important, because that second part is where people, don't die, is when the society is polite, and that includes you and the other person. So, you'll usually find me advocating that people stay out of things like that, not get involved in anything that could potentially come close to leading you to drawing a weapon or having a weapon drawn on you. Distro 32 says the boomer cop wanted one last kill. Sorry, but the former cop should know how to defuse the situation. Yeah, but the counter argument is maybe he did, right? If you believe the defense, he went to apologize for turning the guy in, said, hey, fine. Now, if you believe the defense, he said, hey, if I would have known you'd put your phone away, I wouldn't have gone to talk to the manager at all. Cause it's all in essence, all I wanted was just to make sure you knew that, phone should go away or whatever. And that I wasn't going to be sitting here staring at your bright ass phone screen during the entire movie. So if you buy that, then yeah.
Plus failing to diffuse the situation is not an element of the charge or the legal defense here. It may be a prudent thing to do, like changing seats might be a prudent thing to do, or they could have just left the theater after the first confrontation. That might have been a prudent thing to do. I probably would have chosen all of those before I would have put myself in this ultimate situation with the popcorn. But just because it's prudent to do doesn't mean it's legally required, or that your privilege of self-defense becomes conditioned on you doing the most prudent thing.
Right. Correct. That's often, I mean, if we go back to Kyle Rittenhouse, Kyle being at that protest was imprudent. Kyle having a gun at that protest was not a prudent course of action. Most people would not want that, their loved ones to participate in that type of action. They would be concerned about them in that type of action. So, the prudent thing was to not be there, but that's not the situation that was presented. And so, in this case, him diffusing or not diffusing the situation isn't really relevant, and it's not in question. The question isn't, did he diffuse the situation or not? The question is, was his shooting justified? Was it justifiable self-defense? DeBob03 says, X's lawyer suggests I take my 8-year-old to conventions with scantily clad women, despite pics of Super Mario, LeVar Burton, Kermit the Frog puppeteer. I think you mean stop taking your 8-year-old. That's what your ex's lawyer suggests, you stop taking your 8-year-old to conventions. Well, look, ex's lawyers can suggest a lot of things, but court orders are what make things happen. So, that's up to you how you want to fight that out. If you want to fight it at all. United States of Q says, who hired the Blue Man Group as lawyers? That's a good question. W. Smith says, did the judge's cell phone just go off during a case about cell phone interruption? No, I think it was someone in the audience, but that was good. 200 Watt Studio says, Judge Joe Walsh, unbreaded. Walter Deadman says, I think the bow tie is to tell the law office of bald and bald apart. It's the law office of bald.
It is helpful in that regard.
Yeah, that's true. That's true. Fair Frozen says, I thought Binger was sub for the F slur. Nope, the N one. Otixoa says, you're double lawn crime viewers. Well, good. Torque Hammerwolf says, Nick, the ATF put out a banger Valentine's Day tweet. The replies are golden. Go check it out. I don't know. Well, let's see. ATF HQ. Our sympathies for the Copperas Cove Fire Department. Seattle Field Division. Oh my gosh. Oh, wow. Okay. Yeah, I'm going to pull this one up. I think you'll appreciate this, Andrew.
Okay.
This is, I'm going to give him credit. It's funny. It's horrifying, but it's funny. Valentine's Day can still be fun even if you broke up. Do you have information about a former or current partner involved in illegal gun activity? Let us know and we'll make sure it's a Valentine's Day to remember. Call 1-888-ATF-TIPS or email atftips@atf.gov. Wow. We would love to meet and treat them to a Valentine's Day surprise. That's fun, right? A little bit of snitching, a little snitchery.
Yeah. And by the way, folks, there could be a lot of that. I mean, I don't do gun law, but I hear the ATF is once again reconsidering whether these arm brace things on AR pistols makes them into short-barreled rifles, for which you need a NFA stamp and all kinds of paperwork. If they do that, you've suddenly acquired a machine gun without even knowing it, because you have that arm brace on. So you may want to think about that. If that change happens, there's going to be a lot of suddenly illegal ARs around. And if your ex-girlfriend happens to know that, that's the kind of phone call that could result in serious federal jail time.
Yeah, be very, very careful with any of that stuff. Also, it should be noted that it's possible that that the ex reporting you could be implicated as an accessory in some of this stuff. So, I would suggest to the people who are considering reporting, consider the idea that you should not talk to the police as a primary concern for yourself as well. Okay. That's good. Salty Old Guy says, yo, Nick, why do lawyers wear neckties so the foreskin doesn't pop up over their head? But oh, I get it. Because they're dicks. Casey Morgan says the prosecution should have just said the old man did the wish a motherfucker would when he came back from the manager. Then he drew before a threat was clear. Handerpants says, Recollection and Branca, the prosecutor teaches down here at the police academy. While in class, he was super pompous, exactly like in his opening. Oh, okay. There you go. I wasn't a big fan of the prosecution's opening until I saw the defense opening. Then I wanted the prosecution back.
I think this was the prosecutor in the Michael Draca case too, one of them. He looks familiar to me, and I think it's from that trial. That would be the handicap parking spot trial that took place a couple years ago in Florida.
Yeah, the shorter guy who gave
Yeah.
the opening that you're
Yep.
talking about. Okay, yeah,
I think
I
so.
I don't remember who the attorneys were in that case. I mean, I just remember watching that guy's questioning and going, "Well, you're guilty. Like you're done. Game over." Terrible answers. Dan Usher says Recollection Law 7.7 thousand, Law and Cuck 3.8 thousand, Court TV 423, and Fox 13 Tampa 297. Yes, we are I think over here redefining how people watch live trials, and that is a good thing. That is a good thing. Berserker says, question for Mr. Branca: is concealed carry insurance worth it? And if so, who do you recommend for someone that lives in Pennsylvania?
Well, I can't give a universal answer on whether it's worth it because it costs money, and I don't know what your circumstances are. If you're can't afford it, it's probably not worth it. If you're super wealthy, you probably don't need it. You're effectively self-insured. If you're somewhere in the middle, then you might want to consider. The criminal defenses are extremely expensive. Easily go through a couple $100,000 for a murder or manslaughter trial before getting to trial. Then just increase the cost from there. So if you don't have that kind of money stuffed in a mattress, you might want to consider some kind of, quote unquote, self-defense insurance. The one I recommend people at least take a look at is CCW Safe, which you can find at lawofselfdefense.com/CCW Safe. And if you do decide to become a member there, you can save 10% on your membership with the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. Another one worth considering is Armed Citizen Legal Defense Network. They do good work. Their resources are substantially less than CCW Safe, which is why they're not my first suggestion. Most of the others I simply can't recommend at all. The USCCAs, the Law Shields, those I don't think much of.
There you go. And I have no idea or advice on any of them. Irie says, good morning, good morrow from China. Oh, how you doing? How you doing, Irie, up in China? The wonderful place. I love that. Did you see the recent drama with the truckers and the give send go money?
Yes. So the money was frozen. I mean, I only see the headlines, so I don't read the stories. But
yeah. So basically, the Canada went to their own courts and asked them to issue an injunction against the American company Give Send Go because they had the audacity to be sending money to the truckers that was, being sent to the truckers.
Sounds a bit extra jurisdictional.
Yeah, they issued the order, but Give Send Go said F you, as they should. We're Americans. You can't tell us what to do. However, yes, the bank account. Oh, excuse me. The banks are freezing the accounts that the money's going into. And there's not much anybody can do about that. The banks, it's the banks, all of this stuff, all of our freedoms, really at the end of the day are coming down to the banks. Many of the free speech issues we have on platforms are due to the banks saying, oh, well, we don't really agree that this person should be allowed to say what they're saying. And so therefore, if you continue to transact business with them, we will no longer transact business with you. And they tell that to whoever your platform is. That's how they deplatform people.
They did that to the My Pillow guy, right?
They did it. They did it to the My Pillow guy. One of Trump's banks shut down his accounts. They've done it to I think they talked about doing it to Lynn Wood. I don't know if they ended up doing it. But really, like, this has been going on smaller scales on places like Patreon or whatever, where MasterCard will shut down someone. Jihad Watch, their Patreon got shut down. They were one of the first ones where the bank actually came out and says, yep, you can't have this person on your platform. And it's crazy to me that that banks have that kind of power. I mean, in my opinion, there needs to be a constitutional protection for access to exchange money. And the way we exchange money is banks. Like there's a limit to how much cash you can you can reasonably acquire and send. And
Well,
so,
especially as we increasingly move to a cashless society, in any case.
right. And where you get cash is still from a bank. Like if you don't have any and you just have all of your wealth represented on paper or digital or whatever, you'd have to go to a bank to get that cash, presumably. So it's a mess. But
Hey, speaking of money, I saw that there was a hearing a week or so ago on the Rittenhouse case for his bail money.
yes,
But I didn't watch it, and I haven't read anything about it. Do you happen to know anything about that?
I know everything about it. Yes, there was a stipulation between Rittenhouse and Lynn Wood's Fight Back Foundation. John Pierce stipulated that he was out of it. He didn't want any of the money, wasn't going after it.
He's got enough trouble.
Yeah, so he stepped out. Lynn Wood entered into an agreement with Rittenhouse that that they would each get 925,000 of the 2 million, and then that the remaining amount, I think there was 150,000 or something like that, that would go to the guy who donated a whole bunch, that celebrity who donated a whole bunch right at the end to bring Kyle over the top. I can't remember his name. But I also there was some speculation about how much of that 925 Kyle would receive. From my understanding, Kyle's legal defense was otherwise paid for. So the money did go into the apparently into the trust account of Mark Richards for the benefit of Kyle. And there was apparently not billed from that amount. So that amount was transferred to Kyle, or would be or will be transferred to Kyle. I don't know the specifics on that, but allegedly he'll be getting all of it. So, which is a good deal.
And none of it's going back to the people who donated it, I guess, right? Because in theory, I mean, they donated it as bail money, and normally you get your bail money back, right, at the end. It's
right. But it's
but they're just treating it as if it was just a contribution to Kyle personally.
Yeah. So because they contributed to his defense, and the way that was defended was, or the part of the defense was the bail money payment, I guess, is the way I would look at it. And so
okay, I see. So it wasn't a specific bail fund; it was a generalized legal defense fund.
Right.
All
Right.
right.
And
I just know, like, if my brother-in-law called me up and needed to be bailed out, and I put up the bail, and then he got acquitted, I would want that money back.
yeah, that would right. And I would agree. I think that's a little different situation. In this case, the reason that Fight Back got such a large portion of it, according to the stipulated document, was they could not prove that all of the donations that came in were earmarked specifically for Kyle. So it seems that Fight Back, I'm using the word, but I'm not using it in its negative connotation, commingled some of the funds that came in. Basically, they provided more money than Kyle had specifically fundraised. And so then they agreed to just, this is the split, that's the way you do it. That's the way you handle this stuff. And it was done. There was an actual other party, a creditor of John Pierce, that was attempting to subvert that stipulated agreement and get the money.
Right.
But
That's
they
what
had,
creditors do.
yeah. And they have all sorts of issues with their attempt. Basically they have an ongoing lawsuit against John Pierce. John Pierce wasn't getting the money. It was never John Pierce's money in the first place. He physically made the payment, but he did it on behalf of his client. So it was, long story short, they were eventually, when Judge Schrader decided to finally rule on it, he basically said, no, you can't do that. Tamara Holloway, back to this, says he was so weak and afraid he confronts a big guy. He wasn't afraid at the time he confronted him. And that's another issue with these self-defense cases. You can go from being confident and having a normal interaction with someone to being terrified of them in a moment if their actions become unreasonable. I'm not saying that's what happened here. Again, my default on this is right now, I think Curtis Reeves. I think Curtis Reeves is about to get the Christopher Reeves treatment, have his back broken over the horrific court process, because I think he's probably guilty. However, that doesn't mean that he couldn't have become afraid after confronting someone. And there's not a prohibition against confronting someone as long as you don't do it with physical violence or some particularly threatening action. You can say, "Hey, asshole, turn your phone off." Like, you may not want to, but you can. And so and I know the justification, people will argue, well, there's no justification or you can't justify shooting someone over popcorn or whatever. You also can't justify taking a swing at someone over saying, "Hey, turn your phone off." Like that is not justification. Those are not sufficient fighting words in that case. And if you take a swing at someone because they said turn your phone off, and that person is older and frail, they may shoot you and you may die. And then they may go to prison or they may not. So there's competing narratives, but we'll figure them out as we go through the case. Centrifugal Issues says, is the guy talking about Joe Biden or the defendant? Come on now. You know he's talking about Joe. Liquid City says, this is a clear-cut case of assault and buttery. 200 Watt Studio says, if those lawsuits went to court and were televised, they would be seen by Jupiter now. Someone did say they settled those out of court. The wife's lawsuit with the theater was settled out of court.
Okay. I couldn't find anything after the announcement of the lawsuit, but the announcement was not a lot of money. It was $15,000. Unless that's just like the upfront and they would go for punitive or something after that. But
I mean, they would have a problem, right? Like, it's the enforcing the no gun policy, and even getting a win on 15 grand would be a win on that. That's a pretty weak theory. How would they know that first of all, it's their own policy. It's not a state law. They have no duty to enforce the policy that they have. Like, I can have a no drinking in my store policy, like, right, no food or drinks in my store policy, and someone comes in with some McNuggets and starts eating them, and I choose not to enforce it. Okay. Like, what are you going to bind me to my policy? My policy is my preference, my conditions to someone. I can waive those at any time. So the fact that a failure to enforce a no gun policy that you're not required to have isn't a super strong legal argument, in my opinion. Let's see.
by the way, I would also note, it's been my experience that these movie theaters that have 20 doors going into the lobby from the exterior usually only have that sticker on one or two doors. So it's not even clear to me that most patrons entering the building would have been effectively informed of the condition.
Yep. Joe Taylor says, do both sides think no one has ever been to a movie theater? You almost sit in each other's laps. Yeah, it's that's true. Now, see, there are theaters though where it's different, and so you'd want to make sure and talk about that. For example, I went to the Burnsville movie theater, and it has the similar layout to this one, where it's got the upper section where the Cine Bistro or whatever, and you can order food, and those chairs are very spaced out. You have two chair groups, but there's like a table, well, like an end table kind of between the two chairs. The row in front of you is a significant way in front of you, several feet ahead. So it's that would be a very different circumstance. This just where they were sitting looked kind of like a regular movie theater.
Yeah. And by the way, those premium seats are the way to go. I only go to the theater maybe once every year or two, but when I won't go unless they have that kind of seating.
What if you could just go and have the whole theater to yourself automatically because you rented it?
You know, we have a home theater in our basement with a big projector hanging from the ceiling and a giant screen and a big leather couch. So most of the time it's just it's frankly more comfortable just to stay home.
I agree. Especially now that you can do the like simultaneous movie viewing thing where you can watch not that there are too many movie theater movies coming out right now that I want to see, but I don't have like, I have a nice TV, but I don't have like a theater room or anything for it. But I'd much rather pay $20 and sit down with my wife and my kids, if it's a kids movie, and our own popcorn and everything, and just watch the movie. Like it's funny because like, oh, $20 at a shot, it's way cheaper for me to do that than to take my whole family to the movie theater. So,
And then you don't need to deal with, people having their phones out or, gunfire.
well, when it's the kids, I do, because they've got their stupid iPads. So, DCV Titan says, so they are using the Edgecombe defense a little bit. Yep. They're going to argue that, that he was in fear of the potential violence of this person's hands. Joseph DiMartino, thank you for the donations. Oh, I didn't read this one earlier. Sorry. Kyle Bogue says, Bush at a strip club? Been a while, eh, Branca?
It has, in fact, been some 30-something years since I've personally been in a strip club. Yeah.
Tim the Ancient says, were they depressing then?
Oh, horrible. Yeah.
Yeah, they're
Horrible
depressing now. It's it's like, oh God. Yeah. I told this story when I was at an event down in Tampa, and a bunch of people, we all went to the strip club, and there's a guy for the one girl, and he's like right, like might have been her boyfriend or something. He's like right up front. He's throwing her money like crazy, and she was very average looking, and then she gets done, and they went up to the VIP room or whatever. And then that was the only guy in the front row. Everybody else on like couches way away. And the next girl gets up, and there's nobody there at the the dance bar. And so she's doing this dance and like completely degrading herself. And there's no one to give her any money. So I looked at Lady Rackets, and I was like, I feel bad. And so I had $4. I was like, here's your $4. And I walked away. It was just so, I was like, this is so damn shameful. This is your life. You need to stop, please. Okay. Tim the Ancient says, is the Monopoly man for the defense or the prosecution? Oh, that'd be the bow tie guy, right? Yeah, he was for the defense. Let's see. Berserker says, is this a movie? Because the defense attorney looks like Mr. Strickland from Back to the Future, and the defendant looks like Saul from Ocean's 11. Pineapple Girl says, I'm sure this has been answered, but for those of us arriving on the short bus, why did it take 8 years to get to trial? Well, COVID delayed a lot of things by multiple years. Andrew laid out earlier that, there's in Florida, you can request a pre-trial hearing, which is a mini trial for dismissal. It changes the burdens a little bit and how they're applied, but if you win and the case is over. And I think you also get civil immunity as well.
Yeah, actually have to have a separate hearing, a separate self-defense immunity hearing for the civil. They used to do it at the same time. You just qualified for both, period. But the Florida courts have reasonably enough said that, hey, if in the criminal context, any civil plaintiff's not actually being represented in that hearing. So how can you make their rights go away? They have a right to a day in court too. So it actually takes 2 hearings now, one for criminal, one for civil.
Gotcha. That makes sense. Adam A says, this trial is going to be painful. I'm only here for the Recollection commentary. Thank you, Adam. Adam had a good question earlier that I wanted to address. He was very clearly have to preface this. He was under the impression that the guy was arguing that he perceived a gun was being drawn, which I don't think that's actually been stated. So there's a disconnect there. But he did say that if the theater disallows guns, how is it reasonable to suspect that the other person might have a gun? And to which I would answer, Curtis Reeves had a gun. So therefore, and he was in violation of the theater's policy. And so therefore, it would be reasonable for him to think that somebody else would also have a gun. I mean, I
mean,
hope
you
that
can't just blanket speculate that someone has a gun, but if they're conducting themselves as if they have a gun, they're reaching as if they have a gun, then you can make reasonable inferences from what you're seeing. And there's no, it's not like it's a law of nature that says because there's a sticker on the door of the movie theater, this person can't have a gun on them.
right. Yeah, like if you're Axel Foley and you're at Wally World or whatever, or Wonderful World, then you can point out that they need to cut their jackets an inch heavier on the left side because you can see the bulge of the gun, right? That's what you got. God, I love that movie. Aurelian Naudius Caesar says, when I was 18, I was called to jury duty and did not want to be there to get out of it. I just slept and flirted with a girl who was also on the jury. Turns out the case was about human trafficking. Okay. There you go. Debbie O says, fun fact. This defendant has been in legal trouble, re guns, before, but they aren't allowed to bring it up in this trial. That's typically how it goes. Yep. Because you cannot prove that because someone did something bad at one point, that automatically means they did a bad thing now, even though that's the inference that everybody draws. And that's why they can't present that type of evidence outside of very limited sort of reasons. And if they were allowed to, the Kim Potter decision may have gone very differently. For example, in the Kim Potter case, the person that she shot had pending trials for shooting two other people, I think, one in the head, one in the leg, and had a nasty rap sheet, also a nasty rap mixtape as well. But and he had allegedly armed robberied a female that he stayed overnight at her house just a little bit prior to that as well. So but that's the reason for the rule of evidence, is that those things don't mean what happened on the day happened in a particular way most of the time. Magnus F. Hansen says maybe the defense strategy is to have the case dismissed when the defendant dies of old age.
Well, that would work.
Yeah, it is. In Colorado, do you actually have to motion for dismissal after that?
I don't know.
I had a client.
I live in Colorado, but all my law practice was really in Massachusetts.
What about in Massachusetts? Did you have to motion for dismissal after a client died?
I never had a client die. So,
God, how did I get that? It was a bad day. It was actually, this is the anniversary of it. It was on Valentine's Day that my client died. Took his own life. It was really, really sad. It was I do not believe that my client took his own life solely because of the criminal case against him. But we had actually negotiated a plea deal where he would face no jail time and his felony would go away after a year of probation. So
that's a pretty good deal.
Yeah. But then I got a phone call on my way into the office on the morning of Valentine's Day. And he had I had to talk to the parents. And that they don't teach you that in law school, by the way. There was no training on how to deal with your client has killed himself and you're talking to their parents. Very not fun. Not a fun day that was. But I had to motion for the dismissal. And I had to prove that my client was indeed deceased. So that was fun, I guess. Not applicable says this is Ron Toye the third post BJ pillow talk. What? Logan Cisco says opening so long I want Curtis to shoot me. Caligula says wake me up in 2024 when he finishes his opening statement. Anthony T says this seems like argument rather than an opening statement. It seems like he is playing his cards from moment one instead of holding back. Yeah, I think the prosecution would agree with you, and I think they called him out on that rather effectively. It degraded into an absolutely terrible opening statement. Skeet Neat says that bald guy with the bow tie looks like Dana Carvey from Master of Disguise doing the turtle scene. Also, Tao deserved to swim in lava in Minecraft. Agree. Not applicable says, why are lawyers this bad allowed to practice unjust? Because freedom, baby.
It's not going to get better.
No.
I don't see the quality of attorneys going up over time.
Yeah, well, it necessarily pushes downward, right? Because you've got a couple things. You've got law schools. Law schools, you get paid one of three ways. Either someone pays their way, or they borrow money to pay their way, or there's a scholarship from someone that pays the way. Sometimes that scholarship comes from the college, like they have an endowment fund or whatever. Other times the scholarship comes from third parties. It always benefits a law school to be at maximum capacity for students, though, because that's how they make their money. It's a business.
And there's a powerful incentive for universities or colleges that don't have law schools to open law schools, because basically it's a money printer. It's very little cost. You don't even have to hire real professors. You just hire local lawyers to be your law professors. There's no labs. There's no real equipment. They're just classrooms. And then you can charge people whatever they charge now for law school. God only knows.
It's a lot.
When I went, it was like $40,000 a year. It's probably 3 times that now.
It depends on the
charge
school.
all this money. You get the money up front because the kids take out loans. So you've got yours. And then unfortunately, it's a lot like, farm teams, expansion teams in sports, right? Where you have 15 NFL teams and then you double it to 30. The quality doesn't go up, right? There's only so many people who are actually equipped to play at that level. So the 30th team tends to suck pretty bad. You double the number of law schools, you don't get double the number of good lawyers. You get a lot of people who ought not to have gone to law school. And a lot of them can't pass the bar. As you even see efforts now to do away with bar exam requirements because of the sheer volume of students coming out of law school who can't pass the bar exam and therefore can't practice law. I'm not sure the answer to that problem is to do away with the exam.
If they get rid of the bar exam, I mean, the lawyer hiring minefield will be even worse than it already is. Because look, the bar exam is not always an indicator of who will be a good attorney. Lots of people fail the bar even multiple times and come out and are great attorneys. Lots of people pass the bar on their first time, come out and are terrible attorneys. Okay. But a lot of people who fail the bar deserve to fail the bar. Like that's true. Like a lot of people who do. I met a bunch of people. I know people who failed the bar and are really wonderful. And I would recommend them as attorneys to people in a heartbeat. But a lot of people that I met who failed the bar when I was taking it and they were on their second or third time, I was like, oh, I get this. I understand why you failed the bar multiple times. Okay. Now I get it. So I would not want to hire a lawyer after that. I would only hire someone that I had a very strong personal recommendation from. That'll be crazy.
I mean, it's bad enough with the bar requirement. I mean, we have enough bad lawyers as it is. We see them in these trials, right? That's not going to improve with massive expansion of law schools and watering down of qualification requirements.
When you mentioned adjunct professors, the best part is, so law schools sell them as a benefit, right? These are lawyers, active lawyers with practical professional experience, and then they pay them nothing because they're active lawyers with practical professional experience. So they pay them what, $5,000 a semester? Maybe?
It's ridiculous. I mean, I get offers all the time just because I'm on the internet. So people do searches, and my name comes up, I guess. But they want you to work as an adjunct full time and pay you minimum wage to do the work. I mean, it's absolutely insane. If they asked me to come teach like one course a semester, I'd probably do it just for the shits and giggles and wouldn't care too much about the compensation for a couple hours a week. But if they want a full-time obligation, no, that's not going to work. Not at that price.
Yeah. And like it's a low amount of money considering what they're charging, what each of the students sitting in that classroom has paid for the privilege of being there. I mean, you're talking hundreds of dollars per credit hour. And these are 3 credit and 4 credit classes. And to then pay the professor, 4 figures a semester or even a year is wild to me. But yeah. Okay, then we got, why are lawyers this bad allowed to practice? Because, well, and you know what? Here's my opinion on it. Here's my libertarian freedom opinion. There shouldn't be any requirement to practice law at all. I actually think that the part of the problem is the artificial nature in which they have created this expensive system of gatekeeping. I do think that's actually part of the problem. I think it gets a bunch of people into the profession who shouldn't be in the profession and inflates the costs at the same time, because the perception is if you pay all this money and then get in, then you have this limited market that you're able to participate in and earn from. So, but that's my perception. But at that point, you'd have to be way more cautious on who you're hiring, because it would be up to you, like everything else that you buy. Like my phone, which just recently decided to stop accepting data, because you don't need that. You don't need to receive text messages or emails or internet on your phone. No, I did not drop it or do anything to it. It just stopped. So caveat emptor. Roger Wilco says, by the power of video playback, Funderburk. Ho! Gates. No, wait. Liquid City says he used his entire popcorn fund to hire these lawyers. Not applicable says, here we see oldest deletus in his natural habitat. See Goody says, Recollection Law, check Discord when you can. There's a video someone wants you to see at some point. Not long. You'll like it. Yes. And I'm sorry for my negative reaction. See Goody. I know you were trying to be helpful there. And I took out my ire on you, which is, I mean, you're a mod, so you deserve it, but you didn't, individually deserve it, but you are a mod, so you did. Not applicable says, now we see Winus McLawbird in his natural habitat. Walter Deadman says, are you sure this is a court case? I swear this is just C-SPAN footage of a filibuster in the Senate. God, it kind of looked like it. Not applicable says, object, holy freaking cow, what is happening? Robert Norwood says, yeah, stomp on that parasocial relationship. Put them in their place. Dang right. Not applicable says, hard not to prove homicide with a bullet in the guy. Though, it's not hard, but if they don't do it, that's a great thing. And look at the Rittenhouse case, right? They never actually bothered to prove the curfew violation. Whoops. I mean, imagine if they had never proved that Kyle's bullet went into Rosenbaum, right? Like then you get to the end of the prosecution's case in chief and you just say, Your Honor, we move to dismiss. They never proved that this gun or my client or anybody killed Joseph Rosenbaum. I mean, we know he's dead. We know there's a bullet in him. We don't know where it came from. They didn't prove beyond any reasonable doubt. They didn't make the case at all. If they failed to prove that, then you can win. So, the state still has to prove it. Stinar 28 says Principal Skinner needs a time machine back to law school. Chris Stroda says, so if you are denied self-defense immunity, you can still argue self-defense at trial. Yes. That seems strange. What's you and Branca's favorite Irish whiskey? Do you have a favorite?
I don't really drink whiskey, so
yeah. For me, so far, it's Yellow Spot. Yellow Spot is great.
I mean, I do have a nice bottle of what is it, Van Winkle here, but
Yeah.
it's unopened since the client sent it to me. So,
I mean, it's a crime. What you've just said is a criminal act.
You ever make it out to Colorado, Nick? We'll open it up.
Sounds good. I will. This is going to happen. but yeah, it seems strange, but you're always entitled to your jury defense. And remember, the pretrial motion, the self-defense immunity to pretrial motion, that puts a higher burden on the defendant to prove their self-defense rather than to some extent, rather than to the higher burden on the state to prove that there was not self-defense.
Right.
So,
So
and
in Florida, you can think of it as at the hearing, the state has to disprove self-defense by, I'll make up a number, 75%. At trial, the state has to disprove self-defense by 95%. So the fact that they failed to do it or they were successful at the hearing doesn't mean they'll be successful at the trial.
right. Although, what are you thinking right now? Just gut feeling. I know you don't predict juries, but what are you thinking on this one?
Listen, there's a narrative of lawful self-defense here if you believe the defense.
Yeah.
And the state has to disprove that beyond a reasonable doubt. Now, unfortunately, the presentation of that narrative was just horrific this morning. So, again, you can lose the case not on the law or the legal arguments, but on the presentation alone.
Yeah, and you nailed it. It was horrifying. Just horrible presentation. At Saru says, yeah, but can we talk about how garbage both opening statements were? Yeah, they were both bad. But the problem was, I think, because the defenses was so bad, the prosecutions comes out ahead. I mean, because the
it's just a real missed opportunity for the defense to score some real points there.
Yeah, because it was their job. The jury is not lawyers, and so it was the defense's job to point out how bad the prosecution's opening statement was. Maybe we should have
not to outdo them.
Right. Maybe we should.
You thought that sucked. Catch a load of this.
Maybe we should have known it was going to be bad when the quality of their argument around the videos was coming up, and they just failing to hit on these critical elements of the case. Your Honor, these are not fair and accurate representations. It's showing these people staying in one position for the entire time when they weren't in that position.
All right, Mr. Martin, how'd you do? You all set? You good?
Thanks to Trish.
Oh, good.
Thanks to Trisha.
Awesome.
I've
Definitely
just got
doing
done
something
talking
good.
to the President of the
That's
United
what it's-
States
okay.
about compromises we're trying to make moving forward on some bills.
Okay. Okay. You can do that. Now, at what point do you want me to read a stipulation?
As soon as I get seated,
Okay.
stay ready, then I'll ask you, I have to take the exhibit number 8 mark by identification, I'll hand you I have the steps over here.
Oh, okay. That's what I was going to say.
That's what she was going to say.
The weirdest that's what she said joke ever. Am I still boycotting Heaven Hill? Not actively, but I haven't been buying any Heaven Hill brands. Cannot believe the idiotic missed opportunity they had. Blue-eyed Roof Curry in the base says, Nick, look, if you want to watch the trial, just check out Law and Crime. Otherwise, please pay attention to See Goody and stop the show. His will/sarcasm. Justin Vincent says, if relevant changes in the time between an incident and trial, how relevant law changes, how does that work? I assume the defendant will be tried under the current law. Maybe.
The then current law, correct. So Florida's self-defense statute underwent a major revision in 2005. That's when Florida became a stand your ground state. They adopted a lot of new self-defense laws, like self-defense immunity, like presumptions of reasonable fear when defending your castle. And then in 2014, they made some more changes. And in 2017, they made some other changes. But the law that will be applied here is the law that was in effect on the date of this event, January 13th, 2014.
And
but it doesn't really change anything. I mean, at least the self-defense statute, the important parts of it that would be applicable here are really unchanged.
it whatever the law here is, in general, it's going to be the law under which the incident occurs is typically how it goes, unless there's some times in which a legislature will pass a law that will retroactively apply. Usually those types of laws are favorable to defendants, because otherwise it's typically against the Constitution to make a law that would go back and retroactively be harder for defendants to live under. But they sometimes will do the easier to live under defense. And then other times, what you'll have is a court clarifying a particular law through a court case going up to the appellate or Supreme Court levels of a state. And that can happen and clarify how the law is interpreted even after your incident. And that will control typically how the law, as long as it's not changing the law itself that you're under, but rather clarifying how the court interprets this law, that will be the law as it is at the time you encounter it, rather than at the time that the incident occurred, if that makes sense.
Yeah, it can.
Yeah.
When someone's going to claim it's retroactive in their favor, though, it needs to be pretty damn explicit. I mean, normally a retroactive statute will explicitly say it's intended to apply retroactively, and same with an appellate court decision that's actually making a substantive change in law.
Yep.
Because otherwise it's a huge pain in the ass for everybody. I mean, if it's retroactive, especially if people start petitioning to have retrials because they were tried under the old version of the law, nobody wants to deal with that. I mean, the person in prison wants to deal with it, but nobody else wants to deal with it. Lancelot
652 says Nick's going to be sending his youngest to college once this trial is over. Yes. Okay. Where was that? Where did we go? Where did it go?
So they have a non-bald guy on the defense team. Although he must be super unimportant. He never goes up to the bench meetings.
I was going to say that's their power. That's their power guy.
Is that Thunderbrook?
No. Yeah, I don't know. Might be.
No, I think Thunderbrook was different.
Not applicable says, would have made the fan meetup, but I had stuff to do. Sorry to hear that, buddy. Mr. Bentham says, having peanut butter and jelly in the same jar is a crime. I agree. Bearded Wonder says, peanut butter and jelly, step 1, tell your wife you want a sandwich. Step 2, sandwich appears. Jim in Ohio says, instead of law tube, I suggest junkyard law. Patrick Allen says, Florida versus Robert Hayes trial seems more fun on Law and Crime Channel B, ex-cop serial killer. Well, I'll have to check into some of that, but I'm not going to switch. Look, I like to do one trial straight through at a time. That's the best way, so people can kind of encounter the whole thing, in my opinion. Cynthia says, Nick, for the record, C Goody 564 is more entertaining than you today, and most days. I come for you, stay for him. Ahem. Good. I'm glad you enjoy him. That's why he's a mod here. Joe says, I put sugar on the peanut butter so the jelly spreads better.
Never heard of that, but okay. Whatever works for you.
No one's ever heard of that because that came straight out of hell.
Speaking of which, ironically enough, my wife's about to bring me a sandwich.
God, that's got to be great.
Yeah.
I was going to go heat up some food. Oh, I should have done that during the break. I might go real quick. Can you hold down for just a second? I mean, now they're there. The audio's on once it pops back. I'm going to go heat up a bowl of, I made some food last night. I'll be right back.
Okay. Sounds good. All right, folks, anyone interested in getting hard while Nick steps away? Law of Self-Defense, best-selling book, hardcover, autographed by me. I sign all of these personally. You can get this Beautiful book. Looks great on the bookshelf. Lawofselfdefense.com. Get hard. Or get the softcover version for free. We just ask you to cover the shipping and handling at lawofselfdefense.com/free book. And someone's trying to get my... That was my lovely wife, Emily, bringing me my enormous lunch. What? Yeah. All right, folks. So those were the two books. If you don't want to spend any money, you should at least get our free infographic on the law of self-defense, the 5 elements of the law of self-defense. Totally free. Doesn't cost anything. Just a PDF download. You can get this at lawofselfdefense.com/elements. So let's see if there's any. All right, not going to read that one. I got a chicken parm sandwich and a couple of meatballs, folks. That's the giant lunch. I'll wait till Nick is back before I start chowing down. Oh no, I'll get a seltzer. Thanks.
All right, we ready for them?
We're ready for them. Here we go.
Yes, good. Mr.
Them being the
Martin?
jury.
Okay.
And I'll ask you to read.
Oh, yes, thank you.
This will be.
Okay. Thank you, ladies and gentlemen. You can be seated. Welcome back. Can't see a couple of you, but Mr. Martin's going to use that screen here in just a minute. Were you all able to abide by my instructions during the recess? All right. Hopefully you got a good lunch and a little few minutes break. Well, I think we're ready to begin. Mr. Martin?
Your Honor, at this time pursuant to a previous stipulation, case exhibit number 1, which will be the raw video. At this time, I'd ask the court to read the stipulation instruction and the stipulation to the jury. And it'll be marked as identification at this point as A.
Okay. A for identification?
Yeah.
And ladies and gentlemen, I read you this instruction earlier, and I'm going to read it again. This is about stipulations. When lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true are: the state and the defense agree that authenticity and chain of custody under this stipulated order means that each of the below referenced items of evidence, 1, are what this stipulated order describes them to be, thereby removing any need to authenticate and or identify them pursuant to Florida statute, and 2, contain a fair and accurate representation of the data that A, the camera recording system within the Cobb Grove movie theater captured and the Cobb Theater preserved.
All right, so now we're gonna watch some more video. Just 4 videos.
Oh, okay.
Excellent.
All
I was looking forward to watching
We've
videos.
So I expect this will be the raw,
Dates
uncut
Exhibit 1, which
native
will be
video they were talking about earlier.
1-AWS, 2-AWS, and 3-AWS. And these are flash drives. Yes?
That's what we need. We need more approaching. You just were approached for several minutes. What do you still need to talk about?
I mean, Borkowski would just say, no, you can't approach. No.
Thank you.
Yeah. No, let's move this along. We've already been here for 6 years.
Statement moved, State's exhibit number A, marked for identification, and as State's exhibit number 1, pursuant to the stipulation, request permission to publish State's exhibit number 1.
You may publish, and it'll be admitted.
Imagine if it were that easy to get published, ladies and gentlemen.
And this time I have it on my screen as well, and that one, so I won't be repositioning.
Yes, Your Honor.
Astro Cat Pubes. Yeah, his what is that name? Yeah, his jaw is actually a calculus equation. What is the limit of my ability to not laugh as his jaw approaches negative infinity? Oh my gosh.
Your Honor, may I reposition myself?
You may. Anyone that needs to, go ahead.
May I position myself? Okay. Oh, so they can see the video. They want to see if they need to object to anything. Law Nerd Clip says, Happy Valentine's Day, everyone. Shared a clip of inebriated Rackets talking about how much he loves Lady Rackets. It's amazing. Also, Branca, I tagged you on my community tab with the Law Panel Rittenhouse bail outcome clip. So you can, if you...
I don't know what that means. He tagged me where?
You'll probably get a notification on your YouTube.
Okay.
Or YouTube Studio that'll, because I tagged you in a post and it'll show you, or it'll bring you there, and then that way you can watch the bail outcome.
Okay, cool.
Okay, so notice how you guys are supposed to notice that there are actual gaps in this video. Remember, the prosecution said you would notice that there are gaps in the video. Anybody would. We've seen about 6 gaps so far. Here's one. This is a gap. Gap.
Yep.
That guy kind of just casually walks over. Is that his son?
No, I think that's the off-duty cop who takes the gun
off-duty
from
cop.
him.
Yeah. Yeah, he did take the gun from him there. It's snowing in the movie theater. You know, it's beautiful Christmas miracle is what happened there. No, movie theaters have a lot of dust and crap everywhere. They're big rooms that are really tall. They don't really dust up high. There's dust in the ventilation. There's dust. And so when you have a concussive sound that makes everything vibrate in the room, crap will fall all over the place. And infrared cameras are particularly good at picking up dust because they're projecting out infrared light, and anything that reflects it gets picked up, even if you wouldn't otherwise normally see it. So. Ghost orbs. Yeah, lots of dead souls in theaters. They love a good flick.
Your Honor, pursuant to a stipulation reached by the parties at this time, the state would move into evidence State's Exhibit A and B marked for identification, and ask that you read the stipulation regarding State's Exhibits number 2 and 3.
All right. Are we on 2 and 3? I mean, is it B and C?
Yeah,
Okay.
but the stipulation covers both of them. So
Okay.
we're on marked for identification as B.
Okay.
Is she going to read another
All
stipulation?
right. And ladies and gentlemen, once again, I'm going to read you the same
All right, you want to step away for a second?
stipulation,
Oh my God.
instruction
Read us the
about
same
when
one.
lawyers
Why?
agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true is as follows. Let's see.
Wow.
All right, States Exhibit 2 and 3 are exhibits from previously stipulated video evidence which captured some of the interaction of Chad Olson and Curtis Reeves inside the Cobb Theater at various locations, including Theater Number 10 on January 13th, 2014. Further, the state and defense stipulate and agree the blue screen seen in States Exhibits Number 2 represents the time where the motion-activated camera system did not record any video. Further, the state and defense stipulate and agree the embedded timestamp seen on the video runs continually from the beginning to the end of the video. The timestamp includes the time the system did not record video as represented by the blue screens.
All right, this time the state would move Exhibit B, marked for identification, as State's Exhibit Number 2, and move State's Exhibit Number 2 into evidence. I would also ask that State's Exhibit C, marked for identification, be moved in as State's Exhibit Number 3.
All right, they'll be,
We have no objection.
Thank
to
you.
that.
they'll be admitted as
Okay.
2 and 3.
All right, may I publish Exhibit 2 at this time?
You may,
And may I relocate?
yes.
You know what everybody should do more often, all the time, especially in trials, is cough directly into the microphones that are everywhere. Please just cough right into them as loud as possible.
Did I miss the cough?
Yeah. You dodged the coof that easily. Yeah, actually, that guy on the defense team with hair has enough hair on his head and face to cover the two guys without any hair. So it's amazing.
You stole it. It's not an equitable distribution.
When they hired him, they all had full heads of hair. And his hair grew and theirs receded. So we're going to watch literally the exact same video, except instead of those pauses, there are these blue screens to indicate that there are pauses.
So I guess
Cameraman's so bored he doesn't even care to show the video again. Okay. I guess they just didn't want to, just aren't going to show it. So that's nice. Okay. Good camera work. Big Bro Tejano. Yes, this is the old guy who shot someone in a movie theater. You know what would be bad is if every time this guy saw a video of himself shooting the other guy, he chuckled. That would not look good. Don't do that. Yeah, I got him. Every time. Oh my goodness. Like he's kind of got a smirk on his face right now.
They need a thought balloon above his head.
Yeah, we could do that. Somebody just grab those and make a thought balloon meme. You thought that videos needed to be introduced through a witness. They do unless they're stipulated to.
Right.
And in this case, the parties have stipulated to the authenticity of the videos. But notice what the caveat or trade-off is. They don't have someone sitting there describing to you what's going on in the video. They present the video. These are the videos. We're stipulating that they're authentic. The reason people testify during videos normally, normal circumstances, not in Rittenhouse, but under real court circumstances, is they would be testifying to what's happening on the video as accurate to what happened that they witnessed. So they're comparing the representation to their experience. And that way the jury is then able to get, and whatever they're trying to get out of that. So how does this compare to the defendant's experience or the deceased experience, whatever they're looking for? They're able to try and get through someone else's showing that the video is either accurate or not accurate to what they remember. So that's why you normally get testimony during video, why you're supposed to, but that's not been what we've been watching in recent trials. In recent trials, it's just somebody who wasn't there testifying about what they see, that should be improper and it should be stopped because it's a waste of time. Oh.
Maybe he's just super high.
Curtis?
Yeah.
Could be. They do have medicinal marijuana in Florida. But I don't think it's generally legal there. Although he could just be doing that Delta 8 stuff. That's legal everywhere. For now. The defense attorney just dropped a yawn. As he should, by the way. This is horrendously boring. How long of a video is this? It seems way longer than the other one.
Somebody nudged the girl in the back there in the black shirt. Ever look up? looks promising.
Oh my gosh, we're only a third of the way through this video. I just saw a little progress bar on the bottom. Oh boy.
Maybe they can show this video enough times that we get another 8 years on the trial.
God. Oh my gosh. I'm exhausted. I'm getting more exhausted by the minute with these long video pauses. Like, why aren't the cameras showing the video?
We're only seeing the blue screen portions.
11 Bravo Crunchy says, Mr. Branca, I got a hard package in the mail last week that had your name on it. I thought it was going to be bigger. Thank you, sir.
lawselfdefense.com/gethard, folks. Every book, every hardcover is autographed.
There you go. Peter says, so what's up with the stipulated evidence being shown in this way without a witness attached? Is this a Florida law thing? No, you can stipulate. I mean, the judge may not allow the stipulation, but generally speaking, if both parties agree, judges are happy to let things work out most of the time, unless they foresee some real problem with it. Yeah, no, we talked about this during Rittenhouse and during Potter. It's like, why can't they just have stipulated to some of these things? And the answer is that it takes two to tango. And for whatever reason, it seems like, well, in Rittenhouse, they didn't want to stipulate to the fact that Kyle actually shot and killed Joseph Rosenbaum, because they
Right.
want to show the body over and over and over.
Yep.
If you stipulate that he was the shooter and killed him,
There's no more
No.
argument.
right? You don't need to show him, sucking his last breaths in front of people or anything anymore. But yeah, and so in this case, this video doesn't have a ton of value to either party. It's grainy and a million miles away and an infrared, so you can kind of see some stuff. They don't need someone to dramatically. They don't need to pull the dramatics out on it.
I will say that little lunge at the end when he fires a shot is not a good look for the defense.
Yeah, he kind of moves forward in his seat. But actually,
Legal
I
Eagle
can-
over there looks like he regrets his life choices.
he needs to adopt the Chadley sit. Those legs are too close together. You're on camera. You got a man spread a little bit.
Yeah, sit like a man.
I like his pensive face though. That's good. But I will say by physics, you're actually wrong. He didn't lunge forward. And if I'm the defense attorney, this is the argument I'm making. He actually lunged backwards. He recoiled backwards, but there was nowhere for him to go. So he was propelled forward
Well, that could be.
by the seat. That's what happened right there. The woman in the jacket is Curtis's wife, according to someone who says according to Law and Crime. So I don't know. Leather jacket is not the look I would go for. Not that it matters. It's just not what I would do.
People own leather jackets in Tampa, Florida.
Old people own leather jackets on the surface of the sun. You ever been in like an old person's house? House is 85 degrees and they're like, "Where's my blanket?" It's like, "Oh my God, how are you alive?" The guy there in the glasses on the left, at the top of the frame, he was the guy who looked exceedingly happy earlier on, but now he has headphones on. I wonder if he's less happy now that he's hearing what's happening at trial.
They're playing
Oh, boy.
sad music into his ears.
It's just an audio narration of Old Yeller. It is his wife. She testified in the stand. I wasn't casting suspicion on it. I took it at face value as the correct thing. He's listening to Recollection Law. Gotta be so funny. Someone just sitting there in court with headphones. Oh yeah, I'm using the hearing impaired function. Definitely not Bluetoothing these bad boys to my phone so I can listen to what's really going on at trial. Lady Melora says, "You're so good for my 57-year-old ego." Look, at 57, I know you're not sitting around in an 85-degree house with a giant heavy blanket on. We're talking actually old people with that one. I think. I don't know. Maybe you are. And I don't mean feels like 80, but it's actually 64. No, I mean legitimately hot. I've been in that situation. I'm like, how are you even in here? Because I get too warm really quickly. The Odyssey stream died. That's too bad. Unfortunately, there's not a way for me to personally restart the stream. It's not how when you're multi-streaming, I can't just kick it back up, but hopefully it'll get back up. I don't know. I have no idea what would have caused it. It was not my intent. I didn't even do anything to make it happen.
God damn it.
Wait, was that you who said "God damn it," or was that?
Yeah, I'm looking at
Oh.
the extended weather forecast for my Texas ride, and just when I get there, it's going to start raining.
Oh, yeah, that sucks. I thought maybe we got a hot mic of one of the attorneys. Why are we watching? Oh, this video is horrible. Chaucery and Fraud says the prosecution in opening said they were in the back row. Not quite accurate. They were in the back row of the non-bistro seats.
Right.
So there's a wall behind them. This is a general admission area that they're in. And then behind that wall is a separate section that has more expensive seats that you can order food directly to. You notice they're more of a love seat arrangement as well. You're a little closer to whoever you're sitting with. Yeah, I'm hoping the Odyssey stream pops back up. One day.
Watches State's Exhibit number 2 from camera 11. I'm not going to play State's Exhibit number 2 from camera 12.
Oh
which is a
my
different angle. And,
God.
There will be the same blue screens. There'll be like a 7-minute break and a 3-minute break, but that's
A 7-minute break.
Exhibit 3 or
no, ma'am. This is Exhibit number 2. There's
2?
right. There's 2 cameras, camera 11 and 12. And the
Oh.
last video on State's Exhibit number 2 in the API format will be a quad view, which will put them side by side so you can see
Okay.
them together.
So 10. Exhibit.
Oh, I should. This is going to be another brutal wait. I mean, this is like a 15-minute video.
Drink every time it's a blue screen.
Wait, do you have to drink? How do you do the drinking during the blue screen?
Just funnel it.
Just keep going. No
Keep
breathing.
Chugging for 7 minutes. There's the judge's mug. Valentine's Day mug, I guess.
And I forgot I should probably put like a little bit of a description in the title. So I'm changing the title to say Curtis Reeves movie theater popcorn shooter trial opening argument. And I gotta actually tag you in here. Law of self-defense. There we go. Save. So now, by the way, guys, if you are not subscribed to Law of Self-Defense on YouTube, you can click on his name in the description. It will take you right over to his page, and you can check out videos over there and click on any and all of those. And also, most importantly, that red subscribe button.
Always appreciated.
And if you're interested in this case, you got to check out yesterday. Andrew did a live stream talking about the legal issues that are present here. The procedural history of the case, I believe you covered as well. and kind of the posture of things going into today's hearing. So,
And I have to say, the opening statements for the self-defense immunity hearing were vastly superior to what we got for the actual trial, which is bizarre, considering it was the same people.
right.
Well, I guess it wasn't the same people. Now that I think about it, the same teams, but it was Mr. Chinless who did the opening for the hearing, and it was the shorter guy here who did the opening for the state, and then it was the defense lawyers. I think it was who was it? It was Bowtie here, right? I can't remember now. I think it was the other gentleman, not Bowtie, Mr. Escobar, Attorney Escobar, who did the opening for the hearing, and Mr. Bowtie who did the opening here.
Mickey Perdomo has a good reminder that it's time to remind people this is not a law and crime production. Actually, I have a helpful overlay that I'll put on the screen in just a minute to remind people that this is not a law and crime production. Not that I think anybody is actually curious or confused by this, but it is important always to have a reminder that law and crime is not associated with Recollection Law. You're not on the Law and Crime Show. And they are indeed the live feed that I am using, as is obvious by their watermark. But if you want commentary, legal commentary that is not only transformative, but is also handsome and fun, you come here. If you don't want that, please go watch anywhere else, including on Law and Crime, where you can watch just a trial with no commentary or anything else. That is what they do their own sort of post hoc commentary. You can listen to in separate videos. That's there as well. I think I've never actually listened to it, but I've seen thumbnails of it, so you can check that out if you want. But no, come here for us. They just are an easy aggregator of the court feed. Okay. I'm going to read some of these chats because we've got oodles of time. Crazy Warrior says, "You are ruining jury for me. If I get on a panel, I will be wanting to have your panel explaining WTF is going on in a trial to be awake. Thanks all." Sorry, brother. High Rule 47 says, "Do not buy Batman's cakes or milk." Oh, the milk? Oh, no. Patrick Allen says, "Chat, check Twitter at ATFHQ for hilarious Valentine's Day message." Hey, we actually did check that out, so that was good. Squeeze Louise says, "How much does it factor into the jury's decision that Reeves just kind of looks like a grumpy old jerk?" It depends.
Jurors are human beings too.
But you're also in Florida where everyone's old and the jury could be significantly aged themselves. Probably not. If the prosecution did their job in jury selection, they probably do not have a bunch of older jurors who would be maybe more sympathetic to the idea that he would have felt the need to defend himself from a big young man, right? But let's see. Samadamore says, "At Branca, Class 3+ handheld lasers are commercially available and can quickly cause flash blindness and up to permanent injury. Could a user of these be at risk of justified deadly force self-defense?"
Oh,
So I
you
guess-
mean if they're shining it in someone else's eyes?
Yeah.
Yeah. Well, I mean, if they're engaged in conduct that's likely to cause grave bodily harm to someone, and blindness would certainly qualify, then yeah, the person they're shining that at would be privileged to use deadly force in self-defense. The difficulty there is in proving that evidentiary foundation after the fact, because now you've shot the laser holder. There's no evidence that they were shining a laser in your eyes. Probably.
Unless you do go blind.
I guess. And they may use it for just a moment, turn it off. They may, the laser may be gone by the time the authorities show up. It's who knows.
However, the long and short is, if you have a laser, and particularly the higher power laser it gets, you are committing a battery, according to many courts, by having a concentrated beam of photons go and make a contact with someone. They have found that to be a battery. And they're even to the point where they're trying to expand that to say that a flashing image is a similar type of battery, but it is a battery, and which I don't necessarily agree on the flashing image part, but that's a Kurt Eichenwald thing, so we're not going to talk about it right now.
Right.
But a laser pointer to the eye is a battery, and if it causes blindness, you've committed a felony. So you need to be very, very careful with those laser pointers and the intent with which you're using them, and or the recklessness with which you use them. You could recklessly cause severe injury to people as well, and those could be felony acts. So I would be very, very cautious using a laser pointer. Treat it like the tool it is. Yeah, what the fuck with the flashing image thing? Okay, so Kurt Eichenwald is an internet idiot, former contributor to a whole bunch of different shows or whatever. He's a stupid man, a dumb man, but a hentai pilled man, though, I will say. Look, the tentacle porn tab that was open on his computer was just so he could teach his wife and children about tentacle pornography. But that being said, he allegedly has epilepsy, and then some users on Twitter allegedly sent him some flashing GIF images that allegedly caused him to have a seizure. And so he argued in Texas courts, successfully argued that a flashing image on a computer screen that was sent to someone via Twitter could be a battery. And the basis that they used for that was the idea that light emitted from a device like a laser pointer could be a battery as well. So his theory of the case there is that he was caused harm by this battery that was done to him. And under the Texas courts, he's allowed to make that argument. Now, whether a jury buys it or not is a different question. I don't know if that case ever resolved. But yeah. It's I do not personally think that you should be able to batter someone by Twitter by sending them a flashing GIF, but
I mean, I guess did the person who sent it knew it would have that effect?
I don't know. We also don't know if it did have that effect, right? Like, just have Kurt's word that it did.
Yeah, right.
His quote unquote, his wife got onto his Twitter account and said, "My husband is having a seizure right now," or something. Could be true. Could be false.
I'm ashamed that I actually know about that event.
Yeah. Britt Cormeyer. I think I missed this one earlier. Britt Cormeyer says, "What about the ex that reports even if you do not own a gun, but just to make your life hell, then they say, well, they owned one in the past, or I thought they had picked up one of those," about the ATF thing. Yeah. Well, hopefully they don't. I think false reports and false accusations need a higher amount of prosecution behind them, personally. The life-destroying power of a criminal trial. Alexander Smatrala says, "I need to see more evidence before I decide on this one. But if there's evidence of a strike, and since Reeves is old, isn't it a shut case already?" Maybe. I mean, only if the jury thinks he was in danger from the strike. So it depends what your definition of strike is, I suppose.
I mean, if you can, if you believe that he was struck in the head forcibly by a much younger person, and and then his hands continued to come in and out as if they were striking. Can the state disprove a reasonable perception of grave bodily harm threat beyond a reasonable doubt? I don't know. I think that gets iffy given the age disparity, the frailty of the victim. You know, he doesn't have to be right. He just has to have what would be a reasonable perception under the circumstances.
Right.
And the state has to disprove that beyond a reasonable doubt.
Ovid says, Your Honor, my client was just showing the deceased his gun so that he could see how cool it was. Then somebody yelled fire in the crowded theater. This is really a free speech issue, Your Honor. So there you go. Thank you, Ovid. Zombie Shoot says, I live in Florida. Went to a theater with no weapon sign. They saw the clip on my pocket knife and made me go back to the car to put it away. They never noticed my Glock being CCW. So there you go. Kevin Speaks on it, says, went to a strip club and no joke, Prego on stage 8 months. Wow.
It seems wrong.
Yeah. Andrew Hansen says, did the estate of the defendant who killed himself get the bail money back? We didn't have to post bail money. So it was a very petty drug charge. The lowest level felony drug charge you could have in Minnesota, just mere possession of marijuana above the legally exempt amount, which is 42.5 grams, I think.
I would say that's a good amount of marijuana, but I don't smoke it myself, so I don't know how much you would a habitual user would keep handy.
I think it's a little more than I think it's an ounce-ish, something like that. But Unknown says, why is Branca on the old guy's side? I didn't get the impression you were on his side particularly.
No, I'm not on anybody's side.
Yeah. No, I'm like I said, my bias in this case is I'm biased against the old guy at the onset, just on the face of the case by itself. I'm willing to be convinced, though. So far, after opening statements, I hate both counsel for the defense and for the prosecution. And I'm no closer to him being not guilty. I guess the testimony is going to matter.
I'd like to find this court guilty.
Yeah, this is atrocious. I really want to. I want to see his police statements contrasted with him on the stand.
I mean, wouldn't Judge Borkowski have made them just edit these videos, stipulate to editing out all this blue nonsense?
Yes.
Come up, get together, sit down, come up with a version that's acceptable to both of you, that's not going to make me and the jury sit through this.
Most importantly, me. I don't want to watch this video 19 times. Like, and there's a genuine question. Are they going to show this again and again? Are we going to revisit the blue screen videos? Like, look what we're watching here. This is what they want on here. Oh.
They're not waiting on anything in court, folks. They're watching a blue movie.
Yep.
So to speak.
They're watching a movie and there are long gaps of just a blue screen. Koi 540 says, if you had access to an idiot woke law professor's lectures, would you critique them? Could you legally critique their teaching? Yes, you can. Depends on, fair use factors, I would suppose.
That's
Depends on who took the video.
And the schools are so sensitive today about recordings. When I was in law school, I recorded every class, and it was never an issue. But
both cameras sync together.
that was pre-internet, folks.
Time frame is
Well, it's a while ago.
But the cameras pick up different times.
Oh no, are we gonna watch it again? But now together?
It was at that moment that Curtis Reeves first really regretted shooting Chad Olson. If I'd known they were going to make me watch these videos.
Oh my gosh. What does this have to do with the shooting? This part of the video. What does this have to do with the shooting? Oh my gosh.
And now they're gonna bring in 3 other views
Yeah, they are.
eventually.
Oh my goodness. I'm trying not to yawn, guys. I'm super tired because it starts early for me. But also this is, it's just so horrendously boring to watch.
Half an hour earlier, moving forward.
Oh.
8:30 a.m. their time, Eastern time.
Wait, what? Tomorrow? It's 8:30?
Every day is 8:30, except for today. They made it 9 because it was the day after the Super Bowl.
What? Why would they do 8:30?
Because they don't want this to be a long trial.
That's horrible. I gotta be up. Oh my God.
I'd say I feel your pain, except my pain's an hour worse.
I know, but okay, so an ounce is 28 grams. So, okay, so a little bit under, yeah, so 44.5 would be, 2 ounces. Well, closing in on 2 ounces. My client's amount was significantly higher than that. Although, interestingly, my client's marijuana had been used to produce a marijuana wax or resin, and there was virtually no THC left in the leaves. But that doesn't matter so much under the law. Interestingly, in Minnesota, you can, or at least at the time, I don't know if this is still true, it is legal to produce the marijuana wax or resin. It is not legal to have the wax or resin. And it may not be legal to have the amount of weed you would need to make it. But the act of making it is not actually illegal, which is kind of weird. So if police find evidence that you made that stuff, they can't really do anything unless you actually have it. DCV Titan says, when I mentioned the Edgecombe defense, I meant more that they're claiming the police didn't investigate properly. Yeah, I mean, a little bit. It doesn't seem like they're going to go as far into that one, but just maybe this,
I hope not, but they they have put quite a bit of emphasis on it already. And, it's kind of a traditional legal defense in a criminal case. If you can point to things the cops did wrong with the investigation and an effort to raise a reasonable doubt. But I mean, it's a self-defense case. So he's not disputing it was him. He's not disputing he fired the shots. I mean, those are the criminal facts here. What misinformation was created by this purportedly sloppy police work?
Right. And that was the problem in the Edgecombe case, was that at the end of the day, they're like, oh, well, this police investigation was not done correctly, but it was. They caught the guy who did the thing. Like the police's job is not to find an acquittal for the guy. The police's job is to collect the evidence of the event for the purpose of investigation and acquisition of the perpetrator, to then later be prosecuted by a district attorney. The district attorney gets to mount the prosecution. The police do not. So,
that was a shoddy a bizarre legal argument by B. Ivory and company. It's the police didn't look at this and didn't look at that and didn't talk to this witness, and now, well, so what? I mean, we got your guy. He says it was him.
Yeah. And it's all just about remembering the purpose of the investigation. The purpose of the investigation is to find the guy who shot other guy and bring them in for questioning. Mr. Steve VC says, you guys should open a law school, LawTube School of Law. Oh man, I can't imagine trying to get accreditation. Ugh. Johnny Stoffel says this wasn't homicide. It's suicide by popcorn. Blah blah 987 says thanks for wishing us happy Valentine's Day. It's the only one I've had this year. Sad face. Oh.
Yeah, I get actually quite a few requests to do law school type content, like do a criminal law class on the internet that people can, people who don't want to go to law school, they don't want to be lawyers, but they're interested in that kind of content. I just haven't had the
Right.
time to put something like that together.
Yeah, because you have to be really, really thorough.
Yeah,
do it.
it's a lot of work.
And
So
and
this-
also remember
This Saturday,
that-
I was going to do I decided I was going to do a live stream on Miranda rights because there'd been some case in which that was an issue. And I said,
Sure.
oh, I'll just kind of knock it out. And then the 2-3 days before that, I'm thinking, well, I really got to talk about this. And then I have to talk about that. And then I have to cover this and that. And pretty soon it was turning into like a law school seminar on Miranda rights. And I either had to put that much effort in or half-ass it. And I wasn't willing to half-ass it.
Right. And the other thing to consider is a lot of these topics, law school classes are several months long of several hour sessions, sometimes a couple times a week. And they, it's like you can't just merely do contracts or something on a YouTube video. You can give a basic overview, but to really get into like the law school element, you need dozens of hours
Right.
to cover some of these topics. Criminal law, you couldn't do, but even Miranda. I mean, there's probably a law school out there with a Miranda class
I'm
just
sure.
on Miranda rights.
I was just going to cover the original decision, but the original decision itself is super complicated. I mean, it was a 5-4 decision, but there were like 4 different dissents, and they're all making different legal arguments, and it just.
Yeah, it gets really tough to do that type of content.
I will say the dissents were really remarkably strong. I mean, we all automatically accept Miranda as being settled law at this point, but it was actually a very close decision, and the dissents were robust.
Bowtie Charlie says, if my grandfather could read the law and be admitted to the bar of Supreme Court of the United States, it proves the point. Successfully defended an accused serial killer in 1946. Very cool. Isaac Kazic says, a few hours behind, but I thought the defendant was guilty until hearing the prosecution's opening. Not guilty. Oh, just wait till you hear the defense's opening. Extra guilty. Mo Jorison says, which is more dangerous, corn pop or popcorn? That's a good question.
Corn pop for sure.
He was a bad dude. The Moonbeam Medium says, my husband eats lazy PB&Js like a sociopath. He puts peanut butter and jelly in a bowl, stirs them up, and then dips bread into it like it's chips and dip.
That is disgusting.
That is against all of God's creations. Yeah. Ugh. Leonard Clips. Oh, wait, I read that one. Context is racist, says Surreal. This video is from 2014. It is. Yes. The video we are watching is from a shooting that happened in 2014. Jonathan Bradley says, the little prosecutor looks like my cousin Vinny. I guess a little bit like a Joe Pesci. Walter Deadman says, that isn't dust. It's the dead souls of the generations that have lived, went to war, and died since this trial started. This video is killing me. I'm gonna
It's like the whole courtroom was bad and the judge put everybody into a timeout.
Yeah, gosh, I am trying to. Oh my goodness, I'm trying to stay awake. Corey Cast, welcome to Paralegal Status. Thank you very much.
You do that paralegal status thing. Is that like a membership function on YouTube?
Yeah, my memberships are paralegal, lawyer, and super lawyer level.
And so it's kind of like a Patreon type of thing then.
Kinda, yeah. Except on my, I think you get some emojis that are in there, but I don't push it that hard. But when people sign up, I do really appreciate it. It's just I prefer people to sign if they want to sign up for like exclusive stuff to sign up on locals. That's what I prefer. But the YouTube membership program is there. Oh my gosh. I need to like get up and do jumping jacks or something to stay awake.
Man, I think I need to make some coffee. You want a cup of coffee, Nick?
No, thank you. I appreciate it, but I'll be here. Oh, so how are you guys doing? I know this is the riveting content we all signed up for. How are you guys doing on this lovely Valentine's Day? Oh. Wow. Wow. I'm so tired. This isn't helping. Same here. I'm really tired. I did not get much sleep last night. And let's just say my eyes are thrusting themselves shut. No, Frederick Little, I did not watch the Super Bowl yesterday. I will watch Super Bowl at a Super Bowl party. Lady Raggets and I did not go to a Super Bowl party. Oh, good. The killing occurred. Finally. Thank goodness they have these bottom two cameras that showed so much. And thank goodness they've showed us these two cameras that they just spent this exact amount of time showing us a minute ago. Oh. Yeah, I know the Odyssey stream died. I don't have a way to bring it back. I think I just nodded off. I think I just did it. Alpha Fox Adam says, can I pay you like $50 to record a short video about ineffective assistance of counsel for my Crim Pro 2 class? Oh, I mean, if you want, I don't know. You want me to just talk about what ineffective assistance of counsel isn't because they all keep saying ineffective assistance? Is that what's going on? Okay. Let's see. Where the hell? Where'd this go? Corey Cast. Oh, I said that one. Welcome to Paralegal. UNSC forward onto Dawn says the defendant. Oh, sorry. The defendant looks like one of those SS camp guards who's been on the run for 60 years and is now being brought to trial. God, it's longer than 60 years. It's up to 80 now. 80 years for the camp guards or whatever. Because that was back in the 40s. Cameron Nelson says, when a court is this slow, as a lawyer, is it proper strategy to start a diet of hookers and coke after day one? Yes. Yeah, that's actually, that comes in your package when you get out of law school. And right after you pass the bar, you walk around like several different places, like the Bar Association. They hand you like a folder with a bunch of stuff in it. And one of them is just a guy named Jerry, and he hands you an 8-ball of cocaine and a business card. And he says, yeah, don't text. And then that's how you get the hookers. Loretta Silver member says he's chuckling to himself because he watches Recollection Law and is imagining the jokes you're making with the cameras on him. Caligulov says, my parents were just in Tampa doing renos on the condo in Clearwater a couple of weeks back, and it was 30 degrees there. Other times I've been there on Christmas in shorts and a t-shirt. Varies wildly from year to year. Yeah, it does. And from day to day. When I was in Dallas, 2 of the days were 70 to 78 degrees. It was magnificent. And then the next day when I left, it was in the low 40s, I think. Maybe it was in the low 50s, but I think it was in the 40s. Max Hines says dust was flying due to gunshot. Randy Cogburn says big hair guy in the audience looks like the bastard child of Rand Paul and Good Logic. Yeah, he does. Oh, I see it. I see it. Well, he's not on screen right now. What is still happening? The videos are done. What is still going on at this point? At this point, what difference does it make? Traina 26, welcome to Paralegal Status. Cats with Guns says, I passed out from sleep deprivation when this started, and then dreamt I was a vampire. I was running and hiding. Apparently your show is killing me. Yeah, me too today, buddy. Oh, God. I'm trying to stretch.
Man, I thought those, as bad as those openings were, as boring as they were, they just doubled down.
Like, this is horrible. This jury has to all be thinking about throwing popcorn at Curtis right now. What could they possibly be arguing over? They stipulated to this. The judge looks a little animated too.
Oh, you missed it on, were we watching? On Thursday, you were traveling.
Yeah.
They actually wanted to go into jury deliberations another day on Friday, and she had a fit. I mean, that's the only time I'd ever seen her not look like she was about to fall into a coma. But she was ranting and waving her arms and almost Barkowski level.
Oh, did he throw anyone's paralegals out? Your paralegals out. Why? Because I hate them. The jury right now they're all sitting there going, okay, what's going on? The video's over. Mike Missbach says the difference with a GIF is you are only sending data and the user of the other phone is receiving it and viewing it. Seems very different than laser. I agree. It does.
Well, laser's pretty straightforward. I mean, you're actually contacting the person with photons that you know to be damaging, right? Especially if it strikes them in the eye. So that's a pretty straightforward case. I would make the same argument for super loud sounds as well. I mean, that's a force. It's the force of the sound wave moving through the air. I can certainly see how that would qualify as a battery if it causes injury. But an image, a flashing image of normally harmless photons that's only has a harmful effect if the recipient is in some unusual medical state, feels a bit sketchy.
Automata says, not what I meant when I said play a blue movie. Mandy Karavichus says, Nick, could you do a Branca impression by grabbing one of your Warhammer books and then grifting it? I mean, I could. Oh, God. She has to decide on this evidence now that it's been published. Look at she looks nervous. Sorry, I didn't mean to blow into the mic there. Oh my gosh, what? What are you doing? Why? Ah!
We need a directed verdict and every attorney in the courtroom sentenced to 5 years.
Okay, Andrew, I need to order 2,000 copies of your books 10 feet above my head. That's what I need. Preferably in a lead safe with a baby grand piano on top of it.
I'm sure we have an extra pallet of books in the warehouse. Send it right your way. Airdrop it.
Please airdrop it with velocity, though. Air throw it down. Strike me down like that satellite that drops tungsten rods on Taliban houses or whatever.
Yeah, when I went to law school, the TV show LA Law was very popular, and the theory was driving a lot of people to law school. This case will have the opposite effect.
I anticipate you'll be using that.
Your Honor, due to the delays, we'd like to redo the opening statements, please. Remind everybody why we're here.
Who's your you got your next witness?
Yes, Your Honor. Nicole Olson.
Next
All
witness.
right.
Yeah.
First witness.
But see, we've all been sitting here so long, she thinks there's been about 55 witnesses.
I mean, it's 3 o'clock in the morning there, 3 o'clock in the afternoon there, and they're only getting to their first witness.
And their opening statements happened right away. They were done by lunch. First witness should have been at 1. What was the past 2 hours of time? Oh my gosh. I guess 1:30.
Oh, it's the daughter. Oh no, who is this?
Nicole Olson.
That's the wife of
wife,
Nicole
yeah.
Olson.
Do you solemnly swear?
Raise your
affirm the
right
testimony
mangled
you shall give in
hand.
This cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I heard she still can't make a fist with that hand. The middle finger is always extended. Oh my God, give her a phone book to sit on.
Catherine RUX says, off topic, did you see the video out of Las Vegas where a student beat another student unconscious and no one did anything to stop the assault? I did. That was wild.
Good. Okay.
Man, they have him so low in
Go
that
ahead,
jury
Mr.
box.
Martin.
Thank you. Good afternoon, Mrs. Olson.
Good afternoon.
Follow up. Is that
Would
No
you like
further
to go to a
questions.
movie someday with
Can you
me?
state your name for the record and spell your last name for the benefit of the court reporter?
Nicole Olson, Oulson.
Ms. Olson, what city do you live in?
OUL?
Land O'Lakes,
How
Oh
long
my
have you
God,
lived
this guy, this
about
prosecutor.
15 years.
Would you say you're getting sleepy?
there? Back in
Sleepy.
2014,
I
were
would
you
say so,
married?
yes.
I was, yes.
And your husband's name?
Chad Olson,
And in 2014, how long had you been married?
we were married in
If you paid me
2007
to talk in this passive
years.
tone, I wouldn't be able to do it.
Children?
Yes, one daughter,
In 2014, how old was she?
22 months or just under 2.
He's going to belabor this witness, too.
It's like that. What was that commercial? The most fascinating guy in the world.
Alexis,
Yeah.
It's like the most boring lawyer in the world.
In 2014.
I'm not always boring on direct, but
were
when I
you
am,
working outside the home?
I take
I
sleep
was,
medicine.
yes.
Where were you working?
At USAA.
And what did you do at USAA?
He's going to drag
I
this
managed
testimony
a
out
team of
until the end
insurance
of the day.
agents. So they issued and serviced insurance policies, and I made sure that they were in compliance and doing their responsibilities.
Oh,
And
she
if you
works for
could
my
ask
insurance
in
company.
2014, how long have you been doing that job?
I started in 2007, same year I got married, so about 7 years.
Are you still employed there?
Yes, I am.
Same position,
Yes,
same duties?
same duties, yes.
Oh my God, no promotion and
In 2014, was your husband Chad employed?
He was, yes.
And where was he employed?
Sky Power Sports, the name has changed over time, but I believe that's what it was at that year.
Sky Power Sports, is that a retail business?
It is, yes.
And what sort of merchandise do they sell?
Power sports.
Bikes and four-wheelers, maybe jet skis, recreational vehicles, sports things.
What was your husband's Chad's responsibilities or duties? What was his job there?
He was in sales, so he did the floor when customers came in.
You guys are great.
As
in
of
the chat.
2014, how long had he worked there?
About the same time, we moved over to this area around 2007, and that was his job since then.
Let me go back to USAA. On the campus of that business, is there a daycare?
There is, yes.
In 2014, did you take advantage of that employee benefit and Lexi was at that daycare?
Yes,
The significant date here is January 13th, 2014, so I'm using that date as a reference. Prior to that, how long has she been going to that daycare? How long have you been using that facility?
her whole life since she was about 6 weeks old, so just under 2 years.
Now, you mentioned that she was about 22 months old.
Yes,
Has she begun to get some teeth, cut some teeth?
fun times, yes, she was teething.
Yeah.
Okay, what do you mean by fun times?
Cranky, fussy, never knew from day to day or minute to minute how she was going to be acting or feeling.
Did she ever get fevers associated with the teething?
She did, yes,
Earaches?
possibly, yes.
I want to talk a little bit just about you and your husband.
I want you to talk about anything.
Would you do me a favor? Would you just stand up, please?
Yes, sir.
What?
All right. And how tall are you? About?
5'2"-ish. I have heels on, so maybe a little taller today.
And approximately how tall was your husband?
6'4", 6'5".
And you made that work?
Hey, careful. Lady Raggett is 5'3" and I'm
Let me
6'3",
show you
so
who's been marked for identification
6'2",
purposes
6'3", I don't know, somewhere in there.
State's exhibit number 2. Do you recognize that photograph?
Yes, I do.
And who is depicted in that photograph?
Myself and Chad.
I guess that's why she looks so short in the witness box. She is.
Okay.
Tiny, yeah.
In that photograph, are the two of you standing side by side?
We are, yes.
And using that photograph as a reference, does that particular photograph fairly show the difference in height between you two?
I believe so, yes. I was wearing flats and he was wearing probably sneakers or
And you come up to about where?
his shoulder.
His nipples.
You know, at this time, I've moved Clark for identification as State's Exhibit J and move it in as next exhibit in order.
Get a pre-
Admitted as Exhibit 4.
May I publish?
You may.
If I write on the floor?
Tasha Walden, I am 6'2". I might be 6'3" on some days.
Oops, went too far. I hate you, Jack. There we go. All right. Before you is State's Exhibit number 4. Who is in that photograph?
Myself and Chad.
All right. And you indicated that both of you were wearing flat shoes.
Yes.
And does that photograph represent the difference in height between you two?
Yes.
All right, and you're about up to his shoulder.
Yes.
Thank you.
Oh my gosh.
I'm sorry, I totally missed the table. I thought it was there. Taylor? Thank you.
Oh, if you guys want to know the difference between movie courts and real courts, here it is. Real courts are boring, slow, unpolished, horrifying.
What I'd like to do now is direct your attention to January 13th,
Oh, thanks.
2014. It's a Monday. It's a weekday. Had you worked the Saturday before?
I did, yes.
Your normal days are what?
Normally Monday through Friday, but as a manager, we have to rotate Saturdays on occasion, about once a quarter, and that just happened to be my Saturday to work.
All right. Did you have Monday, January the 13th off?
I chose that day off, yes.
Okay. Since the Lexi came into your life, do you and your husband Chad get many days alone together?
No, hardly any.
It's all about her,
Especially
right?
not now.
Okay. On Monday,
One is the loneliest number.
2014, did you have an opportunity to use the daycare center at USAA and so that you and Chad could have a day to yourself?
Yes, we did.
Let's just kind of take us through the day up until the new time hour, okay? All right. During, before you left the house, did you have any definite plans about what you were going to do that day?
I'll be right
No
back.
definite plans, no.
Just you want to spend it together?
Together, yes.
Okay. Tell me about Lexi. Was she teething?
She was, yes.
Describe her, I hate to use demeanor for a 22-month-old, but how was she acting?
Drooling and always wanting to put things in her mouth, kind of irritated, a little fussy.
She had been at the daycare before with those symptoms?
Yes,
Nothing new to them?
no,
Okay. Yeah, no problems then using the staff at that particular daycare center to take care of your child who was having these normal, I'll call them growing pains, teething?
as long as there's no fever, then yes.
All right. And if there is a fever, what is the protocol at the campus?
We would have to take her home.
And you would get a phone call to that effect?
That's correct.
About what time did the three of you finally leave the house and you drive to the campus of USAA and go to the daycare?
You know, I didn't have a specific time to be at work, so we just kind of gradually got up and got moving that morning. I don't know an exact time, but later morning, 9-ish approximately.
Before you left the house, were there any definite plans after you dropped Lexi off at the daycare?
No definite plans other than to stay close in case we got a phone call.
All right, so we leave the house and we drive to USAA. You drop Lexi off?
Yes.
And tell me that process. Did you just go in and say, here, run out, or what was the process?
Well, no, you have to badge in to get into the campus, and you have to badge in to get into the daycare. Normally, it's my routine, since she's coming to work with me, to bring her and pick her up. So I was the more familiar face there. But that morning, Chad got an opportunity to come, so he was excited to. He had been there before, but not as frequently as me. So we went in together, and he talked to the staff and went into her classroom and talked to her teacher. And we just kind of talked about what she was experiencing with the teething and, you know, just to be mindful of it. And we were around if needed.
Did I miss everything important?
No.
While you're still
She's still dropping her kid off at daycare.
Are there any plans made? Or was that later?
I failed.
Later,
My bathroom trip
All right, so
did
where'd
not
you
take
go
anywhere
after
near
you
long enough.
dropped off Lexi?
well, we decided to get breakfast at Cracker Barrel, which is pretty close by to my work.
Okay.
And we went and had some breakfast.
What did you eat? Have you ever tried
You
their
know
baked
approximately
apple
what time that
dumpling?
is? Breakfast time?
10:30,
Okay.
possibly, yes.
During breakfast, were there any discussions about what you were going to do with the rest of your day?
Yes, that is when we decided our plans.
All right. And tell us what the decision was. What were you going to do?
Well, knew we needed to stay close, so we decided to see a movie. But we had time prior to that starting, so we decided to go to the Wiregrass Mall and just walk around, do a little bit of window shopping, and just kill some time.
Is Wiregrass Mall
Kill
a
some
mall
time like Curtis Reeves will kill your
like we
husband.
had in the 80s where it's just one big box and all the stores are in, or is it at one of those outside malls?
It's an outdoor mall, and it was a beautiful day. That's part of why we decided to go there.
Beautiful day to die.
And after breakfast, did you in fact go there?
We did, yes.
Is it's boring a valid reason for an
Did
objection?
Chad have a cell phone?
Kind of.
Yes.
While at the Wiregrass Mall, was
Do you have
there
a
an
cell phone?
occasion
Do you have
when
my
Chad
phone
showed you
number in your cell phone?
something on his phone
Would
he
you
wanted
like
to
it?
show you?
Yes.
What did he show you?
It was a football meme type joke. It was just a kind of a conversation between different quarterbacks where they were picking on each other and kind of bickering back and forth. I did not take it to be a real conversation. It was just made up, kind of funny about how many Super Bowl rings I have compared to how many you have, things like that.
I think I remember that meme.
A little bit,
A little bit of entertainment.
right? Yeah.
Well, let's talk about the movies. How often do you and Chad go to the movies?
We went
Keeps
quite
asking
often
in the
prior
present
to Lexi
tense.
being born. Since Lexi was born, I'd say a very few.
And what is it about the going to the movies outside the home that is attractive for that type of style of entertainment to you and Chad?
It's just family fun, just some quiet time where we can, kind of get close together and spend some time together.
Imagine the
and enjoy
defense. You said it's
something that
family
we
fun,
have in
but not
common.
all the family, right? You left your daughter with someone else.
From the Wiregrass Mall, did you have an occasion to go to the Cop Theater at 6333 Wesley Grove Boulevard, Wesley Chapel, Pasco, Florida?
We went to that theater, yes.
Okay. Had you made a decision before you got there as to what movie you wanted to see?
We did, yes.
And what movie was that?
Lone Survivor.
Before I ask my next
Once
question, can you say no
arrived-
spoilers,
well,
please?
Do you recall approximately what time the movie Lone Survivor started?
I believe 1:20-ish, a little after 1.
And you got there before then?
We're always early to everything, so yes.
Okay.
Oh, come on. See, I have a bad
You and
joke
Chad
there
go up to
too.
the- I guess it's an outside ticket window.
I believe so, yes.
Did you buy a ticket?
Yes, 2 tickets.
Someone
for
asked,
Lone
how do you-
Survivor?
Yes.
Someone asked, how do you approach
Once
Cross
you
with her?
purchased the tickets
Pretty
and you
carefully.
went inside.
Very sympathetic
you
witness.
At that time, learn what theater number within that megaplex complex of numerous theaters,
Yes, there's an assistant in there that tells you and points you in the right direction.
and it was at theater number 10.
It was, yes.
What I like to do is take you through. Well, first, when you go in, is there a lobby?
There is, yes.
Is there a concession?
Yes.
Prior to going to theater 10, did you and Chad take advantage of the concession and purchase some snacks for the movie?
We did, yes.
After you purchased the snacks, did you make your way to theater 10?
Yes. Maybe a bathroom break, I don't. But yes, we did make our way to the theater.
What I'd like to do is take you through going into the theater and the selection of the seats and where you sat. Okay, that's what we're going to talk about next. When you came into the theater, did you notice the lighting conditions when you arrived? When you first walked in, and you walk in, okay, there it is. What was the lighting?
It was dim, but you could clearly see, where you were navigating to your seats and get situated around you.
Were there stairs that provided you access to the various levels within the theater?
Yes,
Could you see those stairs?
yes.
All right. Were there other patrons within the theater when you first arrived?
Very few, but I believe so, yes.
With the lighting conditions when you first came in, could you see those individuals?
Yes,
Could you make out gender, male, female,
yes,
color of hair?
yes,
If one had a red shirt, a blue shirt, color of clothing?
yes.
Wait, did you
When
arrive
you
before
walked
the
in,
lights
was
went
there any
down, though?
Previews playing. First walked in.
Not what I consider previews, no. Maybe something on the screen, advertisements, maybe, but
Make you
not
hungry to go buy food.
food. Yes,
Yeah,
but
okay.
not advertisement or not previews that I recall.
Was the sound system loud, soft, normal? I don't know how else to describe it.
Normal. I don't recall.
Why don't you
any
just ask her how she
specifics.
would describe it? Because it's an open-ended
Once
question.
you walked in, did you
Even his co-counsel's asleep.
decide
Look at
where
that
you
guy.
wanted to sit?
Yes,
And
Chewing
is
his
there
nails
a
again.
particular location when you go to the movies that you like? I always have to be the aisle. I always have to be up front. I always have to, you know what I mean?
kind of, yes, but not specific seats that we had to be. We would take into consideration if somebody was already in that area, then we would flex, but we like to be up top,
All right. And so you followed your routine?
pretty much, yes.
Did you walk up the stairs?
Yes, we did.
And did you choose the row that was going to be your spot for the day?
We did, yes.
Did you choose the row that you chose?
Because you wanted to die there.
Theater is at the, when you said the top.
Do you regret
is
not
there a
choosing just
wall
the
and then
back
kinda like
row?
a restaurant, I'm not a restaurant, but an eating area above?
A Cine Bistro is what I believe they call it, yes, as you described.
From that, and from the Center Bistro, the general public can't get there, right?
Right. I think there's a whole separate entrance for that.
So let's talk about from that area, is there a row of chairs that butts up against that wall?
Yes,
Is there another row?
below that, yes.
All right, which row were you in? The one that butts up against or the one down?
One down from the very top.
And to what area did you finally make your way to take your seat? Approximately.
Pretty close to the middle, but probably a little off
Take your
center.
seat.
When you first sat down and the seats are kind of in the middle, one row down from the wall,
Yes.
was there anyone seated behind you?
Not that I noticed at the time, no.
Now, Chad had showed you something funny on his phone while at the mall. So I want to talk to you about once in the theater. Can you tell us whether or not your husband, Chad, retrieved his phone from wherever he keeps it and was using his phone for entertainment, whatever he was doing?
Yes, he was.
Okay. When you first sat down, there was no movie or previews on this.
Correct.
As you sit there and people come in and out, was there anyone seated in front where you sat down, or after you sat down, did anyone come and sit down in front of you?
Yes, there was one specific person that I remember.
Which one was it?
Oh, I'm sorry. In
Was he
front of
there
us.
when you got there, or did he show up later?
Oh, showed up later.
Okay. Did your husband, Chad, have any contact with that individual?
He did, yes.
Did he yell at him too?
Explain to us, we'll talk about a little bit about maybe what was said, but just what was the interaction between the two of them?
The other gentleman initiated the conversation, and it was just small talk. It was about different movies that were coming out, what other movie theaters in the area that they liked. Something about an animated movie that Hong Kong or King Kong, something to that. Just small talk, friendly.
King
friendly
Kong,
talk.
Hong Kong, ping pong.
About how long did that last?
Hard to say, probably a minute or two.
Were
Couple minutes.
other patrons also talking within the theater? You might not have been able to hear the words, but you could hear the voices.
I don't recall.
Okay. What I'd like to do is, let's go through a series of photographs, okay? And let me do that. It takes just a few minutes. I'm going to show them to you. The best way I would like to see them. Okay.
Oh my gosh. This is one of me in a swimsuit at Cabo San Lucas. How's this one for you? Here I am in a swimsuit again at Club Med.
Got a timeshare at Sandals.
Oh. Peter Griffin. Yeah, this is a picture of me at the timeshare. Yeah.
May I approach the witness and bring these to the side so we can lay the proper predicate, and I'll ask the clerk to sign it. That'll be all right?
Bald cop spotted. there's always 50.
Judge, we don't have a need to do the predicate. We agreed to them coming in.
Okay, thank you.
Okay. With that,
Can you read the stipulation instruction again?
All right, so let me come back over here.
I wish I would have told you earlier.
Thanks for wasting everyone's time.
Your Honor, I have a series of 8 by 10 photographs with a corresponding poster board. The items are numbered so that the photograph and the poster board are one numerical part of the same JPEG number. So at this time, marked for identification, it states exhibit number E. I'm sorry, let me take this off. I'll do the photographs first. The
Okay.
photograph that states exhibit number D marked for identification, and states exhibit number E marked for identification. Both of them are JPEG number 2081427.
Oh, man.
At this time, I would move states exhibit.
Squizgar says, Rackets, your streams are getting me in trouble. I was on another more uptight stream and made a final solution joke and got tissed. Don't do that.
You're gonna admit both of them?
Yes, that's.
Okay.
Razor390 says, I once whispered to my buddy during a college lecture and got passive aggressively shushed by someone in the row behind me. When I heard that, I shushed back harder and everyone thought they were rude one.
Correct.
Checkmate, no shots fired.
The photo's 5 and the poster's 6.
All right, the next photograph. And,
Eugene says, well, in all cases you reviewed in recent months, only the Edgecombs one seemed to be the one where the prosecutor is not a lying SOB.
marked for identification I, photograph and an enlargement, JPEG number 2060324. Next in order.
7 and 8. They'll be admitted.
Yeah, he kind of sounds
Photo
like Dak
7,
Shepard.
Poster 8.
The next will be photograph and a poster.
Oh, wow.
Stakes exhibit Q and R. I know they're not in order, but.
It's okay for identification.
I'd
I'd like to introduce Pixel Z for identification.
JPEG number 2060444.
Okay, that'll be 9 and 10. Photo will be 9, poster 10. They'll be admitted.
Yeah, that bailiff looks like he's watching old episodes of Sister Wives on his monitor. Hey, man's got a dream.
But now he kind of looks like he's looking at me. Don't trust it at all.
And G
Uh-huh.
with the same JPEG.
F and G. Get it?
All right. Photo will be 11 and poster 12. They'll be admitted.
Thank you.
I need someone to kill someone in a lively state. This is Florida. You'd expect there to be some characters in this trial, but so far. This trial is very breaded right now.
And may I publish the exhibit?
You may.
May I have the witness step down?
You may. Carefully, please.
Okay, I guess she's going to go point out where they sat.
May I, Your Honor?
You may.
Oh my God.
Before you is,
Can you please count off each of the seats in this photograph?
Do you think it would have been a better idea to sit in this seat? How about, this seat?
before you is State's Exhibit number 5, we talked about when you first came in, and that you took your seat. I'm not suggesting to you that this is the lighting conditions at the time you walked in. Its sole purpose is for us to get a layout of where the seats are within the theater. Okay, so in looking at this, you indicated that you kind of had a preference that you kind of like to be up.
Jesus, I feel like I'm Gage Grosskreutz. I'm going to fall out of my chair on camera.
With the Cinebistro. All right. So first of all, using State's Exhibit number 5, show us where the Cinebistro is.
That would be this above this wall, anything up in here, these seats. In the back.
You
And
believe the wall
general
should be 10
ticket
feet higher?
holders from the general seating area do not have access to that.
Not that I know of.
Now, we talked
Are you
about
saying
that
walls
had
are
a favorite
effective?
spot. Of course, now we know you can't get into the Cinebistro.
Walls work.
In the general seating
Racist.
area, you indicated you were 1 row, 2 rows down from the wall. Show us where the wall is.
This is the wall, this tannish area.
All right. And with the pointer, approximately where your seats were.
It's small, but we were not in the very back row, so we were 1 row up and then approximately middle. And I'd say right around this area.
Thank you.
Do I think, well, the defense will cross today? I'm not sure if the prosecution's going to get done with their direct examination of her today. And we have spent inordinate amount of time doing nothing.
Let me show you State's Exhibit number 6.
Please don't.
We talked about the stairs that gave you access to go up to find your seats. So using State's Exhibit number 6, go ahead and orientate us. Where's the wall for the Cinebistro?
Blackish colored wall.
All right. The stairs that you use to get up to your row.
Mr. Martin, if that is the second set, that, the poster would be Exhibit 8, the photo would be 7.
I apologize.
That's okay. I just want to make it clear for the record, if that's the second group, which I think it is, from what I saw.
Yeah, it's the problem, 8 numbers.
Yeah.
All right, may I just have a moment then, Your Honor?
Oh,
8 years to prepare.
I'm not suggesting that you take anything out of order. I'm just trying to clarify.
Well, I understand.
Oh my God.
All right.
Okay, this is good. This is a good question from
The photo on the screen is
Rocksteady.
the
Says,
same as
serious
the
question.
poster.
Is this foundation
So that's
necessary?
7 and 8.
No.
And
No. What do we need? We
What's
know where
the
they're
point
sitting.
of all this?
We know she was at the theater. Like, were you at the theater that day? Did you go in? Did you watch it?
Stairs that lead you up.
You don't show us the stairs
Now
you
we have a
walked up.
relationship
Can we
with
talk
you
about the
all.
daycare some more and her baby's teething?
Down from the back. So this row here.
Now, when you arrived, we talked about the lighting conditions and what you could see. No problems going up the stairs. Okay. Let me show you photo 8 and poster board 9. JPEG 206444. Now, we got the general area for the seating. We have you going up the aisles, up the stairs. Now we need to get down an aisle. All right. So do you recognize State's exhibit number 9, the photo board that's up in front of you?
I do, yes.
All right. Orientated so we know where the wall for the centerpiece room is.
Here,
And you were in what row from there?
not the first one, but the second one down here.
Oh my gosh.
Now, from this photograph, do you recognize an item that is depicted in the photograph, the item that you use when you eat popcorn?
I do,
All
yes.
right, what do you use when you eat
I
popcorn?
always grab napkins, a
All
big
right.
handful of napkins.
All right, and do you see that in the photograph?
Yes.
All right, would you go ahead and show that to the jury, please?
Be right by the drink.
Now, would you have that on your left side or your right side?
Oh, the on the left side.
Okay, and that was your seat.
Yeah, it's my seat, yes.
Next to you, either to your right or your left, which side did your husband sit on?
To my right.
All right, did he have a drink?
We shared a drink. Yes.
All right, and do you see a cup in that general facility that represents that drink?
That's right here. Green
All right.
with the blue logo.
And that's where Chad is seated.
It's to the right of that.
Let me show you Stacy's exhibit 11 and 12. Let's use number 12. All right, so general stairs, got you down the aisle. You mentioned to us in the last exhibit that there was a tissue. Do you see the same tissue?
Yes, right there. And the cup holder.
And the cup that you mentioned?
Yes. To my right.
Which seat were you in?
This one right there.
All right, is that where Chad was?
No, this was where I
Oh,
was.
I'm sorry. Yes, that's where you
Chad
were.
was here.
All right, very good. Now, do you see an iPhone depicted in the picture?
I do, yes.
Do you recognize that iPhone?
Looks familiar, yes.
All right,
Why didn't the
Yeah, we
defense
can say
object for
that.
relevance? You don't want to really burn
based
object.
on the evidence
Not that you have a
he
limited
believed
amount,
it
but
to
you don't
be
want to sit and
sensitive.
object to the widow.
Is that the cell phone that he was using and not only at Wiregrass, but after you first came in?
Yes.
And the popcorn bag on the floor here, was that yours?
That was, yes. Me and Chad shared it and I had set it down at my feet when we were done.
Okay, very good. Now I'll pour it back, and then you may take your seat, and I'll put everything away.
All right. Aren't we glad we did that? Now she's going to go sit down. Dude, This is unreal. What is he doing?
We got an idea of where you were in the theater. You told us about Chad's interaction with the gentleman in front. At the time that your husband Chad was interacting with the gentleman in front of him, to your knowledge, was anyone seated behind you?
Not that I know of.
Should have missed trial if the the jury slits their wrists in unison. It shouldn't
Time
be.
passes a little bit. Does Chad leave the theater for some reason?
He decides to go get some Twizzlers, so yes, he does.
Some what?
Twizzlers.
You got to lean a little bit forward. That is
Twizzlers.
Twizzlers.
Okay.
Twizzlers.
All right. About how long is he gone?
A few minutes, 5 minutes or less, I estimate.
He eventually returns?
He does, yes.
While he is gone, to your knowledge, does anyone come in and sit behind you?
Not that I am aware of.
He comes back with the Twizzlers,
Yes,
whatever they are?
yes,
Okay. Sits in the same seat?
yes.
Let's talk about the cell phone. Once he comes back from the concession and has his replenish his snack supply, does he begin to use the phone again?
At some point, yes.
Now, is he making calls on the phone and talking to someone on the phone?
No, no noise.
You know, you've seen your husband use the phone for, I'll call it entertainment purposes or whatever. We know we can scroll on it.
You can say
He
porn.
does that. Is it normally in his left or right hand? And how does he normally do it?
Oh, he's right-handed, so he would hold it in his left and type or scroll with his right hand.
And is that what you saw him doing?
Yes.
Do you know what he was looking at?
Other than the football meme, I couldn't tell you what else he was doing now.
All right. I want to take you to the time that all the commercials are off and we start previews. Okay, that time change. Before the previews begin, do you know if anyone came in behind and sat down behind you?
I don't recall what time. I did not notice.
After the preview started,
Stealthy old
were you
man.
aware of anyone sitting behind you?
At some point, yes.
At what point?
Talk about the previews a little bit. We've gone from when you first arrived and all the commercial stuff to the previews. Did the lighting condition change at all?
Yes, of course it did.
It was constantly changing depending on the light from the screen, and yes, it possibly got a little dimmer.
At
A
the
little
time of the
dimmer.
previews, did the lights go down?
I believe so, yes.
While Chad was on the phone, could you see the light coming from his screen?
Yes,
Did it
The
annoy you?
previews start playing. Let's talk about that experience, okay? Does the sound level within the theater change as far as the audio that's being played for your enjoyment?
yes,
It goes up?
I would say so, yes.
After that change, did you and Chad have an opportunity to speak with one another? Could you carry on a normal conversation? That's
Oh,
what I'm
yes.
asking
Yes,
with that change in level.
yes,
Chad
With
never
that
could carry
change
on a
in
normal
level, can you tell us
conversation.
whether or not you could still hear other people talking?
yes,
When we talked about could you hear other people talking, could you
The previous
determine whether or
question.
not they were 4 or 5 seats away, 10 seats away? I'm trying to get a distance, based on chairs.
yes,
Oh my God.
You could hear the people talking?
yes,
At some point you couldn't.
yeah,
Okay, fair enough.
Okay.
The previews are playing, so we have the audio. Now we have the lighting. The lighting went down a little bit, right?
yes,
Were you still able to see Chad next to you?
yes,
Could you see the gentleman in front of you?
Yes,
Were you able to see the people that were several chairs away from you in the same row?
yes,
With that lighting condition, could you determine whether or not they were male or female?
yes,
Could you determine, in a general sense, the color of the clothes,
yes,
color of the hair if they weren't wearing a cap or something like that?
yes,
Now, the gentleman in front of you, you could see, right?
yes,
Could you see the gentleman behind you?
Were people, tell us whether or not people were still entering the theater as the previews were being played.
yes,
Could you see them come in?
yes,
And you showed us the stairs going up each side. You were in the middle.
yes,
Whether they were to your right or to your left as they came up, could you tell whether or not they were male or female
yes,
to a general extent?
yes,
Okay. The people that were patrons in there, could you still see body movements? Let me just give you an example. I'm not saying it occurred, just as an example of what I'm looking for. If someone's sitting
Is
in a
there is
chair
part of the
and his arm is
prosecution
moved,
the
like
idea
you
that he's able to
taking a
clearly
turn
see
this
them?
way. I'm
Like,
looking
because
for body movements. Could you see people's body movements?
I
Yes.
don't get this line of questioning. It was part of their opening argument. What am I missing on the fact that they can all see? Is it just that the light shouldn't bother him so much? I mean, is it that simple?
I think during the
There
for
comes
the
a
opening
point
for the immunity hearing, one
where
of the arguments
you
the
have
defense
this
made was that
feeling,
Curtis Reeves was just seeing
sense, whatever, that someone has
Chad's hands come at him repeatedly. First to strike him in the head, then to go for the
Tell us
popcorn and to draw back,
how
then to come
you
back
made
in
that
again.
determination.
throw the
Now I know
popcorn.
someone's
Um,
behind
and
me.
the bad
What took
lighting may
place?
have allowed for
What
a,
was
even
it
if
that led
mistaken,
you
but
back?
reasonable perception that it was an ongoing series of blows.
you.
So maybe they're trying to undermine that
heard a
defense
statement
argument.
that was made, and you also just.
Although I don't recall the defense making that argument in its opening
on
today.
my peripheral see
Yeah.
somebody very close to my right and behind me. You just kind of sense them. You just, based on the sound, you know that they're close, and you just can tell that they're close to you.
Do you know how many people sat in behind you?
I was only aware of the one.
At the time that that person sat behind you, were the previews for movie trailers playing?
Yes,
Was the lighting what we talked about a few minutes ago,
yes,
which included whatever ambient light was flickering on the screen and bouncing into the theater,
correct,
which you said changed depending on the scene.
correct.
After you became aware that someone was behind you, we had the previews playing, was your husband, Chad, was his phone out?
Yes,
All right. Was he talking on the phone?
No.
Making a call? All right. Did he have it like you explained in his left hand?
yes.
What did you see him doing?
Just the light low. He wasn't holding it up or waving it around. It was just kind of lower in his lap.
Did you tell him to knock that shit off?
All right.
Stop being a dick.
I want to take you to the point of time where you are aware of whoever is behind you having contact with you. Okay, that's what we're going to talk about.
What
So having that
contact?
as a reference point,
He's
and
they're
you
gonna
know
hammer
when
on that phrase, even though it's not.
you only
I
know
hope so.
came in and sat down behind you.
No, I meant the
And
prosecution
so
is gonna hammer that
where
phrase.
Yeah,
there
yeah.
was- we'll get to the type of contact, but where there was contact. You know about how long that
We'll
was?
get to the type of contact later.
I'm sorry, from what point until?
First, I want to say contact
First
50
sit down
times.
behind you,
Okay,
and then first contact.
okay.
About-
No, I have to clarify. I don't recall them coming in and exactly when they sat down behind me. All I know is the very first contact when he was,
Okay, you just knew there was someone behind you, and then all of a sudden. there was
Right.
This is almost as bad as B. Ivory's, correct?
Yeah.
Let's talk about that
Correct.
contact.
Why
First,
do
I
people
wanna
feel the
talk
need to
about
take a gun
your-
into a
your
movie theater?
observations visually And then we'll talk about
Aurora, Colorado. That guy
Just
shot up a
separate.
bunch of people. One person with a gun could have put an end to that.
Yeah, I never understand that question. Why would I carry a gun everywhere? Why would I leave it home when I go into a theater? What difference does that make?
I'm going to put State's Exhibit number 11 up.
Oh my gosh. What are you trying to get out of this witness?
You indicated to us where the tissue is where you were seated, right?
Correct.
Okay. And Chad was to your right.
Yes.
Let's talk about visually what you saw. Explain to us, we see where your chair is, we see where Chad's is, and of course there's a little bit of a gap. Which eye did you get the peripheral vision of someone was there?
On my right,
On your right, so it'll be towards
In
where
be-
the cup is.
in between me and Chad, yes, in front of the cup.
Okay. All right.
That question was for the gun control
To your-
nuts on the
to
jury.
your recollection,
Maybe.
was your chair touched at all?
Not that I recall, no.
At that point, did you know whether or not it was male or female?
Yes.
All right, and visually, how were you able
Oh,
to?
visually, no. I'm
Okay,
sorry.
visually, no.
Visually, no.
Just someone, a human head came into that area.
Yes.
All right. At some point in time, you heard something from behind you.
Correct.
What was said?
A demand to put the phone away.
Okay. Just based on your life experience, did you draw any conclusions as to whether or not the voice was male or female?
Yes, male.
Presuming gender.
Let's talk about the words that were spoken. The words were spoken were what?
Yes.
Or what did the man say? What were
Yes.
the words?
Yes, were the
Put
words.
your phone away now, or something very, very similar to that.
Words
Well-
to that effect.
Yes.
Okay, not those exact words.
Right. Not verbatim, but you need to put your phone away or put your phone away.
The message.
Could it have been, could you put your phone away? I guess you ask on
Yes.
cross.
Now, you had an occasion to hear the exchange between Chad and the gentleman in front, right?
Correct.
And then you heard the voice behind you, right?
Correct.
As far as the character and the tone of comparing the two, was the conversation Chad had with the man in front, that tone of conversation, was that different from what you heard from behind you?
Very different. Yes.
Okay, and how was it different?
It was just rude. It was demanding. It was like it was an order. It wasn't, excuse me, or would you mind, or an explanation that, the light is distracting. It was just very matter of fact, you need to do this.
Well, you do.
Based on your peripheral vision, how long did you have that person in your vision? One Mississippi, two Mississippi, that kind of thing, do you know?
Several seconds. Yes, probably more than 5 to 10, but it's hard to gauge.
All right. Did you
What does Ambien take to go to sleep?
Respond
The
to
prosecutor.
what the man said.
Yes, he did.
Listen real close, okay? When your husband responded, did you still have the man's head in your peripheral vision?
I can't say for certain.
Okay. How did your husband respond? What words did he say?
He says, "What's your problem? The movie hasn't even started yet. I'm not making any noise." Not verbatim, but.
Verbatim.
kind
What
of
did he
blowing
say?
him off, just kind of basically not.
Did he
not
use
turning around,
profanity?
Not acknowledging him.
Well, let me just take you through that a little bit. That's what was said.
Yes.
Did your husband, Chad, ever turn back towards where the voice came from?
No.
Nicholas Elliott, I'm dying
Can
here,
you tell
buddy.
us whether or not he made that statement while still looking at the phone, watching the previews? What was he doing?
Still facing forward. I believe on his phone.
But you're not sure.
Just facing forward, I just know he
But
is.
you know he didn't turn around.
Right, correct.
Did your husband use any profanity?
No,
We refer to them as F-bombs, any F-bombs being directed towards the man behind you,
No.
by your husband.
no,
Did he raise the voice to what you would consider to be, in your life experience, a normal talking level?
yes,
A little bit?
yes. It was louder than what you would expect in a movie theater, which is a whisper. It was louder than that.
Okay.
I don't know if I buy that.
Do you know if the man behind you responded to your husband's comments?
He did, yes.
How many times did he say
Was
the
that
N-word?
immediately after your husband said what you just told us?
Yes.
About how long? Again, one Mississippi, two Mississippi, I'm talking, how long was it between where Chad made the statements and then the man behind you responded?
Seconds. It was pretty immediate.
Okay. Do you recall what the man said?
Pretty much the same thing as the first time. You need to put your phone away.
The tone or demeanor, had that changed at all from the first time the man
I
spoke?
have coffee,
No, I
folks.
don't.
It's not helping all that much.
I'm
Was the
dying.
man behind you cursing?
No.
I've blinked to sleep a
Well,
couple
and-
times now.
I know.
Yelling is so subjective, but I mean, was
What's
the
up, Joe?
voice louder
Hey.
than be normal?
Oh, thank God somebody's here.
Yeah, I was
Welcome
just
to-
watching. I was just having a
Welcome
great
to
time
Ambient
watching
Hour.
some
That
paint
level.
dry,
It wasn't
and I
screaming,
figured
yelling.
I'd join you guys over here.
Okay.
Slow down my day a little bit.
No kidding. Screeching halt, more like it. We're going backwards. We're going back to
Oh
opening
my
statements.
Gosh, this is wife of the victim, right?
Yeah.
Yeah. Although today we're the victims.
This guy's face looks like
Uh,
a life version, like if a kid made a stick figure drawing and then you brought that to life. This is it would look like his face.
Okay, that's
It's like a perfect circle, little weird lines for
Let's
the
talk
eyes
about
and
what
mouth.
you were thinking at that point. Based on the tones of the conversation, the words that were spoken, what were you thinking? Were you afraid, scared that the man behind you was going to do something, or
Is
anyone
this
was gonna do
redirect or
something?
still direct?
What were your thoughts?
Direct.
No,
Still
I was
direct.
just kind of taken
Oh,
aback at how
jeez.
we were approached, but nothing stood out.
And they're not even close to
Really?
anything.
Agreed.
They're going to show her those videos, right?
Probably.
Neither one of them.
That's an
cursed.
hour's worth of blue screen right there. They're going to be continuing direct in the morning.
You were really taken aback at how you were approached. Your husband's got his phone on after
Well, I
it
take you to the
says,
point
and
where
someone says, "Hey, turn
um,
your phone off," and you're
you
taken
get the
aback.
sensation or become aware that the
Was
man
this
behind
during
you
the
has gotten
previews
back.
or after the
Use
movie
that
started?
time frame, okay?
Before the
Previews
movie
still.
started, but after they were told to
Prior
turn their
you
phones off.
feeling that, were there any other words by the man behind you directed towards your husband?
Yes.
And what was that?
He said,
asked me
do
for
I
my
need to
phone
go
number.
get management?
And apparently he did.
Yeah,
We've
the
been
guy wasn't
talking
going to turn his
about
phone
the-
off.
The tone and the demeanor of the spoken word when it was spoken. Had that changed at all when you compare it to the first two times the man behind you spoke?
It had not let up, so it was the same.
It was the same. Did your husband respond to that comment?
He did, yes.
And what did he say?
He just said, do what you need to do.
At that point, do you know whether or not your husband's phone was still out and visible? Was he using it like he was before?
I believe so, yes.
at the time that your husband made that response to what the man said behind him, did he physically turn and look at that individual?
No,
Do you recall where his sight picture would be? Was it in his lap, up in the screens? I'm trying to get a feel for where his attention was.
always forward. Mhm.
What does that even mean?
Did you have a sense after
was
that
always
comment,
looking
"Do I need to
forward"?
go get the
Well,
manager?
so he wasn't
that
looking at his
individual
phone?
left?
Yes.
What
I
was
think
it
she's trying to say
about
not turning around at
the
the
environment?
shooter.
What did you hear, see that led you to the conclusion that he left?
You
Or
just,
was he getting up to leave?
yeah, you just sense it. And then I actually saw him going down the stairs after he got out of his aisle and started going down the stairs.
Okay.
I think this trial may be the death sentence for Long Crime Network.
Oh, we're on long
Talk
crime.
a
Very
little
exciting stuff.
But after the
I feel so
third comment,
rebellious.
did you get the sense that your
Do you see my overlay,
husband,
Joe? Make sure people
breaking the law.
was
know that
getting
it's not long crime
frustrated,
stream.
agitated,
Uh.
annoyed?
Yes, I think they both were. Yes, I would say so.
Well, this way, there's no brand
So you
confusion.
finally see him go
That's
down
right.
the aisle, right?
We wouldn't want that. I legitimately hope to God no one
There's a
ever
time
confuses me
period.
with long crime.
Until
I feel bad every time I
wanna
fall
talk
asleep.
about what
I
you
think
were
they
chatting
might.
doing While he was absent. Okay?
Okay.
Now,
Get a cease and desist about
At that
falling
point,
asleep. You're
uh,
replicating our
you and
hosts.
Chad,
You're
began
replicating our audience.
the media experience with the trailers.
Yes.
Was Chad still on the phone?
No.
Did he turn
Do you
it
know
off
if the
because the guy was going to
screen
come back with a
light was still
manager and he
on?
was going to be a prick about it? I mean,
Uh,
come
I'm
on.
trying
You
to
know
figure
what's
His
going
phone,
on
not
here.
the movie.
Yeah, yeah, that's right.
Right,
And an
okay.
iPhone screen. Did you still see that screen light?
It was for a period of time after the man left the theater, but not for long.
Okay.
Shortly after, it was turned off.
Once the
I think this
no
prosecutor
phone
has this
light
woman's
light
photo in his
out,
nightstand.
Do you know where, what Chad did with the phone? What does it have? Keep it in his pocket, back pocket, keep it in the lap, just hold it in his hand?
Just kind of
What
hold
is-
it in your hand, setting it on the lap, usually.
Did you actually see it or you
Taped
just know
onto the
that's
face of a
That's just his
mannequin.
routine.
his routine? Okay,
And I did not see any movement to indicate that he had put it in a pocket, so
all right,
I came to that conclusion.
all right. And I guess one of the things that I need to put in the timeline, if you will. Do you recall that there was a notice up on the screen asking the patrons to please put away their phones?
I'm aware of it, but not from that specific movie. I can't say that I paid any attention to it that day, but I'm aware of, silence your phone or, put it away.
Someone say long crime only has
You
1,500.
indicated that
Oh,
when
5,100.
the man left.
Feel better than I
comments
thought they would
affected
be
what you
with the
gotta do.
content
So let's
here.
talk about
The audience is full, all dead people.
Chad's,
They're all hanging from nooses.
if he's.
Still watching going, why can't I die
Chad
faster?
make any comments to you that would be,
Is there an objection?
He just asked if they could approach. I don't know. Joe, what
Joe, is that your car horn?
Nope.
is that your wife driving?
I just live within 6 miles of other people. So
Your wife wants you to get in the car, Joe.
So Joe, I got to tell you, everybody's been making fun of me because I did a short video from my car yesterday, and the YouTube Studio app records it mirrored. So they're like, Nick's in the passenger seat, and they're just making fun. They're like, "What are you, Joe?" And I'm like, "Oh, come on."
Here we go. Yeah.
No, they're dumping on. They're like after
They're
you,
dumping on you that you were
They're like-
yeah.
They're like after you dared make fun of Joe, You scumbag sitting.
Oh,
in the
they're coming
passenger
to
seat.
they're coming to my side. That's what it is. They're saying that you were basically, yeah. I know your pain on that though, because I used to make car videos, and it always looks like you're sitting in the passenger seat. That's the mirroring thing.
Yeah. I'm glad you have my back on this after I've trashed you for months about it.
Because I'm a real friend. So go figure.
I will continue beatings until morale improves.
All right, ladies and gentlemen, we're going to take a short 10-minute recess. So please remember my instructions. And
It's 4 o'clock. You're not going to recess for the day? Oh my God.
They can go to the jury.
I've
pool
never
room
had a
if they
judge
do
whose
that.
hairstyle was
I
taken
just
from one of the
wanted to
main characters of
mention
Dumb and
that there
Dumber.
are
This is
designated restrooms for you guys.
this is really a first for me.
At all, deputy. Okay.
Judge Mullet presiding.
Did we give him the code?
I wonder if he approached because his client had to go to the bathroom or something. Because she did kind of skip
designated
the
restrooms
afternoon
for jurors
recess.
Is either back there or in the jury pool room, okay? And remember my instructions during the recess. Deputy, it's your call where you want.
Tomorrow,
Back
spectators are
here,
going to come in the
jury
court with those pillows you put around your neck to
Just
sleep
head
on an
back to the
airplane.
jury pool room, in 10 minutes. All right? Thank you.
So I only caught a little bit of the opening statement from the defense. What I took from it was basically any angry old man in a theater has every right to shoot anyone he wants. That's what I took, that the defense is going to bring forward people who are basically going to say that, hey, if you're old, so your brain is a little more shriveled, you're a little bit, you don't walk as well, you have a right to kill anyone who's in a movie theater who pisses you off. That's how I took his opening statement.
Yeah, that's not their argument, but their opening was extremely poor. So I can certainly understand how that was the message that came across.
Yeah.
But the actual defense argument here is that Curtis Reeves was struck in the head by Chad Olson hard enough that it seemed there was an object in his hand. Then Chad Olson continued a physical attack in the form of grabbing the popcorn and throwing it back. But to Curtis Reeves, it looked like more blows coming in. He's frail. He's elderly. He had his elderly wife with him. This reasonably appeared to him to be an attack likely to cause grave bodily harm, which would be the justification needed under Florida law to use deadly defensive force. So I'm not saying I buy that narrative entirely. I got to see more evidence, but that's the actual narrative of the defense. He didn't shoot him just because he was angry or just because he was disrespected over popcorn. That there was, the defense argues, a reasonable perception of a physical battery happening, likely to cause a frail victim grave bodily harm.
Yeah. It's but the thing you may have missed from the defense's opening statement was the absolute travesty that was the last, 15 minutes of it.
Felt like 50 minutes of it.
Yeah, it was very long, where the defense attorney just was I don't even know what he was just testifying. I mean, he was flatly testifying, not saying the
interpreting video.
He's interpreting video, telling the jury what to do, what to think, talking about saying now the prosecution is going to do this, like making arguments against them. It was really, really bad. There were 8 to 10 objections in a span of a couple minutes. And then actually the judge had to pull them up to, he was watching a video and then just saying what was happening on the video. Like actually just saying, now you see where the hand comes in here, that looks like this type thing. And then after the final objection and a sidebar, he came back and just played out the video with no more commentary. So the judge must have told him to knock that shit off. And then, it was eternal. And then the real fun started.
And then the testimony began.
No,
No.
Joe. That
What?
was 2 hours before the testimony began.
What happened then? What did they do?
They had 4 videos that were stipulated that were all the same video of the incident. And they played all 4 of them to the jury without commentary.
Wow.
And
most of the videos were blue screen.
yeah, each video had a 7-minute and 3-minute break in them
that they
of-
played through. So you had to
Yeah.
sit there and watch the blue screen.
Why? Why would they do this? Who thought this was a good idea? Why? This is where you need Judge Burkowski, who's going to
Yep.
basically step in there and say, "This, you're wasting everyone's time. Just skip to the next section.
It was
Let's stipulate that there's blue screen for the next 7 minutes and 3 seconds, and skip past it."
Yeah, and I thought it couldn't get more boring than that. And then the prosecutor got up and then the testimony started. And somehow this guy is able to, like, I'm longing for the blue screen video. I'm like, please bring it back. Please just bring back the blue screen video. Because his questioning of this woman is, we're just sitting here
interminable.
going, what
Was
is
your
the
daughter teething
point?
at the time?
I actually heard that part of it. I've been poking in and out of the chat here, and every
You
time I
work
turned
at
in here, I would
USAA?
I was like torn between like feeling pity for both of you for like sitting here for hour after hour and feeling like I should come pick up the slack, and then feeling like I don't want to do that. But then I was like,
Dude.
if I join, it changes the whole party, the whole dynamic here. It just changes. So
Oh, thank
good.
God
I'm-
you're here. I mean, I
thank
almost fell out
God.
of my chair.
I'm a
asleep
fuel
several
injection
times.
of life.
Yeah, you are.
I have actually blinked asleep a couple times, unironically, because I'm like,
Okay, here comes the
I
fake
mean-
epilepsy claims. Here we go. Oh, what?
no, no, it's not the fake epilepsy. It's the real. I hate everything that these that these people are doing. This is so. How do you make? I keep wondering this as I'm watching these various trials and going through these cases. I'm like, how can you make these stories boring? This is a former SWAT team guy shooting someone in a movie theater over a cell phone screen. How is this boring? His wife is next to him. Both of their wives are right there. It's like young versus old. You've got police versus people. You've got this idea of like privilege on the cell phone thing, privilege on the gun thing. You've got all these different narratives. You can pick any of them, any
Yep.
one of them. And instead you're like, did you walk up the stairs over on the left side of the theater or the right side of the theater? And then did you proceed to your seat in the movie theater? Where about on the picture was were you sitting?
Did you
Would
chat
you-
with the people in front of you about your favorite movie theaters? What are your favorite movie theaters? Could I have your phone number?
She's a widow, so there you go.
If the NSA were to tap into your phone from a subpoena, would I find anything good on it?
Have I shown you my beach photos?
The guy is it's horrible. It's
What
like,
movie? What movie were they watching?
Lone Survivor.
Lone Survivor.
What is that?
That's the movie about the it was a mission over in Afghanistan, I think. Where like a whole SEAL team got wiped out except for one guy, Marcus Luttrell. He became a pretty popular speaker on the right for a while. He was going on like Glenn Beck and Hannity a whole bunch, and yeah, he was the last surviving member of a SEAL team, and good flick. Mark Wahlberg is the actor who plays him. I enjoyed the movie. I enjoyed the movie quite a bit.
I mean, it was fine. It's mostly 90 minutes of him continuously falling down a mountain, is my recollection. But
Yeah, there's a lot of that.
Well, you
Because
also,
he'd
you
been
enjoyed the
shot
movie.
like several times. All his buddies get shot up and keep going before they die. It's like just a real testament to. Oh, and then he gets saved by a native Afghanistan family. Like the Taliban come looking for him
Oh,
or
wow.
whatever.
Thanks for spoiling.
And
So
yeah,
I appreciate that. You enjoyed the movie because you weren't sitting directly in front of Curtis Reeves. So that's
if
perhaps
if
why
I
it
was
better
sitting
for
in front of
you
Curtis
than for-
Reeves, I'd be alive and this trial wouldn't have happened.
That's true, I guess.
Because if he told me to put my cell phone away, I'd cram it down his throat and he'd be dead.
Yeah.
That's right.
Yeah.
Shut
that's
up, old
right.
man. Learn your place. Go die with dignity. I support euthanasia. Get out of here.
your prostate is blocking my view of the screen, old man.
How do you guys think him being an ex-cop plays into the way this whole dynamic plays out? First of all,
Well,
with respect to his duty, as far as like, that he shouldn't have felt, maybe he should have felt less afraid, or maybe maybe it's more justification. Do you think it helps the defense or hurts the defense, the fact that he's an ex-cop?
Well, the defense wants to play, well, he was trained to know about how much anybody could murder you at any single moment and how likely that is to happen. I don't think that's going to play. Like, to me, that doesn't play for a moment.
So you think it hurts him? You think that that's basically the way they're trying to fix this problem?
Yeah, and I think that, I don't know that him being a cop hurts or helps him to me at all, but how the defense is playing it, that he's a cop, so therefore he knows that anybody might punch you and kill you at any time. That is their attempt, but for me, that hurts their defense. I don't like the argument that much. I don't buy it. I don't think most cops look around at everybody and go, this person might punch me to death at any moment. I don't think that's how they actually approach the world. That seems ludicrous to me. If it is, by the way, if there are cops in the chat who want to say, no, everybody I look at, I think they might murder me. Like, go ahead and say that if you want. I have a hard time buying that. I mean,
I don't think that's what the defense will argue, though. I think they'll not argue that Reeves was perceiving him before anything was happening as some potential deadly threat. But once the blows started coming in, based on his training and experience as an officer and working on cases where he'd seen people, viciously maimed by barehanded attacks, he recognized a degree of threat that the jurors might not recognize. They might be thinking of a traditional fist fight. But because of his training and experience, what might seem an unreasonable perception to the jury was in fact a reasonable perception to someone who'd spent 27 years as a cop.
Yeah, I don't know if I agree with you that
Joe's new driver is here.
I wish. Oh my God, that'd be amazing.
I agree with you that's the more accurate framing. Although to me, it comes across again the way I said it, which is my much more annoyed and grumpy perspective. And I also think that the defense is going to bungle it really badly, and I don't think it's going to help. But
they may well do that. I mean, they certainly bungled this opening.
Yeah, that's my problem with it. But yeah, that's a well stated representation.
Basically, it sounds like you're saying the defense is trying to play as if he's constantly doing a threat assessment for who is going to potentially kill him. That's what that's what cops do.
Andrews was better, is that this guy has seen the results of so many horrific things that people have done to each other, that once the danger presents itself, he's at a heightened level of awareness of how bad things can go. So that, like a normal person would perceive an attack, and him being hyper aware, super samurai cop, he perceives not just an attack, but a murder in the making at the bare hands of Chad the deceased.
Right.
I don't know, because to me that plays off. If you're such a super cop, you probably have defensive techniques that have been ingrained inside of you that you should be able to handle someone who's stronger than you in theory.
He's 71. I mean, he's twice the age of the guy who was purportedly striking him. So
yeah. So
I wouldn't want to be fighting a 25-year-old right now.
I don't know. Some 6'4", cop. How long or how much prior did he retire? How much?
Well, it had to be quite a while. He was 71. So
okay, but he might have been working until he was 65, 60. Yeah, I don't know when he.
Yeah, but he's not doing anything physical at that age.
Yeah,
he's not out making felony arrests at 65.
To whoever in the chat asks, it's supposed to be a 10-minute break. I'm monitoring it. You'll hear it. I've got it right here, and the audio is still piping through. So if anything happens, we'll know right away. And I'll get it switched over. But
so he left the theater to get the gun.
No, he left the theater to go tell the management that there's an asshole in front of him with his cell phone blaring light into his eyes. And when he asked him to put it away, the guy ignored him. And then when he said, "Hey, do I need to go get a manager?" The guy said, "Do what you got to do." And the wife did the same thing that I felt like the wife in Edgecombe did to me. Oh no, my husband didn't say
no bad language.
No bad language, and his voice came up to it was louder than you would expect in a theater, because you'd only expect a whisper. So he raised his voice to a normal speaking voice and didn't use any bad language. And it's like,
Yeah, that does make sense.
I don't know.
That's not likely.
Maybe he didn't use bad language, but I think they're going to have testimony that says he does, and then people are going to ask. Well, they're going to have to figure out who they believe. I guess that'll be that. But
How many
the
witnesses
guys
are we anticipating in this thing? Like, how long is this thing supposed to go?
Oh my God.
According to the opening statements, maybe until Christ's return or whatever. Who knows?
Like, how many
Yeah.
theater witnesses are there?
A ton.
Really?
It's
They're going
crazy.
to have
And they're
20
going to call.
people.
I just feel like they're going to call everybody who
The
has
defense
anything
said-
to say.
Defense said if the prosecution doesn't call him, we're going to call him, so you have the whole story.
Oh my God.
So last week, before opening statements today, last week the judge was maybe said explicitly, but at least was implying 2 weeks for this trial. But there's no way it's going to be 2 weeks at this pace.
Yeah, that's going to
No,
be
we
weird.
should be into our third witness by now. How hard is this? If you just focus on the actual event, we don't need to know how she walked up to when you got to your seat, was there anybody there? No. But that begs the question, by the way, and I guess maybe I'd ask on cross. You guys said you like sitting in the back of the theater, right? Yeah. Why didn't you sit in the back of the theater then?
Where
you went up
maybe your phone's not bothering other people.
You left one row back there. Why? Why would you do
an
that?
entire row?
Yeah. Oh, that was another thing the prosecution kept saying. The prosecution's opening statement was bad, except but for the defense's being worse. But the prosecution. So he's in his seat, right? And the Chad guy is up in the row in front of him and over one seat. So the Chad guy's in front of his wife. And the prosecutor frames it this way. He's an entire row ahead of him and an entire seat over. It was like this disingenuous framing. It's like he's right in front of him. He's right there. It's not like they're multiple rows apart. But God, okay,
All right.
here we go.
Mrs. Olson's back on the stand. You're still under oath. I'll tell her that in front of the jury, though.
We are. We're gonna still be doing direct
Are we
of
ready?
Nicole Olson tomorrow morning.
Yeah, I mean, how are they going to finish this up? And because they're going to
Please
get
tell
done
me
in
they're
what?
not going past 5 o'clock. Jesus.
I hope not.
Yes. Oh, really, Emily?
Mark Lerseth, I love doing
Yes,
live
it
streams
is.
with Viva. The
Well,
hard
much.
thing about doing a live stream with Viva is that my non-trial live streaming schedule is at night, and it's typically way later than he's awake. He's a little bit more of a morning daytime guy, but when I do, he pops onto these trial streams from time to time. I think right now he's busy with the truck protests, but he's welcome on. And when I'm not doing a trial stream, I'll see if I can set one up because it's been a while since I got to talk to him one-on-one. Okay.
Thank you. You can be seated. Thank you. Were you all able to abide by my instructions during the recess? All righty, then we'll get started again. Mrs. Olson is still on the stand and you're still under oath. Thank you. Go ahead, Mr. Martin.
Yes, and it's pronounced Twizzlers, not Twizzlers.
Before the break,
Twizzlers.
we were at that period in time that the man behind you had left.
Yes.
And you and Mr. Olson were in the theater, and we were talking about what was going on while the man was gone. And I want to discuss with you, was there any conversation or comments made by Mr. Olson after the man left that would suggest to you that Mr. Olson had any sort of animosity at that time that would result in him acting out in any way?
He did not say anything, no.
You're going to have to talk up a little bit.
He did not say anything, no.
Could you tell whether or not he was sitting there fuming and being agitated. You know your husband. so-
Objection calls for
No,
speculation.
he seemed to be back to normal. We thought it was over.
We,
Well, you know it's not over. The guy went to get management.
she's commenting about her husband's state of mind.
Was as the gentleman went down the stairs and you saw go downstairs,
bit.
your husband, did he make any comments about derogatory comments about the man walking down the stairs that's going to go complain about him?
No,
Completely not credible.
Man's gone for about 3 minutes. We've discussed what happened during that time period. Did you become aware when the man returned?
Well, I just made a 4-year-old very sad.
How did you become aware of it?
again, he's behind us and he makes a statement.
Before that statement is made, do you see the man coming up the aisles that
Not that I recall paying any attention.
you were focused on waiting for that man to come back?
No,
To your knowledge, did your husband make any statements to you that would lead you to believe that he was focused and waiting for the man to come back?
no statements.
All right. Let's get to the point where.
Let's get to the point is right.
As you indicated that there was something said. We're going to break it down as much as we can to try to put it in a proper time frame and sequence. All right. So at some point in time, the same voice that you heard, that man said something. Let's
Yes.
start there. What was said?
He says, I see you put your phone away now that I went to get management.
My mic went way up, like way loud.
Verbatim.
It got louder. Yeah.
How
And
the
was
hell
the
would it
phone
do
away?
that?
It was like suddenly your mouth was like a quarter of an inch from the mic.
Is it better now?
Out of
Yeah.
your peripheral.
It's a little
vision.
louder, but not
still
like
loud.
crazy loud.
Sitting right next to you.
I turned it down. Hopefully that
Do
helps.
you
This is
That's
better.
better.
sense,
Yeah.
feel, or see any type of body movement by Mr. Olson that would indicate that he would be turning to his right and focused on activity that was to his right
Not at this point of time.
before I'm talking about before the statement is made.
Right, no.
Do you recall any type of body movement whatsoever by your husband before that statement is made?
No,
Did your husband make any statement to that man before that statement was made?
no,
Now we have the statement made. Does your husband respond?
he does, yes.
And how does he respond?
Again, with what's your problem? Like,
Anything else?
I know we're feeling, why is this continuing going on? But no, I don't think any other, that was more of a feel, my feeling. And his statement was just, what is your problem? Like,
All right. Was there any cussing by your husband?
no,
Any F-bombs by your husband?
no,
The man behind you, was that man cussing?
no,
Any F-bombs, threats by the man behind?
no,
Okay. When the individual made the statement about
Objection, F-bomb
words
is
to the
undefined.
fact, I see you put your phone away. I'm just paraphrasing a little bit. Comparing that statement when he made it as far as the tone and demeanor of that statement, had that changed at all from the first 3 times that individual made contact with your husband?
no, it was not a nice statement.
Oh, I can hear him scratching on his.
Brain.
When your husband
Writing
responded
pad.
to the statement, words to the fact, see you put your phone away, at that point, did he turn in his seat? Towards,
Same.
towards where the voice was coming from.
During that statement?
No,
I'm sorry.
after the statement was made.
Oh, after the statement was made, yes.
All right, I'm asking you, once the statement was made, did your husband turn towards the direction where that voice was coming from.
Oh, no. No, I'm sorry. I misunderstood.
She may be telling the truth, but she wants us to buy that her husband went from perfectly calm this entire time to turning around, grabbing a guy's popcorn and
Now we
throwing
have
it at him.
Those two, the statement made and the
It's
response
0 to 1,000.
based on the tone and the demeanor of the voices that you heard.
He grabbed the
While-
shooter.
While she had her hand on her husband's chest to hold him back.
Why is this still going on?
He grabbed the
phone's
shooter's
away.
popcorn.
This should be over.
Yes.
Yeah.
That's worse for the shooter.
Worse for the shooter.
I think so, because it's like, if it's like his own popcorn, you don't know what else he's got, as opposed to like, I think it's almost like he's displaying, I have nothing, I only have my hands, as opposed to like, you know, he could sort of like play off like, this guy is like throwing stuff at me. I don't know what he's throwing at me next. Well, you know what he's
Did
throwing
you
at you. He's throwing at
sense,
your own popcorn.
At
Maybe.
that point, that the demeanor of both your husband and the man behind you was somewhat similar as far as either agitation or whatever you want to call it. Was your husband frustrated at that point?
I would say so. I'd say they both were, yes.
All right. Say they were both angry at that point?
Fair statement, yes.
Yeah, just testify to their states of mind. It's fine.
You were there listening to it. Think they were mad at each other?
Objection.
Probably,
Call for
yes.
speculation.
Hold something.
Were they aroused?
Do you recall any type of statement by your husband about texting?
Yes, I do.
In relation to the statements that we have, see your phone away, that.
Why didn't
when
you
did
bring
that
the
take
statement up
place?
earlier when it occurred?
After he returned from getting management, and he stated, I see you put your phone away now that I went to get management. Chad again said, what is your problem? And he did state that he was checking on a message about his daughter.
Was that true? No, he was effing lying.
We're going to take this real slow, okay?
Oh, no,
Now
oh,
we
good.
have that
This was
statement,
speeding along too fast.
right?
Yes.
Does there come a point in time when your husband begins to change his position in the seat?
Yes.
Is that turning around and looking or beginning to stand up?
Beginning to stand up.
At that point in time, did you know where your husband's cell phone was?
I did not see it, but I assumed it was still in his hand.
Either as your husband was standing up or after he stood up, did your husband make any other statements?
Not that I recall, no.
As your husband was standing up, what were you doing?
I sensed, I noticed him standing up, so I started to stand up a little behind him.
As soon as he
Behind
started
him.
to stand, you started to stand. Why?
I just was embarrassed. I thought it was going to create more of a commotion where more people were going to hear and see what was going on, these two men bickering.
And what was your intention?
My intention was I didn't want to contribute by yelling or shouting or trying to get his attention that way. So my intention was just to tap him on his shoulder or just to, it's not worth it, come on.
Okay. Now we've seen the height difference between you two, right?
Yes,
All right.
Yes.
You were seated in your seat.
yes,
Your husband began to stand first, and then you followed with that process.
Yes.
I know we got to take it slow. It's almost painfully slow. I understand.
No kidding.
But I'm trying to get to
Almost.
At least he has self-awareness.
and where they are in relation to one another. As your husband begins to stand, you began to do what with your left hand as you're coming out of your seat?
Reach over. It's kind of awkward. It's kind of awkward, the seats.
Mhm.
So I just, as I'm standing, I reach over just to tap his arm or tap him.
Wherever you could touch it.
Right. My right arm was holding on and that's just what happened. It wasn't planned. That was what was natural.
That was natural. That looked like a terribly unnatural movement. I reached like this across my body to do this and ended up with my hand in front of his.
As you're standing up, I want to know where your focus was. You get up. When you get up, are you turning your body, looking one way, turning it, looking the other way, or turning, looking up at the screen? I'm trying to, when you get up.
Right. Straightforward, facing the screen.
Can you see your
Loud
husband
again, what the
peripherally
hell?
Where he is?
Yes.
Okay.
My volume
Your
is.
focus is,
No, you're fine.
As
Low.
I'm standing up,
You're
it's
fine.
straight
They're
ahead.
trolling you.
And eventually I
Oh.
just turn my head to the right.
It
slightly.
did get a little louder,
My
but
body
it's
does
nothing
not
I
really
would worry
shift.
about.
Must be StreamYard being stupid.
There's suddenly a homeless guy back there.
as you are standing up,
Look at him. He's
your
the
arm
poor
begins to
bastard is
move over.
He looks so.
struggling.
He
He's like
looks
a
so
little
bored.
baby trying not to
You
fall
feel
asleep.
a sensation in your hand.
Yes.
It's like, I don't want to
Describe
go
that
to sleep.
sensation.
It felt like my hand was on fire. Just fire. It felt like my hand was blown off.
At the time, contemporaneous, same time that you felt that sensation in your hand, did you hear a loud noise?
I did, yes.
Are you familiar with the sound of a firearm? Not on TV and all that stuff, but I mean in real life.
Yes. Limited, but yes.
Would you say that your hand got
But
360
it
no
was
scoped?
loud.
It was, yes.
Once you feel that sensation in your hand, do you continue your process of standing up?
Yes.
Can you tell us whether or not
Were there any
you're
F-bombs
coming
then?
up off the seat bottom as you're coming up? Were your legs locked back when you felt the pain? Were you still, your knees not locked in that half sitting position? I'm trying to get where you were.
It happened so fast. I was just in motion on my way up, probably pretty close to being fully up, but maybe not standing straight with my legs locked.
Okay.
Did he know he was going to examine this witness today?
Well, I mean,
Well,
yeah.
Once you
some
heard
week.
a loud sound and you felt a burning sensation in your hand, do you continue to stand?
Yes.
Once you have finished the process of standing, what is your next observation?
Chad. He takes a couple steps and he collapses.
Here come the waterworks.
Are you
Oh, yeah.
concerned about your
Right on
hands
schedule.
or your husband?
Oh, my husband. I knew he was way worse than me.
Think she might hold it together?
Did you forego some
8
immediate
years.
attention to your hand and concentrate on your
Gotta
husband
be tough. Still.
Not if she wants a guilty verdict.
for a short period of time?
Yes. Yes. My focus was on him at that point.
We'll take you back to the process of standing up out of the chair. You're standing up and you're coming up. From your peripheral vision or anything, do you get any sensation that your husband had extended his hand towards the row behind him and brought it back?
No.
Did you get anything, sensation from your peripheral vision that his body at all broke the plane of the back of the chair and reached over with his hand and then came back?
No,
Well, he definitely did at one
He
point because he
did.
grabbed the popcorn.
Yeah, we saw it. It's on the video.
She's only
When
hurting
you
herself.
finally
Here.
had your hand,
She's
in a
ruining her own
position where
credibility.
you felt the burning pain. Just prior to that, did your hand ever come in contact with consistent with someone leaning forward and coming back? You know, that oscillation of the hand. Did you ever feel that?
no.
Yeah, guys, I see the Canada stuff. I'll talk about it in a minute. Her testimony is going to be over in 6 or 7 hours, so we'll talk about the Canada stuff then, briefly.
Now, prior to the events that you just described, did your husband ever jump up and put his feet in the seat bottom of the seat?
No,
Did your husband use the F-bomb in any way directed towards the man that you recall
no,
prior to the sensation in your hand?
no,
Recall any statement to the effect, mind your own F business?
no,
Any statement at all, stay the hell out of my face,
no,
by your husband?
no.
Prior to the time that
is
your
the state
hand
not gonna
had
mention
that
the
burning
popcorn at all?
sensation, were you aware that a bag of popcorn had been
Oh.
retrieved from behind you and
Retrieved.
tossed back into the air?
Had
was
been
not aware, no.
retrieved and tossed back. Like the most passive way to say that. And it's stuff like that that just, to me, it just,
It's
That's-
disingenuous. It's disingenuous.
You're coming up out of your seat and Chad, preceded and coming up. Is that the only time that he stood up?
The only time, yes.
Only
no
time
reason
that
to do
he
that.
Stood up.
you can't shoot someone because
You
they
were
grab your
coming up with
popcorn.
it.
Yes,
That's it.
that's it.
So there's no reason to make it so passive.
Did you ever see your husband stand up and turn and face towards that area behind him?
Prior to. the
Yeah,
shot?
prior to the sensation in
No,
your hand.
not prior to, no.
Oh my gosh. This is bad witness prep, and I mean it's bad questioning. Everything here is
Did you
just
ever see your husband standing?
And they've
his
done all
aisle
this
facing
once
back
already
toward
in the self-defense immunity hearing.
aisle and do some type of motion?
No, not from.
I mean, did they not watch their own videos of the immunity hearing and say, hey, this is what we can do better this time around? Instead, they're doing it worse. Except, God forbid, on cross, the defense is going to get up and say, hold my beer.
Yeah. Unfortunately, that'll be at the end of next week when we get to cross.
You knew that your husband had been hurt.
I did, yes.
You mentioned to us your concerns was towards him. Somehow, did you make your way down one row so that you could go to where your husband was?
Somehow I got down there, but I
It's all
assume I had to
blur.
climb over the seat, but I don't.
There's a lot of
recall how I
leading
got down.
questions here
Yes,
also.
I did get down out of the aisle.
Just
Once you were on that aisle,
little things making credibility weird.
were you able to obtain some type of wrap, bandage, something to put on your hand?
There was a
Objection
gentleman
leading.
that assisted me, yes.
At that point in time, did you see a gentleman sitting in the last row, up against the wall where the bistro was, that was directly behind your seat?
At that point of time, no.
did there come a point in time when you did have an opportunity to see that individual?
Yes, I did.
And that individual was sitting in the seat right behind yours.
Correct.
He was seating.
When you saw that individual sitting in the seat right behind yours, did it appear to be a man of similar stature as you saw go down the aisle leaving for the manager?
Yes.
And based on those observations and seeing where he was seated, did you have reason to believe that that was the man that was continually talking to Mr. Olson and yourself?
And the color of his shirt, yes.
Now, if you see that man in the courtroom today, I'm going to ask you to point him out and describe what he's wearing for the court.
Yes. I was going to say the middle, but there's two gentlemen in the middle of this table here. It is the gentleman second to my right. He's wearing
The bald one.
looks to be a grayish colored shirt with a white shirt.
That's
And
all of
that's
them.
wearing tie.
Your Honor, let the record reflect that the
Grayish
witness has
hair.
identified defense counsel.
Your Honor, the record reflect she's identified the defendant in this case, Curtis Reeves. Yeah, at this time, I'm going to use various pieces of evidence that have already been admitted. I need about 2 minutes to set up the video.
Oh my
and post the
God.
board, if I may do that now. Thank you.
How late are they going to go? This is unreal. Okay, I have a hard cutoff at 6:15 p.m. Central. Hey, Joe.
Yep.
On a scale of 1 to The Sopranos, how much of a mafia guy is this guy holding the easel there? Defense counsel. Wait till you see him.
Luca Brasi.
We need less comfy chairs for judges so they move things along.
Just make him stand.
I want to remind everybody that the evidence that's been already admitted, was all admitted today. This is all admitted like an hour and a half ago. It's not like, why do they need to set all this up? It's already been set up. This is all done just mere moments before she started talking. There's no other time to admit evidence than when they did it right before her testimony. Oh my gosh. C. Goody says, I'm hype AF for that Miranda rights decision stream for Mr. Branca to happen over at the Law of Self-Defense channel at some point.
I will do it at some point, but it'll be at least a month. We got to get through this trial first.
Black Tiger says, the old guy like cream of mushroom soup, maybe cream corn. He fired in fear of cream of some young guy. Gross. 200 Watt Studio says, when you say DA gets to mount the prosecutor, is this a Binger and Krause reference? Yes. Yes. Andrew Hansen says, Trudeau expected to declare martial law. Yes, I'm told that the Canadian Parliament has turned down the motion to end the lockdowns, and the Trudeau is about to implement the Emergency Measures Act, which I'm not Canadian, so I don't know what that means, but it doesn't sound good. Sounds like your rights.
It gives them the power. Yeah, it gives them the power to declare the protest illegal and to basically start seizing the vehicles that are locked, that are there. They're going to start towing vehicles, basically.
We're gonna start arresting people.
Yeah,
Maybe shooting people. You
potentially.
think it's gonna turn
Potentially.
violent?
No guns in Canada.
The police have guns.
Oh, it's funny how that works out.
Yeah. Yeah.
Just like in New York, right, Joe?
Well, some people have guns in New York. Few of them are registered. Wow, this is quite the setup they got going on there. You would think they would have something, preset that, like, hey, if we ever need to show video to a jury, this is how we
They
do it.
literally had the video
Yeah,
up.
they were
They've
showing video
already
earlier,
showed this
yeah.
stuff.
I mean,
And
to
why
the
did they ever
jury.
need that poster board nonsense?
It's 2022. I mean, what cases do you have that doesn't have some sort of video? Are we going to get to see the video, or it's only the jury?
They're going to introduce the whole movie Lone Survivor as evidence and make the jury watch it.
Put on mute because they don't want any F-bombs in court. They've been showing, well, the first video they showed, and then when they replayed the same video multiple times, they didn't show it again.
We got to watch the defendant for 50 minutes just sitting there.
Wow.
If he's going to show this whole video, they already showed this. They stipulated to its admission. If they're going to just show it again,
Do you have something on the screen?
I hope so.
it better be like just a tiny
Is it supposed to
fragment.
come up on the other screen?
It should. Did someone turn that off?
I love it. Does it time out?
Now I have it set on.
Pinch and zoom.
No signal?
Pinch and zoom.
Is it plugged in?
Yeah.
Hmm.
It is.
Wow. This is what it's been like.
Dude, it has been a disaster. Everything is taking forever.
I guess we can
Everything is like
rearrange
this.
again.
Both
What's
sides.
that?
I guess we can rearrange again.
Oh, no.
Yeah, that's unfortunate. Let me just try to reset this and see if it.
You can rearrange again because
Change.
moving it'll make it work.
Before it said DVD, oh, that's what it, now it says that again. Let's just rearrange.
May I, Your Honor?
Yes.
As bad as the other trials' use of technology has been, this is far more embarrassing.
Wow.
Witness step down, Ron.
Yes.
Walk around. Plus the wire. Feet on the X.
Now, just like we rehearsed.
All right, what I'd like to do
That's a toupee he's wearing.
is,
The prosecutor, you can see the line there. That's totally a toupee.
we're gonna
Could
take
be,
it to
yeah.
where Mr. Reed puts it. You see that part of the video?
Yes, it is.
Now, at that point, I'm gonna run it backwards just a little bit. As Mr. Reeves is walking in, at what point do you get a sensation that someone's behind you? Do you know?
When he leans forward, it makes his very first comment.
All right. Let's go to that.
That's that blue screen right there, Joe. That's the majority of the video.
Oh my God. Oh, there we go.
Okay, you indicated the first presence is when you first felt the presence of someone behind. So if you would, let's bring Stacy to it. Let me walk around here. We're going to use this photo board so we can get an idea of where everyone sees this, okay? All right. Please show the jury what seat you were in. And the man behind you, what seat was he in? Okay. And your husband? All right, now you watch the video. As the gentleman leans forward, does he come right behind your seat or off to his right?
He comes right, his face appears to be right in here, so to my right and to Chad's left, right in here.
Okay. And the first contact is what? About the phone.
You need to turn your phone off.
There's a response.
What's your problem?
Well, in 6 weeks, I'll be at Disney in Florida, so I can watch the ending of the trial in person.
And then
Watch closing arguments.
other contact.
Yes.
Now, again, the same positioning, leaning.
Right
And-
in here.
At that point, are you able to see out of your peripheral vision, the head coming into view?
No, just the first time.
All right. And the second time, the words were,
From
What?
Mr. Reeves?
Yeah.
The same, but you need to put your phone away.
in the same manner, tone that we discussed.
Yes.
Okay. Now, there's a point where he leaves.
Yes.
All right.
Oh my gosh.
This is torture.
Now, what is going on during that time period? We have the two contacts. Is your husband still on the phone? When I say on the phone, I'm not talking. The phone's still out.
Still out. I'm sure he's distracted from the phone. We're, more focused on the
Oh, you're sure he's-
conversation that he's
yeah,
having
sure.
on his phone. But yes, it's still out. Whether the screen timed off or what, I can't say. But yes,
Would you agree or disagree that your husband was just ignoring you?
blowing him off. I would agree.
Objection leading.
We then have the third contact that you talked about. So as we watch the video, again, show us the direction in which Mr. Reeves is leaning towards your husband.
This seat in between me and Chad.
On this particular incident, out of your peripheral vision, are you able to see the man's head?
I don't see his head here.
We just hear what? What do you hear the man say?
Do I need to go get management?
Is there a response by your husband?
Yes.
We covered objection.
And what does he say?
Do what you need to do, or do whatever
Objection, Your Honor. Asked and
Asked and
answered. Cumulative. These are the same
You get
questions.
the sense that he leaves.
We're just doing it in front of the screen now.
It's the stupidest thing in the world, and I don't know why. I don't know why defense is putting up with it. Like, let's move along here.
Now, as he is getting up, does he make any other comments?
Not that I'm aware of.
Does your husband make any other comments?
No.
As do you see him, do you turn and look and see the man leave at all?
No, not at this point.
And does your husband turn and look?
No.
This is just a repeat of the testimony about this incident.
There comes
It's the
a point in
exact-
time when he comes back, right?
Correct.
We talked about this before as he's coming back. Do you know precisely at what point a comment is made by Mr. Reeves?
He's behind us, but I don't know if he's sitting or standing or what he's doing. I don't look.
As Mr. Reeves comes back and begins to take his seat, do you notice any type of body movement by your husband to his left, to his right, behind?
No, we don't move.
Exactly when the statement that Mr. Reeves, you don't know whether he was standing or sitting.
I do not know. Reeves listening.
I see people in the comments suggesting that this woman, Nicole Olson, is 32 years of age currently. That seems unlikely. 8 years ago, her husband was 43. So that would have made her, 24. It's possible,
As we
but
see Mr. Reeves come back.
it does not appear 32 to me either.
No.
Nothing by your husband at all
No.
as he's walking by.
No.
No. And as he takes his seat, he's going to take a seat right behind
All
you.
right. I would not have called her a basset hound or a Leatherface comments, but
She's a blonde Angelica Houston.
That's just rude, Joe.
And this guy has no chin. He looks like a young Mitch McConnell.
Yeah, that's what I
You
said
mentioned
earlier.
to us that your husband stood up one time,
Okay.
and you were simultaneously going up with him.
A few seconds later, yes.
And as you're standing up is when you were shot.
Yes.
How many rounds were fired? Right?
Do you ever
One.
see your husband standing and turning towards Mr. Reeves and throwing his cell phone?
No.
Do you hear any cussing, swearing, or F-bombs by your husband?
No.
All right.
Oh my gosh. Is he just trying to figure out question? It's 5 now, buddy. Maybe you could just ask the
Do
judge if you can be
recall
done
any
for the
type
day.
of encroachment in your space by Mr. Reeves before your
I
husband?
mean, can we ask more leading questions?
No.
I'm guessing they're just not going to
At this
object
point,
to
it's
whatever
where you
she
explain, or
to the wife because they're worried about the look of it.
both were mad, angry, frustrated.
It's fair to say. It's hard to say what someone's feeling, but yes.
Yeah, you got the impression that these two guys.
That's really an inappropriate question, but yes.
Okay.
This guy is the
There comes a point in
DSP of
time, like you said,
prosecutors.
when he stands up and you stand up with him. As you're standing up and you're beginning to reach over, we talked about whether or not you ever felt the oscillation of the hand, as someone's moving their body like this.
No.
I don't think oscillation is the word you mean.
Were you aware of whether or not your husband, in fact, reached across the aisle behind him?
I was not aware.
And that was the time that you were standing
I
up?
was facing forward.
Just
and I
a
was
repeat, a
to my right
verbatim
chat.
repeat of questioning.
At that point.
At any time,
Did he
you
cross the
hold,
plane?
strain, body hug, or whatever, that would give someone the impression that you were holding someone back that was in a range?
No, I had no need to. No.
Don't oscillate me, bro.
So the bullet went through your hand and into his chest, but you weren't holding or restraining him in any way.
As you're getting up,
Just touching him on the arm. Doesn't make sense.
She had a bullet in front of him. She got hit in the hand
Yeah.
Yeah.
and went through her hand into her husband.
Yep.
Yeah. That's the thing. This guy was reaching back, grabbing this guy's popcorn, and she was clearly grabbing him because her husband was standing up, reaching over the seats behind him.
I mean, she said she was behind her husband. That means her husband had to be leaning towards Curtis Reeves. There's not that much space in that row.
I gotta see
Once
this
you were
video.
up, you knew that Chad was hurt.
Like, again, that doesn't mean that the other guy isn't guilty. To me, it reeks of dishonesty, and maybe I'm hoping we get a competent cross. It'll be interesting,
about
but
that.
I doubt it. I doubt it.
Using the poster behind you, show that you're where you were standing.
Where am I sitting?
Okay. And where was Chad?
In front of the seat.
After you both began to stand up and you were fully standing, you knew you were hurt, you knew he was hurt. Where was he?
He was come here and start stumbling down the aisle away from me.
And what are you doing at that point? Your hands burning?
Figuring out what happened. I mean, I knew a shot had rang out, but I didn't know where he was shot or what our injuries were, other than my hand felt like it was gone off of my arm, and I'm watching him collapse, so I know it's bad. It's just shock, I think, panic.
Okay. Now, as you see your husband walking away, somehow it's a blur, you make it to the other aisle.
Yes, I have. Get away from it.
I realize the concern, but did you make any phone calls? If you were trying to contact anyone, what was going on that aisle below? You can show where it is.
Right now, the judge
lead.
could be
What were
donning
you
a gorilla outfit and no one
before
would
you made
notice.
it to see your husband?
Yes, a gentleman had helped me, gave me something, napkins, something to wrap my hand. And I tried to contact my mother to let her know that something serious had happened and she needs to get over here. And I guess I'm not making
Slow
sense.
down.
The gentleman takes the phone and talks to my mother, and the same with Chad's mother. And then I knew I needed to get it together because I wanted to go see Chad and kind of figure out what was going on at the time. But I know from prior experiences that if he saw me panicking, he would be more worried about me. And I didn't want that, so I could hold it together enough to get back to him in front of him where I could look over the aisle at him on the ground. And I see
Is there any way you could cry directly on the jurors?
But I tell him, Chad, And next thing, need you please hang in there, we need you. And then I started to lose it, so I walked back away from the scene, not the scene, but from where I could see him. And I went back to the gentleman that had been helping me.
Other people were helping your husband.
Yes, they were doing CPR, assisting.
Please take your seat. I have a moment.
Yeah, you done with the video?
Yes, I still have some more testimony.
Okay.
What?
We'd like to watch these videos at a half speed, Your Honor.
Okay.
Manny,
We've
could
got
you help me
Peter
with this,
says
please,
Trudeau invoked the Emergencies Act. Canada has fallen. Marla says, please review the entire announcement from Canada after this. The freedoms that are permanently being changed as well as temporary history is happening. All funding streams, crypto banks can freeze accounts. No court order.
Wow.
Yeah, I mean, the response to the truckers has been, right? Like the response to the protest, in which no violence has actually occurred against the government at all, is to allow even more infringement upon freedom.
Honking is violence.
Canada is supposed to be a representative democracy, a parliamentary democracy, and yeah, no, it's have fun with it. What's up, Runkle? Yeah, we'll see, buddy. I've got a hard cutoff at 6:15. Lady Rackets doesn't know, but I bought her something for Valentine's Day, and I have to go pick it up. So like I'll have to leave because they close, but I can't imagine we'll still be going by then. But I couldn't imagine that this testimony would still be going. It's after 5 there. Yeah, 6:15 Central is my cutoff time. But at this rate, who knows? Also, Runkle, if you're around tonight, man, that might work too. Don Branca says none of what that person wrote is correct. It's limited and temporary, probably not legally invoked either, as Runkle covered earlier. But just remember that
The first one
we've had 2 weeks of temporary orders in the United States for
Is,
the past 2 years. So.
space mark for identification K, JPEG 2067296. Do you recognize that photograph?
Yes, I do.
Is that a photograph of you?
It is of me. Yes.
Taken a couple of days after this incident.
Yes.
Let me show you State's Exhibit number L, marked for identification, JPEG number 2067299. Do you recognize that photograph?
Yes.
Is that a photograph of the hand that you felt the burning sensation?
My left hand, yes.
Let me show you State's Exhibit number M, marked for identification. Do you recognize that?
Yes.
JPEG number 2067305. Is that your hand?
It is, yes.
And does that reflect the injury to your hand where you felt the burning sensation?
Yes.
Let me show you State's Exhibit number N as in Nancy, marked for identification, JPEG number 2067347. Do you recognize that photograph?
Yes.
Is that a photograph of your hand?
Yes.
Taken this same time as the very first photographs we talked about?
Yes.
Let me show you State's Exhibit number O, marked for identification, JPEG number 2067344. Do you recognize that photograph?
Yes.
Is that a photograph of your hand?
Yes.
And does it represent the injury as it was approximately 2 days after the incident?
Yes.
Let me show you State's Exhibit number P, marked for identification. Do you recognize that photograph?
Yes.
All right, JPEG number 2067332. Does that photograph depict the injury to your hand approximately 2 days after the incident?
Yes.
At this time, I would move a series of photographs in order as State's Exhibits 13, 14, 15, 16, 17, and 18.
Did she,
Any objection?
No objection.
They'll be admitted.
was her first sniffles
You may.
in this trial about her hand?
Oh, I'm sure it hurt.
I know, but it's
I'm just kidding.
interesting to have her not cry about her husband, but kind of start to break up about her hand. Maybe I'm misseeing that, but that's kind of how it looked to me.
We know that after this incident, you were treated. You were treated.
Yes.
All right. What did you finally realize happened to your hand?
That my finger was pretty much dangling and holding on just by a string. My ring.
All right. Were you taken to the hospital?
Yes,
Did you receive treatment?
I did. Yes.
Did there come a point in time that the treatment included surgery?
Yes.
How
Oh,
long ago?
that
How long
whistle.
Ago, how long after the incident did you have surgery on your finger?
My best estimate is within a week or so after.
Okay. Do you know? I don't want to say what type of surgery. What did they have to do in order to repair your finger the best they could?
Well, the bone and everything in the finger was so destroyed that they had to take a chunk of bone from my wrist and put it in my finger in order to reconstruct it. So there are pins or metal bolts, not sure the correct terminology for them, that put my finger back together.
Okay. The injury that you received from your finger, at the time you received that injury, was your hand in front of your husband's chest?
It was, yes.
And he was injured by the same projectile?
Yes.
I know it sounds silly, but I'm going to ask him. You didn't consent to being shot in the hand, right?
No,
All right, so it was against your
it
will.
was, yes.
Let's talk a little bit about the injury.
As if that's a necessary question for some element of a
Yeah.
crime.
I mean, it is an element that it
You have
be
to-
without consent or whatever.
But you can't
But-
meet that element unless you ask her the question, right?
That was just weird.
The mobility that you now have in your finger, is it the same as it was prior to January 13th, 2014,
No.
or different?
Different.
How's
It's establishing permanent injury.
Well, I've lost all movement in my top joint, and I've lost most of my movement and flexibility in my second joint, resulting in me not being able to grip things and just constant pain when I touch it the wrong way or hit it on something.
Let's talk about the way your finger looked prior to January 13th as opposed to after January 13th. Is there any different in the way your finger looked after being shot?
Yes,
All right, and tell us how it's different.
it's crooked in multiple places. Again, scarred, lots of different tissue and scarring around it, shorter, not as long as it was prior.
I'm going to direct you, may I publish these now, please? I'm going to direct your attention now to the.
How many crimes is he charged with?
2
A battery and murder?
second-degree murder and battery with a
Aggravated
deadly
battery.
weapon. Yeah.
Before you is State's Exhibit number 13. Do you recognize that photograph?
Yes, I do. Yes, I
Who
do.
is that?
That's me.
Okay. Taken approximately 2 days after the incident.
Correct.
The white material on your hand, what is that?
Gauze.
My skin.
Had surgery.
Oh, I got it
been
wrong.
Performed at that point in time.
Not at this point.
I'm going to show you State's Exhibit number 14. You give me a minute to orientate it. There we go. You recognize that photograph?
Yes, I do.
All right, is that a close-up of the hand and the band?
She's got a heavy
Yes.
whistle on those
Yeah,
S's.
before
Oh,
surgery.
God.
Yes.
Let me show you State's Exhibit number 15. Is that a photograph of your hand on top of a piece of gauze?
Oh my.
Yes,
Which finger was damaged?
my left finger.
To the
Come
thumb.
on, Joe.
And is that the way the injury appears prior to your surgery?
Yes,
And is it that
They should have had it like
that,
separated out.
resulted from being shot on the 13th?
yes.
You said that your husband went to go get Twizzlers. Do you think if he saw your finger, he would have changed his mind?
You recognize that photograph?
Yes,
All right. Again, is that a close-up of the back of your hand?
yes,
We see there's some red marks on the backside of your left hand. Prior to January 13th, 2014, did you have those red marks on the back of your hand?
no,
Let me show you State's Exhibit number 17. There you go. It's a photograph of your hand palm up, looking at your ring finger. Again, do you recognize that photograph?
yes,
And does that photograph represent the injury to your finger
yes,
prior to surgery?
yes,
And finally, State's Exhibit number 18. Do you recognize that photograph?
yes,
Again, it's a photograph palm up on a piece of gauze. Is that your ring finger?
it is, yes,
And does that represent the injury that you sustained from being shot on January 13th, 2014?
yes.
Yeah. I have just a moment, counsel.
No,
think he
it's
might be
this
done.
evidence is arguably relevant to the sentencing enhancement for the aggravated battery. There's two sentencing enhancement provisions for the use of the gun. One is in which a gun is fired and causes grave bodily injury. So they want to get in the record the grave bodily injury to the hand,
Step down
even if for some reason the jury were to acquit on the
and
murder.
approach the jury box so that they can see the.
If they quit on the murder, in that case, he's justified, and wouldn't that also serve as
It's hard to
provocation?
imagine. Yes, I would agree that logically that would need to be the outcome, but sometimes jurors are not logical.
Grave bodily injury, by the way, is higher than serious bodily harm. It's a higher standard. It involves permanent disfigurement. Serious bodily harm doesn't involve permanent disfigurement necessarily.
If he's convicted, he's looking at a mandatory minimum of 50 years, which doesn't matter much when you're 79 years old.
Yeah, much more than 5 years is death sentence. They may be able to argue his infirmity.
It doesn't matter. With the sentencing enhancement, there's no discretion to the judge. It's mandatory minimum 25 years on each of the charges.
Oh, okay.
Wow.
Otherwise, it would be 30 years for the murder, for example, but 30 years with discretion. So up to 30 years, it could be 30 years of probation, maybe no jail time. And there the judge might take his age into consideration, for example. But with the mandatory minimum provision of 10-20 life, it's there's no discretion for the judge. And it's mandatory minimum 25 years each, and they have to be served consecutively.
Inside the theater.
Well, we get cross today.
One,
They're
Mr.
starting
Reed
cross at
tells Mr.
5:20.
Olson something to the effect of turn off your phone, right?
Correct.
And at that point, Mr.
They must have told the judge they only want to talk to her for 5 minutes.
Yes. He
I hope to
says
God.
something back, but pretty much ignores, like,
Okay.
doesn't turn around to engage, just makes a comment over his.
Okay, what is Mr. Olson? I know you don't remember exact words for anyone, right? We can agree with that.
Right.
What is your recollection of, not the exact wording, but what did Mr. Olson say back? What was your impression of that?
What's your problem? The movie hasn't even started yet. Something about the lights or, no noise being made.
Then there was a second request or conversation or at least communication concerning turning off the phone because it was still on, right?
Correct.
And that's from Mr. Reeves.
Right.
And so what is Mr. Olson's response?
Mind your own business.
And then at that point, by now, Mr. Olson's beginning to get annoyed, right?
I'd say they both are.
Well, let's talk about that. Certainly you were familiar with Mr. Olson, being his wife of 7 years.
Yes.
We can agree that you weren't familiar with Mr. Reeves at all, right? Having never met the gentleman before.
Correct.
Okay. So for sure you knew that Mr. Olson was annoyed, right?
Yes.
And then there was a communication. Well, I guess I have to go to the manager, that sort of thing. Do I have that right?
Correct.
Now, at that point, Mr. Olson answers something to the effect of, well, do what you have to do.
Exactly. Yes.
So between the second conversation, at least, and this one, Mr. Olson is annoyed, right?
I'd say so. Yes.
And certainly hearing I'm going to the manager also annoyed him, right?
Yes.
Now, when Mr. Reeves gets back, and I know you said it, that Mr. Reeves wasn't loud, right?
Correct. They weren't whispering, but they weren't shouting either.
Right? Because in your mind, whispering is the proper way to communicate in a movie theater.
That's mostly what you hear when you go. Yes.
And so it wasn't loud in terms of Mr. Reeves, Mr. Reeves' voice.
Louder. Yes, I'd say it was kind of loud. Yes.
Okay, so now you're saying it was loud. You know, previously you testified this afternoon that Mr. Reeves' voice wasn't loud.
Okay. And again, let me try to explain. In a movie theater, a whisper would probably be a normal voice that I would expect from people and that I would use. However, it was louder than that. So it was loud compared to what I would expect, but not shouting or screaming.
Louder than a whisper.
Yes. Somewhere in between, shouting and a whisper.
And so Mr. Olson was also at the same level or higher than that?
I would say they were both the same.
Okay. Now, Mr. Reeves leaves, comes back, and now there's some more communication, correct? That's what you described.
Yes.
Now, at this point, Mr. Olson has already been annoyed going into it when Mr. Reeves comes back and communicates to him, telling him something to the effect of, I see you put your phone away. Certainly, that made Mr. Olson angry.
I can't speak to how he felt.
Well,
but I
you
would
could
say
have
that they
a
have
minute
both
ago.
been annoyed, angry. Yes.
Well, now you're telling me you can't speak to how Mr. Olson
Good.
felt.
Good.
But earlier, you
Good,
were
good,
able to
good.
tell me that a stranger that you never met before was annoyed. So was Mr. Olson angry when Mr. Reeves came back and said, I see you put the phone away?
That's
why
twice he's been able to do that on her testimony.
I'm
Good
sorry, Can you
questions.
repeat your question again?
You're telling me that you don't remember or you don't know if Mr. Olson was angry or not. But earlier, you were able to tell that a stranger's annoyed, right? That's what you told me earlier.
Yes.
And so your own husband, when Mr. Reeves gets back and says something to the effect of, I see you put your phone away. Sorry, I went to the manager. Mr. Olson is angry at that point, right?
I wouldn't say any angrier, but yes, I would say that they were same annoyance as I couldn't see anything escalate in annoyance, but yes, I would say that he was probably annoyed and angry just as Mr. Reeves appeared to me.
Well, again, Mr. Reeves didn't raise his voice, right?
And neither did Chad.
Okay, but you know Mr. Olson, so you know when he's angry, right?
Yes.
You don't know Mr. Reeves,
No.
right? Now, at some point, there's a kind of an escalation. I think that Mr. Olson says something about what is your problem? I was checking on a message or checks for my daughter, something to that effect.
Well, you say an escalation, but no, I would not categorize it as an escalation. I would say it was more of a de-escalation, but yes, he does make that comment.
Well, let's talk about that because
Okay.
right about
She's
that
starting to
time
sound
is
angry.
when Mr.
Yeah, look at her.
Olson
Look at her face and her
turns around, right?
mannerisms.
Around that time, not at the exact time, I can't commit to, but around
All right.
that time.
So certainly that's more than just blowing Mr. Reeves off, number one, right? You'll agree with me.
Yes,
Oh,
probably.
there we
Number
go.
two, you'd agree with me. It's more than just talking back to Mr. Reeves to say, what's your problem, right?
Say the words would be similar. Yes,
Well, but now he's taking physical action, Mr. Olson, right?
he stands up,
And he turns around, right?
correct?
And he turns around to look at in the row, he's facing towards the road directly behind him,
Yes,
the row that Mr. Reeves is in
yes,
with his wife, right?
yes.
This is a good cross so far.
Now, when Mr. Olson gets up, he gets up fast. It's not a slow process, right?
I was standing up normally. I wouldn't say any faster than if I was to stand up out of my chair right now.
Yeah, but you're
He
angry.
gets up. As he gets up, the back of the seat pops up because that's how those seats go, right? You remember that?
I don't remember the seat popping up now.
Okay. First, let's go back to the question before. So is your testimony today that Mr. Olson did not stand up quickly and turn around?
He stood up, yes, quickly, but I wouldn't say he jumped up. It wasn't springing up out of his seat. It was standing up. And I think anybody can pretty much stand up quickly unless you're
Except for the defendant.
having trouble with a part of your body that
She almost said
keeps you
probably
from
old.
standing up.
Okay, like an older person. maybe.
Right.
So in this case, Mr. Olson stood up quickly. You agree with me now?
I would say, so he stood up, yes.
Well, is he quickly or not?
I wouldn't categorize it as quickly, no. Just,
Okay.
well, that's hard to
Well,
say. Yes, he stood up.
This is bad
It
for her.
Didn't take more than a second or two, so I would say that was quickly, yes, if that's what you're asking.
And I'm going to ask you again, the seat you sit on popped up when he stood up.
I can't say that I saw it pop up, no.
Was it broken?
Okay, it's page 823 of the previous court proceeding.
Here we go. Yep.
19.
Prior inconsistent statement. You said he stood up quickly. You said the seat popped up at the other court statement that the jury didn't get to be at because it was just a motion hearing. Telling a different story to the jury than you told to the judge.
So were you lying then, or are you lying now?
Again, this guy's opening statement made me want to die, but this cross is pretty good so far. I'm liking it.
In this case, we agree Mr. Olson stood up and he's facing Mr. Reeves and Mrs. Reeves towards their back row, right?
Correct.
And it's at that point you describe that you are starting to get up at the same time?
Shortly after, Chad, not at the exact same time, no.
Okay, shortly after. And during that time, you say you try to get Chad's attention, Mr. Olson's attention,
Correct.
and you were doing that by telling him it's not worth it.
No, I did not say anything to him. That's what I was thinking in my head, but I went to tap him to, let him know that, hey, focus on me, it's not worth it. But I did
Alright.
not say those words, I don't believe,
Now you're showing me that you tapped him with your left hand
in my left hand.
because Mr. Olson is to your right.
Yes,
And so for some reason, you're not using your right hand, right?
correct.
Okay, you'll agree with me that your right hand was closer to Mr. Olson than your left hand.
Yes,
Okay, and when you pointed in the board here, you were using the pointer with your right hand,
I'm right-handed, yes.
but for some reason you chose to use your non-dominant hand to reach across your body to get Mr. Olson's attention. That's your testimony.
Yes,
And to get his attention, you didn't tap him on the shoulder, right?
I didn't have a particular place in mind. It just
Her
was a
hand on his
natural
chest.
reaction.
It's a natural way to
Yes,
get
I would
someone's
probably
attention.
think that his shoulder would be where I would try to get, but
And
didn't
so-
end up there.
And we know what happened, so your reaction turned to be to somehow position your left hand between Mr. Olson, Mr. and Mrs. Reeves, right?
Yes,
Now, you saw the video that the prosecutor showed you. You were standing here.
yes,
Now, there was one part in the video, it was at, and I know you didn't write down the numbers, it was 13:26:25. In that image, it appears that Mr. Olson is coming across the aisle because in that frame, you can see his head and his arm. Your testimony today is you didn't see any of that.
correct.
Well, he was standing next to you, facing the row behind him. You had your hand out to touch him. Did you feel Mr. Olson move at all?
No, I did not.
You can't deny that you saw a figure in the frame going forward, correct?
That is correct.
The next time, it's about 10 seconds away before we see the popcorn grab. That's something else that you say that you did not see, right?
I thought we were just talking about the popcorn.
There was a frame at 13:26:25 that was 10 seconds before the popcorn grab.
Okay.
And the prosecutor stopped it right on that frame. Do you not remember that?
And I remember the arm coming out and the popcorn being reached and then the popcorn being thrown. So maybe the numbers are throwing me off.
Well, that was 10 seconds later. So there was something that
Okay.
happened before.
Okay.
It's real quickly visible.
Object. I mean, we're just throwing out frame number 13:26. If he wants to show it, go to play it.
Doesn't have to.
I mean, she can't, she
Yeah.
doesn't know frame by frame.
Okay, let me ask you a question then. Let's say hypothetically that there's a 10-second gap between Mr. Olson reaching into the back row towards Mr. and Mrs. Reeves and Mr. Olson reaching again back there to grab the popcorn. What were you doing for that time period? After Mr. Olson stood up, what were you doing?
I can't speak to 10 seconds, but I noticed him standing. It drew my attention, just kind of waiting to see what was happening. And then I started to stand up. I'm looking up as I'm standing in front of me. And then I look over to him to tap him. I never look
Why would you be tapping him
back
this
here
way?
any
He's
further. I never turned
he's
my
this
body
way.
around. My feet never
this
moved.
doesn't make
My head
sense. You'd be like
looked at
this.
Chad as I was going to tap
Also,
him,
the stipplings on
but
the
I
back
never
of your
turned around
hand.
and
Stop
saw
it.
anything behind me.
Okay, so as you're looking at Mr. Olson, you don't see him lean over
I do not know
at any point.
at any point.
Why is
Shouldn't
she
be
using-
lying.
Why is she using her left hand if she's right-handed to tap him?
Yeah, because he's leaning over and she
Yeah,
has to
that's
hold
why.
him back.
That's
Yeah.
why.
This charge,
It's
we
obvious
can
that
agree
that's
that
what she's
Mr.
doing.
Reeves didn't
That's
say
what the
anything.
defense needs to
I
ask.
did not hear anything, no.
They did. She's like, I don't know.
I
It
don't
just,
have any questions. Thank you.
great cross.
Yes, Your Honor, and I'm gonna need to play the video. We have that frame.
Oh, you got
Do
to
it
try and
quickly,
rehab
please.
that. Good
Do it-
job.
Do it as quickly as you can, please.
Yes,
Oh my
I-
gosh.
He gave us the number, so.
Okay, gotcha.
Just-
You know, play
Okay.
the part where he's
We're-
leaning over
we're
the
all
seat
aware of
right
how
in front of
long
the
it will
jury
take.
to rehab the
We've seen
the
you a couple
witness.
times now. It's not that bad. It's okay. Just, yes.
See, that was very a very adept cross. He got a whole lot of admissions that she was inconsistent. He got admissions about that she actually couldn't know how the defendant was feeling. He got admissions about actions that her husband had taken that were not brought out on direct. And he didn't really get any bad facts out of her for the defense at all.
Yeah, and he didn't overreach.
No, he didn't badger her, bully her. It was really, in my opinion, it was very well done. Is it enough? I mean, only time will tell, but you do what you can do, and he did what he could do there.
She's also not his key witness. He just wants to try and mitigate as best possible. I still would have focused on that fact that she's right-handed. She claims she's not holding him back, and yet she's using his left hand to tap him on the chest rather than using the right hand to tap in the back, the way most people do.
I would have called out the hand being the opposite way, because the prosecution brought up that the red spots, the stippling was on the back of the hand in the picture. I would have brought up, wait, you keep doing this, but he was behind your hand, right? So you would have been like this, kind of like you were holding him back, right? I mean, I know you weren't holding him back, but it kind of looks like that'd be the look of it, right? Like this. So you're tapping your husband on the chest this way. I mean, if you're going to tap his shoulder, wouldn't you do it this way?
You weren't holding back, but to everyone else, it might have looked that
I
way
have to
because
see
that's the
everything
position that
you guys do, which is why I've been repositioning. We all have to see everything.
Because if she's actually just trying
I
to
messed
tap
up
his
my
shoulder,
screen. I turned
right
it
hand
off,
like
and it
this
didn't come
to
back
her
on
much
where it was
taller
supposed to,
standing
but I
up
can see it up
husband
there.
makes sense. Left
See,
hand
I-
like
I
this
do
is
it
not a
too.
shoulder. She's lying. It's obvious that she's lying because it's obvious that her husband was pissed off at this old man who's being a dick.
He was going to get into another fist fight.
Does he have a history of fist fighting?
I don't
the
know,
husband?
but if the wife is acting in this way, it suggests to me that that's a possibility, right? My wife
Yeah.
would not assume I'm about to get into a fist fight with somebody and feel the need to hold me back.
I love that this guy, his plan is to show the jury this guy reaching over 10 seconds earlier. Now, maybe the video doesn't show it, but I'm guessing it does. Him reaching over 10 seconds earlier and leaning over the seat and being aggressive. And he's going to do that for the sole purpose of rehabilitating the witness.
But if it's in the video, and I presume it is, the defense was just referring to it. If he doesn't show it, they'll show it on recross. I mean, you'd have to.
Well, he didn't do it on cross, though. He could have. He got the admission he wanted on cross, but now this guy's going to show the jury what they just testified about.
He just may not have wanted to go to the video again, but now
maybe.
Now it's set up, right? It wasn't the defense that demanded the video again; it was the prosecution.
Yeah. If they want to on recross, they'll just leave the video.
Yeah.
We'll be using that in just a second.
On cross-examination, Mr. Michaels asked you about a particular segment, 1326. He used 25. Let's go ahead and take you to that point. And what I'd like to do, you indicated to us that's where Mr. Reeves shut down. At some point, it's when the comment was said. Now, at some point, you told us that Chad stood up,
Yes, one time.
and you stood up with Zach simultaneous almost with him.
A couple seconds later, yes.
And then that's when you were shot.
Yes.
At 13:26:25, let's go back this way. See where your husband is?
Leaning over. He's in the frame.
All right. He only stood up once, correct?
One time.
And that one time that he stood up, within seconds you were shot.
Yes, correct.
That's it.
That's it.
And that was here.
That's the one.
You did not see the
I
popcorn.
did not.
You know he's standing there,
Yes, I'm standing up.
okay? And you did not see this.
I did not-
All right. But what you do know is you never felt the oscillation.
Right, he was standing up when I reached over to tap him. He was not moving forward or backwards.
And then you were shot.
Correct.
What is the time period from the time that you were standing up to when you were shot? Is it 5 minutes, 3 minutes, 1 second, 2 seconds?
Seconds.
Just
Seconds, I mean, get out of your seat,
and
hit
shot.
it. However
Shot.
many seconds that is, 2,
Okay.
3.
And you don't know where Mr. Michaels was referring to at 36, 13, 26, 25. Here, where you see, you weren't shot there.
No, all I see is Reeves.
All right. And
I mean, you can clearly see the husband in the frame at the frame that he said, right? When he comes back from the blue, he's
See
in
your
the
husband?
frame.
No.
Okay. All right, that's fine. If you don't see it, you don't know it. All you know is you stood up and you got shot.
Right. So when I was speaking to the popcorn, which was not at this.
No further questions.
May this witness be released?
No
You are
recross.
on standby. What-
She'll be here, so she'll be on standby.
He just
and
wanted to, I mean, they did what he wanted.
counsel
The
approach
prosecution
on that?
just showed them leaning over. All the jury's watching for that guy leaning over. I assume they all saw it. I guess you should maybe never assume, but that guy's clearly in the frame that entire time, at when the video comes back, and then he goes back out and then comes back in. So, I mean, he got that in front of the jury without him having to do it and bully the wife about it. So that's kind of interesting. I might have gone back on recross and said, do you see this spot right here that they just kept passing by where your husband is clearly in the freaking shot?
Oh, you got Ian in here just in time to celebrate Canada's Emergency War Powers Act being.
Yeah, celebrate. I mean, there might be a lot of drinking involved.
Yeah.
It's really messed up. They've got compelled labor in there.
Oh, compelled labor is good.
Yeah, they're
everybody
going
loves
to
compelled
literally
labor.
force people to work. It's
Wow.
so.
What about COVID?
Well, because the tow
COVID.
trucks, right? They have to
Yeah,
compel
the
the tow
tow trucks.
trucks. Yeah. You going to dismiss court for the day, Judge? Come back tomorrow at 7:30 in the morning, or 8:30.
6:30 my time.
Oh. What is left to do today? You've just completed the first witness.
All right, ladies and gentlemen, we've
Thank you.
reached the end of the day for today. Thank you for your attention all day. It's been another long day. I would like to start at 8:30 tomorrow.
Jeez.
But Madam Clerk just indicated to me that I guess you have a few things to do in the morning before you get here. So if you guys could be here at like 10 after 8, quarter after 8, and
Wow.
take your business
She's a
with
ball
them,
buster.
and then we'll
Wow.
do our best. We're all here on time, but there's a lot of times that things come up, as you've undoubtedly seen in the last 6 days you've been with us, that we have to discuss outside your presence. So my instruction, I never know how long that's going to take, but we definitely try not to waste a minute of your time unnecessarily. So please remember my instructions during the recess. No independent research, no talking about the case, and report to the jury pool room by about 8:10, 8:15, and we will get started at 8:30. And Deputy Martin does have she has the clerk's daily letter for each of you, and then the those of you who requested a letter from me. If I missed anybody, just you can. Oh, I can't get it tonight. I don't think. But if I miss anybody, I don't think I did. But if I did, just hang out in the jury pool room, and I'll double check, and I'll type you something tonight. Okay.
It's weird to me that the jury's on the right,
till
on her right.
tomorrow morning. Thank you, everybody.
The prosecutor usually sits near the jury because they're the burden proof.
It is Florida.
So what time did they say in the morning? 8:30?
8:30.
Oh.
That's gonna suck a lot. I do not like early mornings.
Yeah.
I was so proud of myself getting here and starting the show a few minutes before
9.
the hearing got started. I was actually early, but well, if we're done for the day, I'll keep it up just in case anything happens. But that's the hearing. But let's go to our man in Canada. Want to quick give us a rundown on what the Emergency Powers Act, or whatever it is, the Emergency Commie Act is?
So just as a bit of background, there was initially the War Measures Act, and the War Measures Act has been used
Thank
three
you,
times in
everybody.
history.
Well done. See
World
you
War
in the
One, World War II, and the October crisis, when the FLQ set off about 200 bombs in Quebec. So they got rid of that after it was used in the October crisis, because that was seen as a bit of a bridge too far, and they replaced it with the Emergencies Act. So this is not exactly got a great pedigree, but they've now decided that this is a national emergency, which it seems hard to qualify as, because it has to be something that's endangering the safety or Canada's stability as a nation, basically. And yeah, there's a bunch of loud, annoying people who are blocking some roads. It really doesn't seem like we get there.
Maybe that's enough to disrupt all of Canada. I mean, it kind of is, like, in a non-joking way, disruptive, but that doesn't rise to the level of instability of the country, right?
Yeah, the country's been running, just fine. It's just that people are annoying, and they literally said part of the reason for justifying this was we're going to lose confidence from international investors. So when we start suspending rights to make sure that international investors feel that Canada's okay, I got some real concerns about that. But they're going to be compelling the tow truck drivers to work. They've given the RCMP blanket powers to seize bank accounts. It's going to be wild.
Money. They want that any of the money that was dismissed or that was distributed out from Give Send Go or GoFundMe to the truckers. They want to seize it, because that's the. And I'm not saying Canada needs the $8 million. I'm saying that is the power play, right? And this is an Emergency Powers Act is about power. It is about reestablishing control and to take the money that people gave and to seize it. Oh, geez, God. And to seize that money and to show, no, not only do you not get it, but we will confiscate it. So all of your work is for nothing. That is the power play, in my opinion. What do you think about that?
Yeah, no, I think that they're absolutely trying to. I mean, crowdfunding has really opened the doors to a lot of situations where people stand up to government. Rittenhouse being able to run a full defense relied on crowdfunding. I don't think he had the money to run that defense just out of what was in his pocket. So being able to sort of break the back of crowdfunding is something they're looking at. And also they were saying Bitcoin as well, although they didn't quite go so far as to explicitly say that they wanted Bitcoin on FinTrack, because it was really funny. They're talking about like GoFundMe and Give Send Go and saying that they're going to have to report to FinTrack, but they also mentioned Bitcoin. They didn't quite explicitly say that they wanted Bitcoin to report to FinTrack, but it wouldn't surprise me if they tried.
I would think they'd go after places like Coinbase. is what I would think. Coinbase, and the massively popular digital wallets that are out there that make things easy for like a boomer like me to figure out Bitcoin, or to acquire and hold it. Would, I'd go pay the extra fees on Coinbase because I suck. I don't actually do that, but that would be the thing. And so they can't easily just go after Bitcoin itself, because it's not like Bitcoin's a company, but they can go after Coinbase for reporting and even for seizing funds, I would think.
Yeah. And I see people asking what FinTrack is. It's our financial tracking system, which is basically where they have to report all of their big financial transactions. If you get a payment over a certain amount, it's anti-money laundering and that kind of thing.
Wow. Wow.
We have the same things with currency transaction reporting and suspicious activity reporting in our banks, that would do and all of the banks participate. They're required to participate. Otherwise their charters can be revoked if they do not do this. Any cash transaction over $10,000 is automatically reported on a CTR, and anything over, really anything can be done on a suspicious activity report, but typically it invokes on multiple cash transactions at $3,000 or more, because it looks like someone's structuring the transactions. So, and those are part of U.S. law in I would assume a similar way.
Which is that itself is so authoritarian, and people don't even realize banking law in America versus in Europe. Bank secrecy laws in America literally mean the opposite of what they mean in Europe. In Europe, when they say bank secrecy laws, they're talking about under what limited circumstances are banks permitted to report to the government about various transactions. And we'll find certain limited circumstances that they're allowed to do it. In America, it's literally the opposite. It's like there's a general assumption that the government is entitled to get whatever they want. And then in what areas are banks required to unilaterally run to the government and alert them of information, which is just, it's astonishing. But yeah, we live in a very imprisoned, liberated society. So,
well, I do love that the act of peaceful protest, the act of assembly, is being squashed with emergency government powers by what many would consider to be a liberal democracy of the West, right? Canada being clearly a country that has long expressed a high value on human rights, is now squashing those human rights at the first sign of resistance. And it's amazing.
Yeah, Trudeau came into power basically promising not to do this stuff, and he was very much saying, my father brought in the Charter of Rights and Freedoms, and he's been doing his best to burn that down.
So what's the procedural posture here? You said they have 7 days that they have to get approval on this from Parliament.
I've got to review it, but it expires in 30 days, and then I think it's 7, but I'm not sure. I got to look and just be sure. But they do have to take it back to Parliament and say, hey, is this, can we continue? Can we confirm this? And
they get 30 days as a freebie.
So far, they've got the support of the NDP, which is enough to push anything through.
What's the NDP?
And I find that's shocking. The NDP bills itself as a workers' party, and they're supporting they're supporting a provision that includes compelled labor. Like, that is it's a strike breaking provision, essentially. They're saying we're worried that these guys are going to refuse to provide us with services, and therefore we are going to force them to work. Like, how does that reconcile with a labor party?
Yeah. And for people who don't understand the issue or haven't been following the issue, I don't mean, it's not a condescending thing, but one of the beauties of this protest, is that they drove a bunch of big giant trucks and they're all parked. And the problem with that is that if you arrest the truckers, the trucks all stay there. They can't just move the trucks. Just a minute, lady. They can't just move the trucks. So you would need a big tow truck and kind of a specialized tow truck to do so. Get out of here, you stinker. You would need a specialized tow truck to do so. And the tow truck drivers all basically called in sick and said, "Oh, you know what? We're not going to do it either."
Nice.
Well, and
Oh.
I mean, in some cases, what they've basically said, they've interviewed some of the truck drivers and they said, listen, it's really difficult to move these trucks at the best of times. And if you've got a driver who's not keen on you moving this truck, it's dangerous to do so. You know, it's not like moving, you know, a Honda Civic or something. It's a big endeavor. And so they've said, like, listen, we don't feel safe doing this. We're not. And also, these guys are our business. We don't want to be seen attacking our business base. You know, if, you know, it's like if you have a cleaning contract with, you know, X corporation, you don't want to go and be seen, you know, protesting X corporation. They don't want to take that side against, because they may never get work again. So, yeah, they don't want to work it because they have legitimate concerns about what that might, you know, what cause, you know. So
Right.
the other thing is that, of course, a fair number of the tow truck drivers also sympathize with the cause. So this is effectively asking them to act against their own positions.
Yeah, well, it's I mean, when we get down to this, there's a bunch of stuff going on, and I'll probably be talking a lot about this tonight from an American freedom-based perspective, because I'm not Canadian. I don't know the law, but some of the issues that we have are that money is speech in the United States. Citizens United, the decision that everybody hates, that I love it. It's so great. It's a great decision. Money is speech. And so when you seize money, when you take it and appropriate it away from what it's supposed to be, you are taking speech and putting it, compelling speech, in an opposite direction. Imagine this. You give $5 to the truckers. Your speech says, I give this much speech to the truckers, right, in support of them. And the Canadian government takes that money and appropriates it in a different way. They have now compelled your speech to support something else. That is a massively disgusting encroachment on freedom. It's way more than silence. It is compelled speaking. Then you have compelled labor, which, can you imagine anything other, anything more offensive than a government forcing you into work against your will? And then of course, denying assembly, denying speech in other places. It's amazing what's going on.
But
Some trucks started honking.
Emma, do you think I'm wrong for suspecting that this is all about trying to flex their muscle until they can get some members of this protest to snap and become violent, and that way say, you see, they're all crazy violent, and now we need to like lock them all up? Like, it's almost like they're looking to sort of crack the whip until they can have some video of somebody protesting, reacting to this crackdown, and that will now give them license to basically round them all up and say that they're all January 6th rioters, so to speak.
I would say, oh, sorry, go ahead, Runkle.
I'm not sure about that. I mean, they did go and arrest a bunch of guys in Coots who apparently had firearms and so forth. And it seemed to me that if that's what they wanted to do, like some sort of, they could have just let that sit and waited to see what those guys did. But I think it may have the effect of provoking people. There's going to be a lot of upset people. So
there's
yeah.
that, but I would say they don't need to, though, because you have agent provocateurs already, right? Like you already had the people showing up with the Confederate flag and the Nazi flag, and those people smell kind of like they glow. You know, you just like these. It's really easy to fake the violence. I mean, not that a government would ever instigate violence within a movement to try and discredit the movement. I mean, not that that would ever happen. They would never send like a special, operative or two in to actually foment violence. But I don't think they need to actually do anything to provoke it, because I think they could just create the violence that they wanted to justify it. I mean, they already did. They already have been saying that the movement is violent. That was the first thing with what was it? Oh, when they shut down the GoFundMe, right? The narrative was that there was all this rampant violence, and it was a violent protest, and it was, everybody's like, where? It doesn't matter. Well, we've made arrests. show them. What were they for? Where were they? Who were they? Well, we don't need to do that. So I don't know, but gosh, this is ugly. Runkle, are you going to be talking about this more?
Yeah, I got a bunch of things to do, including, I don't really know what this is going to do, and this could cause protests to explode. So, one of the things I'm going to be doing is going out shopping and just making sure that I got enough food and so forth in case stuff gets real crazy. I don't know if it will or won't, but I don't want to be sitting there going, I wish I'd gone shopping and didn't. So, that's on my to-do list. I'm probably going to try to stream. I'll probably try to throw myself on a live stream at some point when I can tonight, just because this is wild. And I think that a lot of the people in support of this are really going to find themselves regretting it down the road, because I see a lot of people, particularly in like left-wing circles, going, this is great. They're cracking down on those right-wing whatever. And I think, you guys know that the next time you guys have a protest, this door has now been opened. And so the next time we see Wet'suwet'en blocking rail, doing a rail blockade, that could be, they could be saying, hey, we're going to start seizing people's bank accounts. We're going to start compelling labor. It's worrying to me. And
but the right rarely exerts its political power in the manner that the left routinely does. I don't want to call the right a bunch of pussies, but
they are.
Yeah.
Well, in Canada, what we tend to see is that the conservatives push for something that infringes rights, and they do this all the time. And people say they're big and they're bad, and we can't do that. And often people are right. Like the conservatives tried to push through a internet surveillance bill that was just messed up. But now the left here, the Liberal Party, which sort of left, but they're now basically trying to implement a lot of those same surveillance measures. And everyone's like, oh, well, it's fine because they're on our team. And I go, you got to realize it's the same sword that you're giving government. And eventually a conservative government's going to have that sword and is going to swing it against you. Once you give government a weapon like that, it's going to be turned against people you like and people you don't.
Here's the really interesting irony of all that. They assume the left will constantly scream that the right, when they are in power, are wielding these authoritarian swords. That's what they say about Trump. That's what they say anytime the right is in power. Like, oh my gosh, they're going to start, doing all sorts of racist, crazy crackdowns on gays and all. That's what they assume is going to happen. It never does happen. And while they assume that's what will happen, they're still willing to give government the sword. So either they're full of crap when they're claiming that they believe that's what the right government, how the right will act when they have power, or they're stupidly short-sighted.
Yeah. Well, I'll be following this, guys. If you want to see what Runkle's going to cover, his name is in the description. You click on it, go to his channel, and subscribe. That way you get a notification for any live streams he may be doing, if YouTube will let them happen. But
yeah. Or if the government doesn't say we're going to shut it down.
Yeah, no kidding. I need to read super chats and then get out of here because, like I said, it is Valentine's Day and I have an errand to run before the stores close. They close early around these parts. So to all my guests, you're welcome to stay. But if any of you have to go, I certainly would not begrudge you at all, of course. If there's anything anyone wants to say before I get started, please do so. Otherwise, I'm gonna tear through the rest of these. We've actually made really good progress, so it shouldn't take too long. But
while you're talking about free speech, I will tell you that tonight I stream from 10 p.m. to midnight Eastern. Tonight I'm going to have Mark Gerhard, father of Lucas Gerhard.
Good man, a good man.
He's gonna be visiting, providing an update on that case and developments that happened in the wake of Ethan Crumley shooting. So, I urge you all, if you're interested in Lucas Gerhard case, he's the teenager who has sent out a Snapchat to a group of friends, picture of his gun, saying going to go melt some snowflakes, and that got shown to the wrong person who reported it, and now his life has been in turmoil and facing potentially a potential criminal punishment that just boggles the mind. So his dad He's not allowed to use. I would have him on, but part of his house arrest is that he's
Yeah,
not
he
allowed
can-
to use he's not allowed to use the internet. So in lieu
Been
of
for
having-
over. He's coming up on 2.5 years
yeah
of being.
two
He
and a
was
half years of that.
arrested for 82 days without a hearing. He was held. This kid was 20 years old, held for 82 days without a hearing, and then has spent the next 2 years being on house arrest with a no internet order. Can you imagine being 21, 22 years old, being taken out of college, having a no internet order because you posted a legal picture of a legal firearm that you legally took to your school and legally checked in at the armory? All of that perfectly legal, no threatening behavior, but because someone showed it to someone else who has been hassling you for a year, that person determined it was a threat and reported it, and now you're arrested for 2 years of your
And
life.
every time it seems like things are going to start going well, like they're trying to change the law in Michigan to make what he did, specifically to make his actions that he did not be deemed illegal. All of a sudden they have Ethan Crumbley arising, and all of a sudden everyone starts freaking out about school shootings. So his dad is supposed to come on tonight and provide updates as to how that's happening, how that case is developing. His attorney may be on. I'm not sure if he's going to make it. I don't want to overpromise something I may not deliver.
His attorney's great guy.
Yeah.
And the dad is wonderful. Mark, I'll try and pop into the chat and say hi, but tell if I don't, please tell him I say hi and give him my best.
I'm going to provide a link to LawTube also.
Okay.
So anyone who wants to join in and talk to Mark Gerhard or whatever, feel free to pop in whatever time works for you. So I urge you all, make sure you check it out. And I'm going to go set that stream up right now. So I'm going to pop out of here, but I look to be back with you guys tomorrow. All right. And hopefully I'll see you guys later tonight. All right. The invitation is to each you, not just Nick, for you to come on tonight.
No, I appreciate it. I'm afraid it's a bit late for me, but
Okay.
I appreciate the offer.
I will have to see. It's good to know that you're running that, because I'll try to make sure my live stream doesn't conflict. Because
Okay, cool.
I'm probably going to step out and go do some panic shopping just to because
stock up.
Live stream it.
Stock up the shelter.
Live stream your panic shopping.
Yes,
Do it.
that'd be really cool. Actually,
I'm 100% serious. Live stream your panic shopping. People will love it.
Especially if there's if there are hordes of people there, for sure.
The thing is that most of my shopping, I've already got a decent amount of supplies. It's just kind of rounding things out and making sure I'm more comfortable.
Doesn't matter. Do it.
But
Do it anyway.
Here's what you're missing.
48 cases of beer.
Especially if
that's
there's
actually not a bad
craziness.
idea.
If there's craziness in your local Walmart of people stocking up, in that case, just filming that, even if you're not shopping for anything, the reaction to what's happening, because of everyone's following Canadian politics for the first time in the history of forever. So and the impact it has on its citizenry. If you want to document that, I think that's something everyone would love to see. So check it out.
Everybody in the chat saying, do it. Do it.
I will
think
have
it'd
to
be
see. I got to figure out how to live stream from my phone, but I'll think about it at any rate.
Later, gentlemen.
All right. See you guys later.
See ya.
All right. Mr. Branca, anything before I jump into these?
Nope. Let's do it.
All right, here we go. Jacob says, did we move from the trial to the punishment by forcing him to watch these videos? Yes, we did. Phil Harrington says, Runkle, Trudeau's father, is buried in Cuba. Ooh. Sean Brennan says, the Virgin PB&J versus the Chad Fluffernutter. What? Brian Miller says, I'm going to need a few bottles of liquor to get through this trial. Squeeze Louise says, couldn't we at least get some Zack Snyder slow-mo during the gunfight? This movie sucks. Ben Ogle. Oh, where did it go? Shoot, it just jumped down on me. Hold on. Almost there. Almost back to it, I think. Ben Ogle. The judge is definitely Sig Hansen, captain of the Northwestern crab fishing boat from The Deadliest Catch. I dare you to unsee it. Kevin Speaks on it, says, do you believe there's actual corn pop or Joe Biden dementia? He was a bad dude. I don't know. Maybe. I think he made up a figure that was an amalgamation of bad black people that he knew, because Joe Biden doesn't like black people. I think that's what happened. And he just turned him into corn pop because he likes cereal. Zenothium 15 says, is Biden giving out crack pipes entrapment? No. Also, Borowski would have this trial at closing arguments by now. Marco Vital says, I don't remember the name, but when I was a kid, my parents would buy a combo peanut butter and jelly in a jar. Yes. And it's disgusting looking to me. I can't. Oh, ugh. Nova Amp says, it's me, your boy. I'm back. I was a parole officer for Washington State and got subpoenaed for an old case where I ID'd the defendant on. Oh, okay. But you got subpoenaed
To be
as a witness or a juror. To be a witness, great. The general advice is go in and tell the truth. That's your obligation, and tell the truth to the best of your ability. And if you don't remember the truth, like if you don't remember what happens, just say I don't recall. It's, a couple years ago or whatever. But yeah, go do your duty. Let the process work. Dark Moonslayer says, guess they're having a conversation about the Asian food waiting in the back. AA Ron says in Monty Python voice, bloody big nose. Tor Theo, the prosecution lawyer will be played by Ben Stein. Chris Oliphant, you are 6'2" to 6'3" when looking up, otherwise 5'6". No, I'm 6'2" to 6'3" when laying on my back. That's the trick. Andrew Hansen says, my 6'6" brother married a 5-foot girl. My family prohibited me from giving her a stepladder as a wedding gift. Christopher Schaffer, his name is Chad. He lived in Florida. He should always be the presumed aggressor. John Diaz, what's the relevance of all the questions about the child and teething? That was actually a very, very poor attempt to engender sympathy for the woman. Like, I'm surprised the prosecutor didn't spend several more minutes talking about the baby that got left behind.
Step through each tooth. Get an x-ray of the child's jaw.
The baby who will now grow up without a popcorn wielding father. Nick Sweetman says, happy Valentine's. Testify about your dead husband. Oof. Yeah, that's bad timing. Bob Johnson says, can you get Joe to join in to explain the speed of light from the phone to Curtis Reeves' eyes? Josh Vermillion says, regretting your choice to cover this trial yet? Yes. I'm hoping it picks up. Justin P says, since there is a Cracker Barrel, how come there's no Binger Barrel? Racist. Let's see. Kenneth Crandall says he sounds like the lawyer from Idiocracy. It says here you robbed a hospital. Blue-eyed Roof Cree in the base says, hey, chat, I hear this blonde is single now. Stop. Makeup Queen says, Bueller. Sounds like the prosecutor. Dan Goodwin says, creepy employee, place that camera on the back row. Tyler Mueller says, I tried watching your coverage of the Potter trial, but it's more boring than this one. Thanks for the commentary as always. I thought the Potter trial was more interesting, but
yeah.
Underhanded Joe says, I'm doing mind-numbing work watching a mind-numbing trial. Hope I don't doze off. Magnus F. Hansen says, I don't normally think of myself as possessed of a very strong chin, but looking at the prosecutor, I feel like Ernest Kalimov. I don't know who that is, but I would assume their chin is massive. Kiwi Kel E says, who knew we'd need crack to stay awake for this trial, or that you're not allowed to spell crack correctly? Sadly, the free pipes haven't been distributed yet. Not applicable says Twizzlers were relevant again. Us. Well. Tego the Turtle says, thanks. Mr. Steve VC, welcome to Paralegal. William Barnes says, the correct answer to why do you need a gun is always, I don't need a reason. F you not wanting to have one is all the reason anyone needs. Dragon's Treasure. At this point, you should pay us for watching this with you as background noise. This is the audio version of watching paint dry. DCV Titan. Law and Crimes audience are all Democrat voters, or at least they are now. J Mac E. Read the book. Movie was 1/4 of the events. Murdered. Oh yeah, the Lone Survivor book, and everybody should. Murdered Out JD says, anyone else see the irony of the movie they went to see and the outcome of the night out as Lone Survivor? Well, not you, Chad. The Squid says, did the man at least dress up like the Joker before shooting someone in the theater? I don't think so. He was old. I don't know if he could do a quick change like that. William Wise. It seems like there's an undercurrent of the morality of using a phone in a theater. How does that materially affect the issue of the shooting? It shouldn't, but jurors will have opinions about people who use phones in theaters, how annoying it is, and how, look, a juror can look at this and say, man, if I saw someone using a phone, I'm just going to keep my mouth shut. Or the other one could say, if I politely ask someone to put their phone away and they jump up and attack me, would I need to shoot them? You know, I mean, it can really cross the whole spectrum of reactions. You won't know. It's how each juror internalizes that sort of situation. Two Segoy for you says Aaron Jaeger told him to take out Chad to secure the viewing pleasure for the Eldian people. 200-watt studio. Every theater witness will be asked about their day leading up to the theater. Dr. Spoon, Jesus, I knew Florida was the old folks state, but I didn't know it was this slow. 200-watt studio. Jokes from you guys in chat make this worthwhile. Andrew Lawhern, defense stands up and says, well, at least it wasn't your bicep that felt like it was blown off. Cameron Nelson says, hookers and coke, baby. Let's light them up. Eugene says, it's sad there's no unbreaded segment during the trial coverage. Yes, but there's also no other segment. You know, the one which proves dubs over subs is only correct in the sense of raw body mass. TC, that's right. I'm not playing you guys that podcast, so you're welcome. TC, has a defense ever placed a doppelganger in the defendant's chair and asked witness to identify the faker? Yes. Yes, that has happened. Not necessarily a doppelganger, but just someone who matches a vague description of someone a long time ago. That has worked. Yeah. Nick's Hex says prosecutor equals Charles Boyle. 200-watt studio, Your Honor, trying to connect DVD to TV, but it's on channel 3, not 4. Can you help? Brian Quick, how does this prosecutor put on a pillowcase? What? Forever 39. What happens if the defendant dies of old age during the opening arguments? Move for dismissal. Case is closed. Barry Dworak says, and they're not guilty, by the way. A person who dies during the pendency of a case is never adjudged guilty. So they're not guilty. They die with a clean legacy. Barry Dworak says, Nick, you and your LawTube compatriots have made me lose all faith in our unbreaded justice system. Good. At some level, there needs to be exposure of the system that you potentially are subjecting yourself to. Because the best, I think you would agree with this, Andrew, the best self-defense is to never, ever have an opportunity to be in the legal system.
Yeah. Oh, you don't want to subject yourself to this system. I'm always amazed when I hear people say, I'd rather be, judged by 12 than carried by 6, because I know they're assuming those 12 are going to acquit them as having used force lawfully, and they'll have won the legal fight and the physical fight. But those 12 people can be a madhouse, folks. And it's not much of a victory if you win the physical fight and you spend the rest of your life in a cage with really unpleasant people.
Yeah, so the best option is to not have the physical fight if at all possible. That's why basically every concealed carry class will tell you avoid situations, avoid them from the start. Don't not just retreat, but if you're in a situation where you have a gun and you feel tension, you maybe just leave. You maybe just leave. That is the way. And because if you are trusting 12 idiots with your future, I mean, it's a roll of the dice. QB says, if the prosecution is interested in a conviction, they should hurry up so Mr. Reeves doesn't die from boredom. Mr. Leon, Canada is now allowed to freeze all bank accounts without a court order. 200-watt studio. Prosecutor, does your daughter realize her text got her daddy killed? Oh my God. Hugo Itano, the prosecutor sounds like Frito Idiocracy. Barco Verwer says, are unappealing people drawn to become prosecutors, or does becoming a prosecutor make people unlikable? Branca Gorilla basketball video reference for the win. Jackson guy, Trudeau announces 2 weeks of jackboots to flatten the protester. I'm sure it will be temporary. Cough. Gregor Brzeszczkiewicz says, Nikki, I missed the trial eating smoked brisket you're not allowed to enjoy anymore. What does your Polish proboscis say about corn pop, breaded or unbreaded? Also, your internet's slow and shorter than Tom. First of all, always unbreaded. My internet is slower than Tom, but everything is taller than Tom. And what do I sniff about corn pop? Corn pop's a bad dude. Bobbert, is it just me, or is it this witness you should end your case on? a lot of the theory about witnesses is you start with a strong witness, you end with a strong witness, and you sandwich in a bunch of BS witnesses that are boring. But you want to give the jury a good impression at the beginning, and you want to leave the jury with a good impression as your last person. So one step too far says she must have been unable to properly flick bean for weeks. Gross. Jackson Coleman, 12 angry men, 12 suicidal people. Shock TNC. I actually like the bow tie. Chat needs to cease and desist. Peacock. Annoying people at movie theaters should be silenced. Luke Pearson says, ask the defendant to stand up and go quicker than that. GRP poll. Canada has fallen into a dictatorship. Trudeau has enacted the Emergencies Act and can use martial law and can freeze any bank accounts he wants. Brindor Rain says, come on, Canada, never go full Nazi. Patrick Allen, what's the over-under? Recollection Law Barber has 80 tattoos on his neck, maybe some lightning bolts and a few SSs as well. Pretty close. He doesn't have a ton of tattoos, but it's not outside the realm of possibility. My barber's a really good dude. I like him. Will Carter, anyone or another synonym for forced labor is slavery. I thought British Commonwealth countries abolished slavery. Is government slavery a loophole? Authoritarians gonna authoritate. Oh wait, I just caught the end of that. My barber is a Hispanic man who is not a neo-Nazi. I should point that out. But cartel out of the question. I'm not so sure about that one. I'm not so sure if the cartel is out. Not applicable says brown shirting is fun until someone does it to you. Michael Kingswood says, oh, come on, Runkle. The government will never suppress left-wing protests like this ever. The left is the government. Train of 26 says, thanks, Nick Recollection. You're a good man. I was grossed out at first, but now I understand BBC love. Okay. Tara Rayner, your favorite Canadian thinks if the police don't adhere to our Bill of Rights and Charter, this will crush the bills, period. All institutions colluding to end what we are entitled by God. Truck Fudo. Hot Snodge says, forget booze to get through this trial. You need a cocaine or Walter White special blend. More Unbreaded Havoc says, William Corn Pop Morris died in 2016. Aiden Ramos, I wanted to hug Branca last week when he asked people to share his stream. Then he started losing viewers. You could see the hurt in his eyes.
It was very funny. I was pushing, I don't know, maybe 900 to 1,000 viewers. I was like, oh, we're so close to the next threshold. Please share the link, hit subscribe. And immediately the number started dropping.
Oh, that sucks. Barkover's William L. Corn Pop Morris Legacy.com obituary refers to him as Corn Pop. Corn Pop died in 2016 at the age of 73. Corn Pop and Biden born in 43. So there he is. This is the real Corn Pop. 200 Watt Studios prosecutor. What's it like to kiss someone? And then there's one over at Odyssey. It says, I hope everyone is enjoying my conception day. Voodoo doll. This is from CD Random. Well, there we go. Sorry to Odyssey that the link broke, or the show stream broke over there. Not sure what's up with it. That's it. Any closing thoughts before we head out?
No, thanks for hanging in there, folks. This was a brutal day of trial. Very unpleasant, about as bad as they get, frankly, arguably, except
Really?
with the cross of Nicole Olson. Hopefully things will improve, although I'm not expecting much from the state in that respect. So
yeah,
we'll
we'll see.
Happens.
Maybe they were all just having a bad day, and it depends, because if we get a different prosecutor asking questions, we might get some good questions.
Yeah, I mean, the other prosecutor did the I think he did the opening in the immunity hearing, and he was much better. So if he starts asking questions, maybe the tone will pick up.
Yeah, we'll see. Okay, and Perihelion says, holy crap, Castro invoked the Emergencies Act. Canada is now a tyrannical dictatorship. Now what? Now we see what happens. Now we see how far they go. That's the terrifying thing. All right, guys. Thanks for hanging out with us. Andrew, I'll see you tomorrow.
See you tomorrow morning, Nick.
All right, brother. See you then. Peace. Peace.
Oh, he drinks a fair bit, but you realized that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitter and Erlang. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of that broad. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dante to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law